Same tender.
How many matters?
There are 5 matters because 5 petitioners are there in a same tender.
Okay.
But for such reason, Lord, I have come.
All 5 are agreed with the tender process.
Only because Lord, they have been delisted only of the reason 0.0221. That was the indication. But it can be ignored. That is the settled principles of law. That is the.
That's called tender. That's called tender.
That's called tender.
Compromise application.
When is the opening date?
Next Thursday.
Next Thursday. Tuesday as unlisted as urgent motion.
Compromise.
Tuesday as urgent motion, huh? Yes.
Compromise application.
Who is senior?
Compromise application. 138 matter.
Compromise application.
Yes. Already listed.
Listed?
No, not listed. Matter was listed and Justice Choitali Chatterjee to be listed in 10th.
So why mentioning here?
Because determination is here.
Determination is 130 is here.
Yes, 138.
Which year?
2011.
काम करो. To be mentioned में रखो. To be mentioned में रखिए.
Either 13th or 20th.
Okay, 20 has to be mentioned. 11 2011. Yes. ले लो. अर्जेंट उसमें रखा था ना उस दिन टेंडर वाला. कब दिया डेट? 13th Tuesday.
May I have, my lord, kindly mention an application. My lord, we've taken an application for vacating of an interim order in respect of IBC proceedings, which was stayed on the ground of limited.
IBC before this court?
No, residuary. So, my lord, it was under the residuary only. My lord, there's been an interim order. We have made an application for vacating, my lord. May this be
vacating interim order. So, matter is not in the list?
No, it's not.
Have you served the copy?
Yes, I've.
Yes, my lord, I am from the plaintiff.
Petitioner
has applied for vacating almost after 1.5 years.
Affidavits were complete before that. We were all waiting for the matter to be listed. But now, my lord, there are several judgments which have also come out that, my lord, that, of course.
Affidavits completed?
Yes, my lord.
Then read, my lord, affidavits is completed. This vacating no.
Adjourn motion on 14th. 14th as adjourn motion, huh?
New motion, madam. New motion.
For what?
For electricity.
Huh?
Electricity.
Electricity. New motion, whatever, give all the list to my.
Listed motion.
My name, my lord, has been struck up.
Listed motion.
Whatever the motion matter, give them to my court officer.
My lord, I have. My lord, motion I have third row.
ওইটাও নিন
এক সেকেন্ড ভাই
let the motion completed. Whatever the motion you want, give all the list to my court officer, we'll see and it will be listed. So why you want here? It has been changed. Okay, you give, it will become.
On motion.
Okay, I will take. Yes. New motion matter over? New motion matter mentioning over? New motion give to my court officer.
My lord.
Just a minute, I will.
New motion matter.
Okay, yes.
new motion ছিল
The only difficulty is, my lord, that I had already mentioned this matter on 3rd, and your lordship had granted permission for this to be listed on 11th, that is today. However, I find that it has not been.
What is that?
Relates to passport act. Your lordship will kindly recollect passport seized. We preferred renewal. They said criminal case pending. Go to trial court. We took trial court's permission. Then we made representation to passport authority. Still, they are saying that no, we will not grant permission to renew it.
Okay.
Therefore, we have filed a writ petition.
Day after tomorrow. Today we are on 11, no?
I'm so grateful.
14 urgent motion.
May
So
may I seek
My
my lord,
name, my lord, has been struck out from the role of the medical practitioner, my lord, without hearing me, my lord, on the allegation that there is a criminal case, my lord, pending against me. My lord, there are certain, my lord, rules which say that, my lord,
What is the criminal case? 315?
No, no, my lord, the criminal cases with regard to, my lord, defalcation of fund and, my lord, economic offense. Economic offense. But, my lord, I was
New motion. It's a new motion.
new one.
एकटा करो अर्जेंट मोशन में कर दो उसको. अर्जेंट मोशन कब दिया था? 18th कर दीजिए. 18. Yes.
may I seek my lord's kind indulgence to mention, my lord, a writ petition. My lord, petitioner is a septuagenarian. On 13th October, my lord, 2023, my lord, a complaint has been lodged before the State Information Commissioner. As my lord, despite order passed by the State Information Commissioner, my lord, the public information officer was not divulging, my lord, information. My lord, is a septuagenarian. My lord, the writ petition had appeared, my lord, on 8th of May 2025, my lord, when it was dismissed for default. My lord, restoration application was taken out soon thereafter on 20th May 2025. May this, my lord,
Restoration application.
my restoration upon notice, my lord, I'm mentioning.
My lord,
Give. You only mention the restoration. I will take. Because all the restoration application has not yet come. That's why it is not listed. I will see if it is come, it will be listed.
I'll grateful, my lord.
May I be permitted to mention 2 items for upgradation? Both are electricity matters, petitioners are.
What is the urgency?
Petitioners are without electricity, lordship.
Since when?
Lordship, the matter is pending in the list, lordship.
Hmm.
Lordship, I'm looking for upgradation matter taken up.
This list, it is in list.
It is in list
Under
the heading motion, lordship.
come,
Item number 161 and item number.
take on
212.
all 18th on as urgent motion. 18th on urgent motion.
Grateful.
my lord,
I have your lordship's leave to mention, your lordship. My lord, this is for inclusion in list. My lord Justice Tirthankar Ghosh released the matter because matter relates to External Affairs Minister writ petition.
Okay, इसको list as
May I-
ऐसे motion में लेके.
my lord,
May I
have your lordship
Under
kindly
the
to
heading
mention,
motion,
my
yeah.
lord.
Who is senior?
My lord,
Deeply obliged.
mention a new motion. There is some urgency, Your Lordship.
What is the urgency?
The original writ was for calculating the stamp duty of 2 sale deeds. Now, because we needed the sale deeds in a different litigation, we have in good faith submitted around 32 lakhs.
For as a stamp duty.
No, as a stamp duty, as the calculated stamp duty, so that we can obtain the sale deeds without prejudice to our rights to have the leasehold. Their Lordship, they are supposed to give us a affidavit in opposition with a copy of the deeds attached, but they have not done so. The matter has been pending. 32 lakhs is stuck, Your Lordship.
Who is for the other side?
They are given notice.
Have you mentioned? Have you issued the notice?
They have given notice. They have appeared before as well.
They have not filed affidavit.
They have not filed affidavit.
Hmm.
They have handed over the lease deeds, the original lease deeds, but they are not contesting the matter. Whereas 32 lakhs.
18th as adjourned motion. 18th as adjourned motion.
my lord,
This matter, which my learned friend has mentioned, we are led by not by retired Justice Dr. Muralidhar in the matter. Humbly requesting your lordship, subject to your lordship's convenience. If it
But
be
the problem is that affidavit is not there.
Yes.
So what can be done? If
Very well. Let it come up.
let it come first. If the affidavit, then I will fix. If the pleading is completed, then I will fix a date. If any lawyer is appearing through virtual, no problem.
my lord, may I have your lordship's kind leave?
Yes.
Of the new motion, Your
For
Lordship.
what?
Under section 16 of the West Bengal Apartment Ownership, Your Lordship.
New motion.
For inclusion in the list.
New motion.
Tender matter, Your Lordship.
Tender matter.
Yes, Your Lordship.
Tender हुआ.
No, it is expiring in the in the end week of this month.
So what is your prayer?
Your Lordship, the tender, we have participated in the tender process and now they have selected other participants for this.
So how you will be prejudiced?
Eligible.
You are not eligible. When is the last date of the opening of the tender?
27th of November, Your Lordship.
27 November.
Lordship, may I be permitted?
19th as urgent motion.
May I be permitted, my lord? This is a application where we have, my client has not being paid by the SBI Life Insurance. This writ was heard in detail, extensive hearing was done, and we have filed a written notes of submission. All have been done. Then her lordship has ordered the official liquidator to appear and file his submission. The date has also expired for there, and the matter was due to appear on 10th November, my lord. I am
10th November. Oh, it is not appeared.
no, my lord. This is the urgency, my lord.
Adjourn motion 18th.
My lord, may I be for lordship?
18th as adjourn motion.
My lord,
But I am mentioning one
Much
matter,
obliged.
my lord. This is an electricity matter.
Huh?
Electricity matter. Now, the matter was moved earlier bench. The earlier bench directed to submit a report. Now the report was not matter was fixed on 7th November, not as yet listed. Now what happened? The electricity authority is going to install the electricity connection over my part of the land to the other villages where my building is constructed. That's what this is an extreme action.
So you are objecting for that.
Yes.
Your lordship,
my lord, there are two writ matters.
your lordship,
As
these are
new
written.
motion.
May I be permitted to mention, my lord, with deepest regard and respect, my lord, the petitioners before your lordship are undergoing IVF treatment. My lord, the respondent authority has suddenly unilaterally stopped the treatment, citing a clause under the new Act of ART, Artificial Reproductive Technologies Act, my lord. This is their last chance to become parents, my lord. This is the urgency.
So what is the urgency? What you prayed for before this court?
My lord, that provision, there are judgments of this honorable court where that provision has been relaxed. I only want that relaxation.
Which for the other side?
My lord, I have served. This is a new motion.
New motion.
New motion.
New motion.
My
Where is that?
extension of interim.
Your lordship, this is an inclusion for the returnable motion, and the matter is already been heard on 3rd of November this month, and the returnable motion is on 14th/11.
1411. For under adjourn motion?
Yes.
1411 adjourn motion.
Lordship, may I seek your
Obliged, my lord.
For what? What is the urgency? Upgradation? Huh?
The matter was heard in the earlier bench,
Ah.
but so the petitioner is in that for 5 months. He is suffering.
Who's for the other side?
I have
Affidavit completed.
no lordship.
Then
Settlement notice.
affidavit has been filed by the other side.
There is no direction of it.
There's no direction.
And today,
Put as a new motion.
7 lordship.
147. It is already there. Then let today how far this court will go. That will become lordship. Let me see how far the court. If it is not coming within 2 days, then you mention them.
May I have your lordship's
My lord,
kindly?
petitions, which my lord, there are two writ petitions, which my lord has heard in the earlier bench. And my lord has kept it for only filing of written votes. My lord has also marked it part of.
But that is the insurance.
Yes, my lord.
Insurance matter.
But
Yes.
it was scheduled to appear on 6th of November. My lord, if my lord can keep it on any date.
Which for the other side?
My lord, we have given notice to the other side.
अच्छा एक काम करो इसको 14 को 2 भी मेंशन में रखो.
Lordship, may I seek
But
your kind indulgence
extension of interim order is expiring on the 15th.
15. 14 to be mentioned for extension of interim order.
Sir,
14
your
to be
lordship,
mentioned for extension of interim order.
your lordship,
Yes, Mr.
your lordship.
Samantha. Now, if it is listed before the other court, no. Affidavits completed, no. Not that new motion. New
May I have your lordship's kind leave?
motion on 17.
IVF matter, my lord, can date will be fixed, my lord. IVF matter.
Lordship.
It could be
Your lordship,
Which matter?
IVF matter.
उसको 17 कर दो. IVF उसमें उनका भी 17 कर दो.
Lordship, may I seek your kind indulgence to mention one matter, today's matter 143 of today's list. The urgency, Lordship, the private respondents had surreptitiously and maliciously disconnected my own electricity meter in my own premises. And they have installed their own meter.
Okay, today please you wait for 2 days. If the court not reach that up to that mark, then you mention the matter. I will upgrade.
May I
Please
have-
wait for 2 days. Please wait.
May I have your lordship's kind leave to mention a matter on extreme urgency? It's a new matter, WPA 25601 of 2025. I'm facing a disconnection tomorrow by DVC. Whereas by APTEL order, I'm
Why
entitled-
disconnection not pay the consumption charges?
No, all current charges paid.
1820 arrears 16 lakhs I have not paid because there is a APTEL order in the interregnum on 15th of September entitling me to recover 2 crore 32 lakhs. So we again, upon receipt of the disconnection notice, we wrote back.
Industry list.
Industry. We wrote back saying that please recompute as per the APTEL order clearly entitles me to the refund. So kindly adjust my 16 lakhs, only 16 lakhs, that to 1820 dues, all current charges paid. No other arrears. I'm entitled to recover as per
Have you
APTEL.
challenged the demand made by the authority with regard to
Yes,
that?
we have. We have
What is-
already, by way of this writ petition, we have written back a letter, two communications, two representations, asking them to recompute. Instead of recompute, yesterday, they have deposited a PDC and they are threatening disconnection yesterday. So extreme urgency I'm facing, Your Lordship.
Tomorrow is urgent motion.
Tomorrow, top of the list, maybe.
Urgent motion.
Very well. I'm
Your
deeply
Lordship.
obliged.
Your Lordship, we are mentioning for the extension of interim order, the expiration
When it is going to expire?
in this month, 28 November.
28.
28.
Come on. उसको लो 27 to be mentioned. 27 to be mentioned for extension of interim order.
My lord, may I have a lordship? My lord, this matter was appearing as an urgent motion before the the honorable coordinate bench, my lord. My lord, the urgency in this matter is, my lord, I carry sand from one place to another. My vehicle has been blocked by the DLLRO. Now, my lord, a challan needs to be generated to carry the sand under Mines and Minerals Act. And now, my lord, the vehicle has been blocked by the concerned DLLRO. And my lord, till date, in spite of the orders of this honorable court, my lord, and I have mailed the orders of the honorable court, my lord, no reasons are being intimated to me that why my vehicle is blocked, my lord. Now, my lord, I am.
Any criminal case initiated?
No criminal case initiated, my lord.
Against the person who is carrying the mines and
No, my lord, no
minerals?
criminal case initiated. At least I do not have any notice.
Who seized the vehicle?
My lord, DLLRO has blocked the challan. He has not seized the vehicle. He has blocked the challan to carry sand. And my lord, till date, I do not know why the challan has been blocked. Because my lord,
So might be he made a complaint to the forest officer. Forest officer might have been made a complaint to the concerned magistrate and
to me, my lord. There is a clear order of the honorable court, my lord. I have brought the orders also that the state must intimate that why the vehicle has been blocked.
And when it was blocked?
My lord, it appeared first, my lord, on 26th of September. My lord Justice Sinha had directed it to appear before the vacation bench, my lord. Now, my lord, before the vacation bench also, my lord, they couldn't intimate the reasons, and my lord, the matter was directed to appear before the regular bench. My lord, the extreme urgency in this matter, my lord. My life and livelihood is.
18th urgent motion में रखो.
May I permit for a mention, my lord? This is the new listed motion. My lord, the writ petition has been filed against the non-starting the FIR and investigation of cyber crime. My lord, credit card.
Side court. Police inaction.
No, my lord, I'm against.
This court is not having the police inaction
No,
determination.
not police. Against
So
the
what you want?
Residuary group.
Side court. Yes.
Inclusion in the urgency in this matter is yesterday police officers came before my house and stated that my shop will be demolished within Thursday.
Police will demolish the shop. Under which act?
Under your lordship, Section 10(4) of the West Bengal Highway.
Is there any eviction order was passed?
Eviction order was released.
Ah.
Last appeared before.
Have you any notice when the notice was issued for eviction?
It was, your lordship, it was running currently in the list. So, it was
So
last it appeared before the combined monthly list of September, your lordship.
affidavit completed. Then what can be done?
It was not directed, your lordship.
Not directed.
Your lordship, Thursday, they are stating that they will demolish my
Thursday.
shop in Thursday.
Thursday is on 13. Today we are on 11.
I have served.
What you served? इसको एक काम को कल को listed motion में रखो कल top में.
My humble submission, my lord, kindly release the matter, my lord.
Yes.
My humble submission, my lord, kindly release the matter. Like this was filed before.
It's here.
Yes.
Where it is not in the list.
No, not running.
Not in the list. You go to the department to correct. If it is in list, then I can pass. This court can pass an order for correction. It is not before me. What order can be passed?
Lordship, may I be permitted to mention a matter? This is for inclusion in the list. Actually, we are the petitioner in this matter, and this is a matter related to the passport. Your Lordship is not appearing in the list.
Huh?
I'm just praying for the inclusion in the list. This matter.
Inclusion.
So,
this matter was wrongly listed in the court of Lordship Ritobroto Kumar Misro, and it has been released since, and we are praying for inclusion. I'm praying for inclusion.
Your Lordship, I'm seeking leave to file on matter with great urgency.
You are mentioning list, for unlisted.
Your Lordship, I'm seeking leave to file a matter on great urgency. Your Lordship, I am the father of an unfortunate daughter who is alive, yet the Department of Health and Family Welfare has issued a death certificate in her name, which is, yes, Your Lordship. I have the relevant documents. I can prove that she is alive. Your Lordship, as a result of that, my Aadhaar
Who has
card.
filed the writ application?
Your Lordship, the father of the daughter.
What is the age of the daughter?
She's a major.
So why
She's
she
married.
has to file the application? Why she?
Your Lordship, her Aadhaar card and everything has been rendered invalid.
Why?
Your Lordship,
Declaring death.
yes, Your Lordship.
So
Your
what?
Lordship, the urgency is that the SIR is also being conducted in the state.
Huh?
And the SIR has also been conducted in the state. And Your Lordship, at this stage, since I have been declared dead by the death certificate, I couldn't participate in this.
So you are
process.
challenging the death certificate?
Yes, Your Lordship. I want to quash. Yeah, I want to quash the death certificate. I have made the necessary representations and nothing has been considered.
18th को urgent motion में लेके.
My Lord, may I have your Lordship's leave?
Liberty given to file and list on 18th as urgent motion. And the petition is directed to serve notice to the others.
My Lord, may I have your Lordship's leave to mention a matter, my Lord? My Lord, this I pray only for inclusion, my Lord. New motion, my Lord. Now, my Lord, the urgency in this matter is, my Lord, I am a father of an unfortunate daughter, my Lord. The daughter was actually mistreated by the hospital, my Lord. Now, my Lord, I complained to the concerned authority, the health medical services, my Lord. Now, there my complaint was rejected, my Lord. So, my Lord, there is no appellate for my Lord. The writ court is only the for my Lord for urgent inclusion, my Lord.
What is the urgency?
My Lord, I only want inclusion in this matter, my Lord. New motion, my Lord. New motion,
Yes,
inclusion.
My lord, I want to include my matter in the list as to be mentioned so that I can take leave, because it is a mistake on my part that inside the writ petition I have written private respondent number 8 to 17, but in the cause title I have not made party to the
tomorrow to be mentioned.
tomorrow to be mentioned.
Okay.
Lordship for day after tomorrow or tomorrow?
Inclusion give that.
Yeah.
This is a new motion matter.
There. Grateful, man.
On the reopening day, it was in the daily basis, Your Lordship, and after that, it was not appearing.
Your Lordship.
Use Your Lordship, then emails for the authorities.
Your Lordship.
Yes.
My Lord, may I permit to mention? Well, item number 84 and 90, in these two matters, Senior Advocate Mr. Deep Kavi is appearing and he is requesting kindly fix the matter on Thursday because he is in.
Okay, if the matter is called, you mention it, I will accommodate.
Your Lordship, for inclusion of writ matter in the daily list.
Lordship, I am mentioning a matter upon notice to the other side.
What is the urgency?
Urgency is this, Your Lordship, that I had filed a writ petition against the insurance company, Lordship. While the matter was being taken up, the insurance company had also agreed to settle the matter with us, Your Lordship. In the meantime, the matter was taken out of the list, Your Lordship. And now they are taking advantage of this fact and not giving me my money that was due to me. Now, Lordship, I have a.
It's not in the list.
No, Lordship. May it be taken up in urgent motion, Your Lordship.
19th में urgent motion.
Lordship, obliged, Lordship.
Yes, call the list.
Lordship, may I permit to mention the urgent motion, Lordship?
What is the urgency?
Lordship, the petitioner is 75 years old first. It is a land under a refugee devolution committee.
Correct.
The land was issued in favor of the mother.
Correct.
But measurement is wrong. That's why in my name, probate has been already passed by the Alipur court.
Correct.
But measurement is not correct. So I only fear they let them consider my representation in respect to the only measurement, nothing else. Nothing else.
My Lord, my Lord, may I live to mention one of the matter like they are vacating my shop in the railway canteens in the matters like the Susmita Mishra versus Union of India. They are actually my rent agreement is not yet complete, not yet. Yes, so they are free notice to.
Have they issued the notice for eviction?
Yes, my Lord. Eviction, not causing the notice for the causing.
Quashing the notice.
Yes, my Lord.
When is the date of eviction?
Yeah, it's at the end of this month, my Lord.
It might be date.
30.
What is the date of the eviction? They are fixed.
30.
When you receive the notice?
28/7/2025.
28/7?
Yeah, my Lord.
So what is the urgency?
Don't.
Live notice was issued. Give it will be listed.
My Lord.
List. Yes, call the list.
Thank you.
Call the list.
This is the instructions were given by the petitioners, my Lord, for withdrawal.
Withdrawal. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Petitioner handed over the communication wherein the petitioner has informed the learned advocate on behalf of the petitioner to withdraw that the petitioner do not wish to proceed the matter and requested to withdraw the same. In view of the communication, counsel for the petitioner prays for withdrawal of the suit. Consider the submission made by the counsel for the petitioner and the communication WPA 15360 of 2021 is dismissed as withdrawn. Connected application, if any, is also dismissed.
Instruction.
Stand vacated.
But the instructions may be kept with the record.
But the communication be kept with the record.
Grateful, man.
Yes, next.
My lord, item 2 and 3 are connected matter. In this matter, I am led by Mr. Bilwadal Bhattacharya and Mr. Chatterjee. My lord, the reason for urgency of this matter is, my lord, so far as item number 3, which is an anticipatory bill, is concerned, the interim order is expiring today. So, my lord, I am beseeching your lordship to extend that interim order and fix a date for hearing.
Give the CRM file. The item number 3. Give the item number. Okay,
Yes, my lord.
both file you go. Give
If your lordship sees the last order, even Justice Sinha was pleased to send up the matter today because the interim order was expiring today.
Give the CRM matter. Item number 3. Both are here.
My lord, a common order was passed on 10/9/2025 in the writ petition as well as in the anticipatory bill application, extending the interim order till 11th of November.
Dated?
My lord, 10th.
Order is passed in WP or CRM?
My lord, both. My lord, I have the order. My lord, it's marked.
Order dated?
The writ and the CRM are being heard together. For the state, I appear for the CRM. In the writ, the state is even not a party. So that is the only difference as far as I.
Appearing, writ you are not appearing.
State,
Writ who are the parties in the writ petition?
Well, petitioner is.
With your lordship's kind leave, my lord, in the writ petition, my lord, first of all, my apologies, my lord, for appearing virtually. I am a little bit indisposed.
It's no problem.
Now, my lord, in the writ application, the ECI is the primary respondent and the CBI is also a respondent along with the Union of India.
Yes.
Now, the ECI, pursuant to the directions passed by the Honorable Court on the 20th of August, they have now come up with a report. The report, I do not know, my lord, whether the ECI has at all filed the report or not. We have been served with a copy of the report. The report states that the allegations, as has been revealed in the writ petition, on the basis thereof, there were inquiries conducted. It's prima facie found to be correct. There are inquiries, there are FIRs now against government officers, and the state government is acting loath. That is what, my lord, the report indicates. And they say, my lord, the ECI says that SIR has now commenced. So this was, my lord, at the nascent stage. This was in August. So, my lord, we will also like to deal with the report that they have filed, my lord, in the writ petition.
Have you received the report?
We have been served with a copy of the
You filed
report.
the exception to the report.
We will do that one. We will do
And
that.
what about the interim order of the CRM?
My lord, in so far as the interim order is concerned, my lord, there is no allegation, my lord, on part of the state respondents, as also recorded in the last orders, that there is non-cooperation. I have cooperated. I have been to them. They have interrogated me, my lord. The only difficulty was, my lord, since I filed the writ petition as a whistleblower, they suddenly added graver sections to indict me, my lord. Otherwise, my lord, these were all, my lord, coming within the purview of, my lord, notices under section 35(3). So this particular design of the state, because it's a design, my lord, orchestrated by the state, that is the allegation, my lord, in the anticipatory bail petition also, that they will try to scuttle the investigation and they will try to keep the truth away from the records.
Yes.
Yes. So, my lord, insofar as the allegations contained in the writ petition is concerned, my lord, I am in a dark. My lord, cannot comment on them. As far as the CRM is concerned, if your lordship is, my lord, inclined to extend it, and today it was for extension only, I would, my lord, request your lordship to consider, my lord, putting in the previously put conditions in the orders, my lord, along with the extension.
Cooperating with the
And, my lord, to hear out the matter, my lord, as and when your lordship, my lord, deems fit.
Counsel for the petitioner. It is CRM. Counsel for the petitioner submit that the interim order in connection with the grant of anticipatory bail is till today and prayed for extension of interim order. He submit that initially this court has passed an order granting anticipatory bail to the petitioner by an order dated 25th of August. 25th of August is the first date.
Yes.
25/8, subsequently extended on the 10th of September.
Yes, 2025, and subsequently by an order dated 10th of September 2025, the same was extended till today. We submit that there is no allegation that the petitioner has violated any terms and conditions of the anticipatory bail granted by this court, and petitioner is cooperating with the investigating agency. Nana counsel for the state submit that the petitioner is already enjoying the interim bail and anticipatory bail. If this court intends to extend the anticipatory bail, the term can be extended subject to the condition imposed by this court. Subject to condition imposed by
Yes.
In view of the above, the interim order is extended. How soon you will file the exception to the writ petition? That's
I can do that within 2 weeks, my lord.
within a week.
2 weeks, my lord. A
Within
fortnight.
So both is to be heard together.
Yes,
My lord.
Petition and that.
My lord.
2 weeks and today we are on 11. 2 weeks, 25. So I am extending till 5th of December 2025.
Grateful to your
And
lordship.
I am fixing the matter on 3rd of December at 2 p.m.
Grateful to your lordship.
Is extended
Obliged.
till 5th of December 2025 with the condition that the petitioner shall cooperate with the investigating agency and shall not leave the state of West Bengal without the permission of this court. Let the matter appear on 3rd of December 2025 at 2 p.m.
My
At 2 p.m. Along with WPA.
My lord, may I pray for one indulgence only, my lord? I have attended, my lord. I have been interrogated several times, my lord, by the police.
But I recorded, you have complied with it and you
in
have-
the name of interrogation, my lord, what they're doing is the police station is, my lord, at a remote point. It's in Bokhali. So,
These were
The Bhattacharya that always be there.
my lord, not more than twice a week, not more than 3 hours at a stretch.
No.
Very
Grateful,
well.
your
My lord,
lordship.
in that event, my lord, we always have the liberty of coming back and mentioning before your
Yes,
lordship.
if it is there, then yes.
Grateful, your lordship.
Extremely grateful.
It is fine that WPA, it is fine that the respondents number 1 and 2 have filed the report, counsel for the petitioner prays for time to take exception to the report. Let the exception be filed by 25th of November 2025 after serving the copy to the respondents. Please the matter on 3rd December 2025 at 2 p.m.
And my lord, the ECI may come back, my lord, with the updated status also, because the
A 2462 of 2025.
the ECI may come up with the updated status also, because this was in September. First week of September, the report was affirmed.
Let them come on the, we'll see if it is required, then I will call them.
Very well, my lord. Extremely grateful to your lordship, my lord.
No. Cran display. Cran display. Under the heading especially fixed matter. WP especially fixed 2 p.m. Yes, next.
I wait for the statement.
Yes.
The petitioner. There is the case regarding the plot number 441.
Huh?
441 in the plot.
Use microphone.
Microphone to use school.
In respect of this plot number 441.
What is your prayer?
Well, prayer is to pass an interim order because the appellate authority is passed under section 10(4) of the Highway Act.
Yes.
Now, ultimately,
So you are in occupational government land.
in respect of this the order by filing this writ petition by the private Honorable 12, whereas the writ petition was directed of this Honorable Court to hear out this appellate authority afresh, but without any inquiry of the concerned BLLO of the concerned plot and without any demarcation, that property has to be demolished.
Where is the order of the SDO?
My lord.
They have preferred an appeal before the SDO's order. You have the
SDO's
DM. They have challenged that order.
Where is the order of the SDO?
My lord.
Page 44, my lord. Page 44 of the writ petition.
Proceeding under section 10(3) of the West Bengal Highway Act 1964. By an order dated 28 December 2022.
Earlier occasion also you approached this court.
Yes. They have suppressed all these things.
No, I have already.
They have not annexed the order passed by the Lordship, the Honorable Justice Shubhra Ghosh, my lord.
The petitioner was filed by the private respondent. We are the private respondent. Whereas the writ petitioner was filed. We are not filing this writ petition. Now, in connection with that writ petition, it has been directed to the challenging of this order. It has been directed
Let me know everything.
To prefer an appeal.
Come to the impugn order.
Interim order is prayer F. An interim order of injunction restraining the respondent and the agents not to give any effect or further effect of or staying of operation of the impugned order dated 28 2025 arising out of the order dated 28 December 2022 passed by the respondent number 2 and 3 herein being annexed P4 and P5 to these petitions forthwith in connection with the plot number 441 GL number 195 Moja Palpada Potaspur 1 block post and PS Potaspur district Purbo Medipur of the land of the petitioner as Rayoti land being annexed P1 to this petition pending final disposal of this application.
The DM order is page 47.
So your lordship, my lord, kindly take it up for hearing, my lord, in any.
This is the my lord, report filed by the assistant engineer, my lord.
Because assistant engineer PWD wrote.
What is the name of the petitioner?
Writ petitioner is the Ratan Jana.
Huh?
Ratan Jana.
Ratan Jana.
Yes.
And page 44, who is the petitioner?
Because my lord, the Dhananjay Dey is also made party in private.
Dhananjay Dey is the complainant, and you are the opposite party. You are the opposite party before the sub-divisional officer.
Yes, yes.
And this is the order of the sub-divisional officer.
Yes, yes.
And where is the appellate order?
Page 47.
Page
47, my lord.
47.
This is the DM's order.
And this is the 2024 till date, the order has not been executed.
It has not been executed, but by tomorrow, my lord, that will be demolished.
No.
How you came to know that tomorrow it will be demolished?
No.
Because my lord, the recall of that order of justice.
Repetition is pending, my lord.
In respect of. No. Let a copy of this be served upon all concerned.
Sir.
Final
Yes.
disclosure.
Here is the report filed by the assistant engineer. You also can see. Kindly see, my lord. This is the order passed by his lordship, the Honorable Shubhra Ghosh. After that order, kindly allow me. Kindly allow me.
I will send you out from this court.
Kindly allow me.
I am sorry.
You also can come to page 44. After this order, the subdivisional magistrate will hear the matter. Against that order, they prefer an appeal before the DM. DM's order is page 47. My lord.
The page number 44 is the impugn order.
Yes.
Kindly come to the impugn order. What you understand from that order? Show me. Or tell to this court what you understand.
But the matter is taken up for hearing today. The learned advocate for the petition is present in the opposite party. The submitted hearing objection, which is adjudged of the court of the not sufficient of the grant of further plea and the opposite party
please, not allowed by this court. After hearing the parties, after careful perusal of the available documents and records, in directed to Assistant Engineer Tomlu PW Department to recover the position and
What
remove the
document he has considered? What was before the subdivision? Where is that? Where is the reasoning?
That is why I am filing the report.
Why this you can
Filing this report, my lord, will logically see the report, my lord.
whether this report can be read with the order of the subdivisional officer.
Yes,
This is the way the subdivisional
after
officer is
considering all
passing the
these things,
order.
after considering all these things and report, after
That's why
measurement.
show me in the order what document has been considered by the subdivisional officer. This is the order. This is a way of the
Against that order, they prefer an appeal.
Record an order.
Against that order, they prefer an appeal, my lord.
The petitioner being agreed and dissatisfied with the order passed by subdivisional magistrate Agra dated 28/12/2022 and the order passed by the district magistrate Purva Midnipur dated 21/11/2024 has preferred this appeal and preferred the writ petition. The order passed by the subdivisional officer reads as follows. Okay, page 44. Yes. Considering the impugn order passed by the subdivisional officer, this court finds that it is recorded that the subdivisional officer has considered the documents and records and directed the assistant engineer Tamluk to recover the possession and to remove the encroachment. The subdivision officer has not mentioned what are the documents and the record were available with the subdivisional officer from which the subdivisional officer has satisfied that the petitioner should be evicted from the government land. It is also, this court also did not find that any report has been called for or any report has been supplied to the petitioner so that the petitioner get an opportunity to deal with the report. Mere with only by one paragraph, the subdivisional officer has passed an order for eviction. Full stop. The appellate authority, by an order dated 21/11/2024, has also did not consider what are the documents were available before the subdivisional officer or whether any document were produced before the appellate authority at the time of hearing of the appeal. Considering the above, this court finds that the subdivisional officer as well as the appellate authority have passed the impugn order in a casual manner without following the due process of law and without giving an opportunity of hearing with regard to the document which the authorities have relied upon and has not been supplied to the petitioner. In view of the above, the order passed by the subdivisional officer dated 28/12/2022 and the appellate authority order dated 21/11/2024 are set aside and quashed. Full stop. The matter is remanded back to the subdivisional officer to hear the petitioner afresh, and if the subdivisional officer is relying upon any documents or any report, the same shall be served upon the petitioner. The petitioner has liberty to deal with the report, and after hearing the parties, after hearing the petitioner and the affected parties, to pass a reasoned and speaking order within a period of 8 weeks from the date of receipt of this order.
Report be kept on record.
The report submitted by the state be kept with the record.
And the report filed by the police officer to the police.
The report submitted and affidavit of service filed by the petitioner kept with the record.
And the report filed by the local
report by the state. Report filed by the state है ना उसी में is be kept with the record. Yes, next.
By disposal.
Remanded 8 weeks you consider fresh. Tell your officer.
After seeing all the documents and
tell your officers if you are relying upon any document, please serve. Why you are putting the burden upon the court? Yes, next.
My lord, I am for the respondent in item number 5, my lord.
is addressing another court, my lord. He is requesting if your lordship will kindly take it up at 2 p.m., my lord, if it commences. There is urgency in this matter, my lord. As a tender matter, I have been disqualified. They have not yet, my lord, declared the successful bidder, so there is staring urgency, but I'm instructed to pray for that. Your lordship will kindly take it up at 2 o'clock, subject to your lordship.
Password till 2 p.m.
Extremely good.
Come at 2.
My lord, great.
Yes, next.
But I am for the petitioner, it has appeared at my instance. But I had told your lordship that appeal was carried to the division bench from an order of refusal of ad interim order in this matter. But the division bench has passed an order where the division bench has observed that the Lord Illuminati takes the order. That since my lord, the Kolkata Municipal Corporation was not made a party in the original writ petition, and hence the application, my lord, although it seeks my lord leave to serve KMC, my lord, that should be addressed before the learned single judge. That's why I mentioned there was some urgency. My lord, kindly takes the order of the petition.
Where is the fine?
But I have served Kolkata Municipal Corporation. I do not know whether they are appearing or not. I have served the Kolkata Municipal Corporation.
Your Lordship, in this matter, I am appearing for respondent number 9. Directions were passed for filing of affidavits. That was challenged before the division bench. Honorable division bench was of the view that as the matter is pending before NGT, the honorable single judge had rightly passed for affidavits of directions for affidavit in opposition, because we have taken the point of mentability, your lordship. Kindly seize the division bench's order. The single bench's order, yes, they had gone to the division bench. They had gone to the division bench challenging that order, and that order has been upheld by the division bench.
Please, I will hear all. I will hear all of you.
You have the habit of misleading. That is why I need to correct. Yes.
I will not pass any order by hearing only one party. I will hear
So grateful. So grateful. Hey, then. NGT ব্যাপারটা এখানে NGT কথাটা বলেছে
formulated a case committee to look into the allegation of illegal conversion of water body. These subjects of the portion of the water body state are identical to that. There are structures which corporation sanctioned with respect to the area.
আরেকটা অর্ডার দাও না
submits in the direction of that illegally filled up area should be reclaimed, that the water pollution is distributed. Subject cannot be trusted to undertake such works since the structures remain on water. But an advocate appealing for respondent number 9 submits the application training for NGT taking exception. The state is represented now, paragraph 7 of the petition is still pending. In the pending petition, the application filed with the appellant as a petitioner seeking various directions on KMC. KMC is not a party responding to the petition. Appellant did not apply for adding KMC as a party responding to such a petition. That single judge is yet to decide the application finally. That single judge directed affidavits to be filed. We do not find that exercise of discretion by the single judge is erroneous or purpose to require intervention at this stage. Such is corrected. All I'm saying, and now takes a look at CAN 6, which is the application.
So you file the CAN?
I have filed.
CAN नहीं करना चाहिए. Now the read.
But after hearing the
CAN 4. Yes, sure.
And Madam, kindly allow us first, Madam. This is, I think, the rule of the law.
That's what I'm telling. I will hear all of you. Let the petitioners.
We shall be allowed to file our affidavit.
Affidavits. And this 8th, kindly seize the 8th August 2025 order. CAN 6 application was adjudicated 8th August 2025, an order was passed
this court.
By this court, your lordship, by the Conduit bench.
By which order?
8th August 2025, which was challenged before the DB. That is not all.
Correct. What is the CAN 6? What is the CAN 6?
The urgency which they are now.
Our original municipal corporation. First grade. And we have several other grades. Now, we have all that the honorable judge, your lordship, which is said, did also. There we let them. There the honorable judge. Or in Kansas, we are not minded to interfere with the order. Number I have mentioned matter 5. Number 1, directions for activities. Only and only respondent number 7 has filed an affidavit. None of the rest of the respondents have not filed an affidavit. Despite direction, number 1. Number 2, my first prayer, which is going to lead to serve the municipal corporation, is still there. I can press for it, and I press for it. Your option is to ask me to direct a copy of the affidavit to serve the case.
Have you have
They are served case. Kindly see over the affidavit of service.
who is for the respondent number?
7 only has filed an affidavit. Nobody else has filed an affidavit.
You will file the affidavit.
Your Lordship, my affidavits are ready.
Yes. Now
And this,
let them file the affidavit.
the affidavits, if he
You are appearing
completes, your
for-
Lordship,
You are appearing for whom?
respondent number 9.
You are
If,
for
he
the
com-
respondent.
if my learned friend completes, then I will apprise the court with the facts.
Please, let me understand who has filed the. So you are for the respondent number 1. You are filing affidavit.
I am for respondent number 9. Your
9.
Lordship. 9.
Okay. So you are filing affidavit today. And what about the 1, 2, 3, 4?
My lord, so
Lordship,
far
I have
I am,
submitted
my lord,
the-
so far I am concerned, my lord, if there are one contempt application, your lordship will find item number 7. In contempt, my lord, I have filed my.
Contempt I will come and with let the can 6. Can
Okay.
6.
As your lordship.
Yes, you are appearing for
Lordship, I am appearing for on behalf of the state. Lordship, I am submitting.
state which
Respondent 7.
respondent number 7. 7 and 9. Now then
7 are already filed.
And 9, your Lordship, I am filing.
9 no copy has been served out.
দিয়ে দিচ্ছি
7 and you are appearing for?
তুমি ভালো ছেলে তোমাকে দেবো না
Have you filed the affidavit? You will not file. No, let 3 clarify whether you will file the affidavit with regard to the can 6 or not.
Direction is given, Lordship. I will.
Direction is already there. On 8th of August, there is a direction. 8th August, there is a direction to file affidavit.
1 week or 2 weeks. Can we
Extension
file?
of time. And you are appearing for?
The respondent number 5, your lordship.
Yes. You will not file. You will not file. Okay. Then, what about the other? You are appearing for?
I appear for Lord Intervenors. My application can 4 was not dismissed by the Honorable Single Bench. Lord, an appeal is pending as on date with that. Lord, this entire NGT proceeding is at my instance. Lord, my plot is in progress. Lord, behind my back, without making me a party, Lord, this entire proceeding was drawn up. Immediately, after notice, Lord, I went up to the Honorable Supreme Court. I was granted Lord liberty to pursue my cause for the NGT. Now, these proceedings are in the meantime not carried out so that the NGT proceedings become in success. So that's the only Lord purpose.
So what has happened to that your appeal?
Lord, the appeal is pending as on date, Lord, because the appeal is pending because NGT. Lord,
There is a rejection order by this court.
Lord, that is no, there is no state. Lord, I will not say that there is no.
Where is the rejection order? Can number 5?
The can 4. That's the rejection. The NGT proceedings at my instance. My plot, Lord, is
Please.
And for 3 order আছে 30th March. 30th March is the order.
Yes.
The proceedings of NGT is at my instance. My property is at stake. These proceedings are not initiated so that my property is demolished. Now, without hearing me, I'm not on board as on date.
What can be done? Now this court cannot go beyond the order.
What is the purpose of this petition?
That's correct.
What is the NGT
That's
proceeding?
correct.
If your lordship would reconcile, your lordship would find.
That's correct. I can reconcile, but I cannot reconcile the order passed by the coordinate bench.
15th of December is the next date fixed for NGT for hearing
15th of December.
December.
Correct.
Next date fixed for hearing of my application.
Before
NGT.
NGT.
Grants me that time, takes up this matter after that, so that in the meantime.
Okay, by that time, let they file the affidavit. By that time, let they file the affidavit with regard to the Can 6. Let they file the affidavit. I am extending the time for affidavit.
And EMC has been served. I am asking for a copy of the EMC has been served.
This one?
Yes, person to not given to me. But I have not.
Anybody is appearing for the KMC? Who generally appears for KMC?
Yes, counsels are there. I can serve them one.
Your Lordship, may I show the prayers of Can 6? Can 6 prayer is at page 28. The first prayer at A is an order granting leave to petitioner's advocate to serve a copy to the present application upon the KMC, Your Lordship. This prayer was also pressed on 8th of August 2025, when we had seriously taken the point of mentability and showed that there is a serious cause of forum shopping. There are orders in teeth of the courts of NGT and the Honorable High Court. He is filing one after one application to get the matters heard out in his favor without allowing the other parties to be heard. So we had seriously objected that this KMC cannot be added as a party in the proceedings because initially the writ.
So as per your case, unless and until the parties have been heard, no notice can be issued to the
Your Lordship. And what he has done is, without apprising Your Lordship about the DB's order, and the DB order has never said that the KMC should be served a copy, and he has taken the liberty, and now he has quoted possibly that Your Lordship has given the liberty to serve the KMC, and he is wanting to induct the KMC or implicate the KMC in the proceedings, Your Lordship. And we are also taking exception in the NGT. Proceedings are going in NGT, where KMC is also a party. Your Lordship, parallel proceedings in different forums is possibly not the rule of law, Your Lordship. Kindly take our affidavit. Let them file their reply.
Give this also. That also. Give this. So respond number 7, respond number 9. 2 have filed, and you have received against any other?
7.
No, please.
So 9 and 15.
So any other respondent want to file the affidavits? You want to file affidavit with regard to 5? 3. And other respondent didn't want to file any affidavit. I will record this. Recorded. The respondent number 9 has filed affidavit in opposition in connection with Can number 6 of 2025. After serving the copy to the learned counsel for the petitioner, let the same be kept with the record. It is found that the respondent number 7 has already filed the affidavit in connection with the Can 6 after serving the counsel for the petitioner. You will file a reply. The counsel for the respondent number 3 prays for extension of time to file affidavit in opposition in connection with 6 of 2025. Let affidavit in opposition be filed by 1 week, by 2 weeks after serving the copy to the learned counsel for the petitioner. The petitioner is liberated to file affidavit in reply in connection with all the affidavits and affidavit of, if any, filed 7 and 9 within 2 weeks thereafter. Full stop. Let the matter appear. Full stop. The counsel for the petitioner submits that the petitioner has served a notice upon the KMC, but the KMC is not appearing. It is found from the prayer of Can number 6 of 2025. The prayer A is for leave to serve the copy of the application to the Kolkata Municipal Corporation. This court finds that the respondents are restraining the petitioner for adding the KMC as party for serving the copy of the application to the KMC. Thus, this court is of the view, unless and until the application is not been heard on merit after the exchange of affidavit, the petitioner is not given any liberty to serve the copy upon the KMC. Let the matter appear on 2 weeks, 4 weeks, on 10th of December 2020. When your matter is fixed? 25th, 15th. Let the matter appear on 17th December at 2 p.m.
Your Lordship, they be directed to serve this copy to the KMC because earlier they have served that.
Let this court satisfy.
अरे ठीक আছে
The prayer. So if you are objecting and serving the copy, so what purpose should be served?
No, copy of this application, copy of this order, Your Lordship, because he has quoted that Your Lordship had given liberty to.
That's why I clarified.
Your Lordship, this clarification should again go from their end. Okay,
If they will come, then we'll see to that.
Okay, we will clarify.
If they will come, then we'll see to
So,
that.
sir.
Under the heading specifics.
Item 7 মানে the contract matter.
ওটা তো adjourn হয়ে গেল তো
মানে item 7
एक मिनट, just a minute.
7 is also adjourned.
हम जो ऑर्डर देता है ना स्पेसिफिक्स आप नोट करके रख लेना ताकि फिर वो लिस्ट में आना.
And in content matter, may I file my opposition?
Content matter is for the petitioner.
Went up. Your Lordship, it be also adjourned.
7. Recordance. You are filing?
3 and 4 on behalf of 3 and 4, and may I file the opposition?
Counsel for the alleged contemner number 3 and 4 has filed affidavit in opposition.
Yes, sir.
Affidavit in opposition.
It has been served upon the petition.
After serving the copy to the learned counsel for the petitioner, let the same be kept with the record. Let this matter also appear on 17 December at 2.
Grateful to you.
Next.
Item number 8.
Very short is covered by language part by your information. The Constitution Council proceeds that section Council records that under 80 conciliation is initiated. In that, every party files a claim, I file my claim. If there can't be any conciliation, then I will award it. So that 18(2), just on the point of jurisdiction, recording of conciliation is mandatory. Either if it fails, then 18(3) comes. 18(3) comes in, then arbitration has been incorporated by reference, then you follow the entire arbitration act and pass an award. Once that award is passed, I have to challenge under 34. Otherwise, unless my first point is I'll just be paying for a stay of this today. But on the next day, I'll be paying for sitting aside based on
354.
354. This is the counter. Worship will directly come straight to her, the history counter, history card, all of that. I'll just show one line. Please have a look at 361.
Yes.
Under the above circumstances, the council initiates conciliation process under section 18(2) of the MSME Act for an amicable settlement of the dispute between the parties. With this, the council directed the OP to file counter against the execution of the claimant before the next sitting and send the copy of the same directly to the claimant under information to the council. Upon receiving the same, the OP claimants rejoinder all of it. So parties file their claim for the next of the conciliation. Now please come to
So this is the
I think what we will find at least 904. Then the entire thing is set out. Ushida all of it. But today I don't need to cover consult.
904.
904.
Yes.
Ushida the whole of it. I don't need to talk with any of it.
Yes.
Have a look at the 911. Notice has been sent line about 6 from bottom. notice has been sent to the parties to attend the 108th sitting. And on 13 December. So this is the one that I just showed you already. The order. Then fair counterclaim, all that we find in terms of the order of consideration. Now, please give it a cursory glance. There is no recording of any finding with regard to consideration. This is treated to be what it is, and 914 is the award. There is, but apart from just the reasoning, there is no finding of for anything. Just the whole case is set out, and the Lordship will find at 914 the award is passed. So just in aid of this,
Council directed OP to pay principal amount and interest under 18(3).
conciliation to arbitration didn't even happen.
Who has passed this order?
MSFB Rahul Kelly.
Chairman, director.
Straight away award. I cite one division bench judgment of this honorable court, and I will not trouble you also any further. So this is 2015, sorry. Yes, 2015, volume 4, Calcutta High Court, page 1. This was also a challenge by the writ petition order, path or in the nature of an award, whatever it be. Get the first paragraph if I may just play. Special enactment, MSME Act, which indicates how a micro if involved in the litigation has to be dealt with, not in dispute with the complaint and the party. Specification counsel took up the matter to exercise power control upon them under the Opposition Act of 2006. The improved order annexed D of the paper book. Apparently, reading of the said order would indicate that initially conciliation was attempted on the part of the council, which ultimately resulted in improved order dated 10 February 2012. It is not in dispute that the order dated 10 February 2012 came to be challenged only in the year 2014 when the party respondent attempted to execute the same as an award. In order to appreciate the contention, then section 18 is set out. Your Lordship, I will not have the ability to read out the section. Please have a look at immediately where the section ends. Subsection 3 is quoted, then it is not in dispute. Then just after that, it is also pertinent to mention that once the conciliation fails, there has to be an order of terminating the conciliation and intimation of initiation of an arbitration proceeding to the opposite parties, where to allow the parties to know the intention of the council. The conciliation proceeding initiated on the reference made by the complainant was unsuccessful. Therefore, they would proceed with the matter in accordance with the provisions of the Arbitration Conciliation Act 1990, Section 3 of 18 of 2006. So, recording is mandatory. Please have a look at the last paragraph. In the present case, I'm sorry, this is page 3 of.
Yes.
In the present case, the last paragraph of page. In the present case, the ultimate result is 9 or 10 lakhs due to the appellate here would compel to pay 92 lakhs interest on the said amount due. If ultimately, after giving an opportunity to contest the proceeding, the appellate have to pay interest as indicated in paragraph 16 on the strength of an award in arbitration proceeding, it has to pay the same as procedure contemplates. So, in another proceeding challenge the values of the act is already failed. It has already fallen as the court failed, upheld the legality of the enactment, but the fact remains whether it has an opportunity to contest the matter in arbitration proceeding after termination of conciliation proceedings. No doubt the appellant has an opportunity to challenge the council's order much back earlier, way back in 2012, instead of challenging the same, and execution of the same is sought to be made by the private respondent. According to him, such award is honest and
did not have
he did not have the opportunity as contemplated in subsection 2 of section 18. The procedural lapses on the part of the council goes to the root of the matter. Therefore, even if there is delay, in my case there is no delay, and lapses on his part, the same has to be given concession as the respondent number 4 would not be prejudiced in any matter. As against this, learned counsel for the private respondent contends a right has accrued to him by virtue of an award to be executed. Therefore, at this point of time, the same cannot be unsettled. Looking at the consequences of an award, wherein the appellant had no opportunity of taking part in the said proceeding, we are of the opinion no prejudice would be caused to private respondent number 4 if the impugned order is set aside, directing the council to proceed with the matter in accordance with procedure contemplated under subsection 3 of section 18. However, the parties have to be put on terms, that is, A, the entire procedure contemplated has to be within 3 months from the date of receipt of this order, and the appellant shall not be delay tactics. The inconvenience caused and so and so, or this was cost was paid, because he had come after 2 years. Here I am actually within time.
Yes.
So two things, one is.
So your contention is that the order, impugn order, should be a termination order instead of the award. He has passed the award. After the termination, then the proceeding is to be initiated under 18.3.
That's the long and short. That's it. Which is why I say I don't want to double your lordship too much today. On the next day, I'll be asking for a setting aside of this, because this is
correct.
Only without
the other party come and see to that. What is the contention?
Is it? I am appearing for the Vidhi Vidhan engineers.
Vidhi Vidhan engineer.
I want to say just two things.
Just a minute. Your party, yes.
Party in person.
Yes. Tell me what is your submission?
See, Honorable High Court of Odisha has said that.
Who are you?
I am the party in person on behalf of Vidhi Vidhan engineers.
You are the partner?
In person.
Vidhi Vidhan is the partnership firm. You are the partner or you are the authorized representative?
Authorized representative.
Where is your authorized representation?
Everything I will produce.
When you are submitting before the court, you have to produce. You have a representation.
I had only 2-3 days.
2-3
days only. After getting the notice, I had only 2-3 days. And
so only tell me that the order which has been challenged, can the authority pass an award before without the cancellation or termination order, the cancellation proceedings order under 18.2?
See, 18.2 is elaborative and very clear. Very clear. What I want to put today is only that Odisha High Court has said, Chief Justice of Odisha High Court has said, there cannot be any proceeding against MSCFC award in High Court in form of writ petition. I have that judgment also. Moreover, this is a very, very dark picture. Section 2213 of Companies Act 2013 clearly mandates that any due that is to be entered in the books of account as and when accrued. This is a matter of 2018. When something accrued, that would have been entered into the books of account, and that has not been done at all. We are all moving in.
Okay, you come on the next day?
Yes.
The petitioner has filed the present application challenging the impugn order dated impugn award dated 25th of June 2025, wherein the council directed the opposite party. You are the opposite party?
Yes.
Here the opposite party within bracket petition herein to pay principal amount of rupees 65,97,876 and interest amount of rupees 190,51,078 under section 18 within bracket 3 within a period of 30 days from the receipt of this order. Full stop. Counsel for the petitioner submit that the council has initiated
serial number कितना चल रहा है?
Initiated
8 ना? हैं?
Initiated a proceeding, a cancellation process under section 18 within bracket 2 of the MSME Act 2006 for amicable settlement of the dispute between the parties. Full stop. I submit that instead of submit that you had appeared before the cancellation. Parties have appeared before the cancellation proceedings. Once the order is proceedings have appeared before the cancellation officer, but instead of passing an order under section 18 within bracket 2, whether the cancellation proceeding is settled or terminated, it has directly passed the impugn order by way of an award. He submitted under section 8. He submitted the chairman cannot pass an award in the proceeding initiated under section 18 within bracket 2 of the MSME Act. MSME. Mr. Counsel for the petitioner has relied upon the judgment in the case of Lloyd Insulation within bracket India Limited versus State of West Bengal, reported in 2014 SEC Online Calcutta 20072 and submit that in the said case also the Honorable Division Bench of this court has categorically held that the award, the categorically held that and if the proceeding is initiated under section 18 within bracket 2, comma, the council directly cannot pass an award unless the parties have come to a settlement. If the parties have not settled the matter, comma, it is to be terminated and further proceeding is to be initiated under section 18 within bracket 3 of the said act for under the Arbitration and Cancellation Act for appointment of arbitrator. Considering submission made by the counsel for the petitioner, peruse the judgment relied by the petitioner. This court find that the counsel has initiated the proceeding under section 18(2) in 18(2) for cancellation of for conciliation of the process, but finally the chairman has passed an award, but that the award does not reflect that the parties have settled the dispute, and on the basis of the settlement the award was passed. This said award is under section 18 within bracket 3 of the MSME Act, and thus this court is found that the petitioner has made out a prima facie case that the chairman cannot pass and the council cannot pass an award unless and until the parties either to settle the dispute under 18(2), or if it is not settled, it is to be terminated and the proceeding is to be initiated under the Arbitration and Cancellation Act. In view of the above, the impugn order, the operation of the impugn award is stayed till 2nd of December 2025. That the matter appear on 28th of November 2025.
On the
28. 28. The petition is directed to serve the copy of the writ application along with the documents to the respondents.
Which is the next date, my lord?
28.
28 November. Thank you.
Next.
I will appear with all my
Come with then appear.
Okay, thank you.
Item number 9.
Yes. So you will deal with this.
Before dealing with this, my lord, one thing, lord, is what previously heard by one of the coordinate benches, my lord. And we took a point of maintainability of the writ petition itself, my lord.
Justification, my learned friend was not there. I pointed it out to your lordship that they have taken the point
of maintainability.
And since my lord, the advocate who was here, my lord, was not fully prepared, that is why your lordship is pleased to adjourn on that. May I file this supplementary evidence?
Just a minute. Yes, preliminary objection is raised by the respondents.
My lord.
Second and fourth respondent. You are appearing for?
For the state respondent, my lord, second and fourth.
Second and fourth.
Fourth, my lord. Second, third, and fourth.
So whether the maintainability can be taken on facts or you want to argue the matter before that?
The maintainability, my lord, kindly take some maintainability first, my lord.
What is the point here?
My lord, my lord. My lord, kindly takes up the prayer portion of the writ petition itself. Is page 39.
Yes.
May I read it for your lordship? Prayer A. A writ of mandamus to issue commanding the respondent authority, the main agent and servant to recall and or rescind the or cancel the stop work notice bearing number such and such, dated such and such, orders dated such and 9th July being annexed P9 and P11. Well, then my lord, kindly turn to P9 first. It will appear, my lord, 103 of your lordship's speech. May I read it for lordship?
Yes.
Dated 29th of September 2022, the JMCT regarding such and such. Well, this directly come to the, my lord, second paragraph starts with therefore. Therefore, you are hereby directed to stop all works within the project area immediately under Section 5 of the Environment Protection Act 1986 and its subsequent amendments to the standard operating procedure for identification and handling of, well, that has been stated. But the Environment Protection Act, may hand over, my lord, it says the Section 5A itself says, my lord, that the any person aggrieved by any direction issued. Well, may I hand over to my lord? 5A, my lord. Appeal to National Guild Tribunal. Any person aggrieved by any direction issued under Section 5 on or after the commencement of the NGT Act 2010 may file an appeal to the NGT established under Section 3 of the NGT Act 2010 in accordance with the provisions of that Act. Now, my specific objection to the writ petition is this, my lord. They prayed for the quashing of Section 9 and P9 and P11. P9 says it had been issued under Section 5 of the Act. And the 5 capital A says, my lord, there is a provisions of appeal. They have to prefer an appeal. This is one of the preliminary point. Now, second, my lord. Yes, sir. Section 14 of the NGT, my lord, the National Guild Tribunal Act, my lord, 2010.
Yes.
Well, this is the Environment Protection Act and the section 14. Tribunal to settle the disputes. Tribunal shall have the jurisdiction all over civil cases where substantial question relating to environment, including enforcement of legal right relating to environment, is involved, and such question arises out of implementation of the enactment specified in Schedule 1. Tribunal shall hear the dispute arising from the questions referred to in
You are
subsection.
referring to 14.
That is Environment Protection Act, that is National Green Tribunal. May I hand over? That is with in the tab, Milord. May I change it, Milord? But today we are also trying to be digitalized, so not carrying the books.
It's good.
See, Bosaga said that no physical filing, physical file will be there after few years.
That's correct.
The lordships are also trying to be digitalized.
Yes. Nowadays, because of the space and all these things.
May I, Milord, 1 second, Milord.
Section 14.
My lord. Tribunal to settle the disputes. The tribunal shall have the jurisdiction all over the civil cases where the substantial question relating to environment, including enforcement of any legal right relating to environment, is involved, and such question arises out of implementation of the enactment specified in Schedule 1.
Yes.
And Lord, my humble submission, this Lord, this question relates to the environment. So it will go to the NGT, Lord. And as per section 5A of the Environment Protection Act, and Lord, as per section 4.
Arising out of the implementation of the enactment specified in Schedule 1. Where is the Schedule 1?
Schedule 1, Lord. Schedule 1 is part 4.
Water, Forest, Air, Environment Protection Act 1986.
Water, Environment Protection Act 1986. Serial number 5.
Correct.
But this is my humble submission that the writ petition is not maintainable in view of these two facts, my lord.
Yes.
They have to approach the tribunal.
So you have taken the point of alternative remedy.
My lord. Not alternative remedy, but specific remedy has been, not as per the Schedule Acts, the serial number 5 in the Schedule Act.
Okay.
The lordship can remember when the tribunal was set up, the land tribunal was set up, there is a specific act. It was specified that it will not be maintainable before the High Court any longer.
Yes.
Kindly look into the order of 9th of February 2023 passed in this petition. If your lordship, can I hand over, or if your lordship has a copy?
Yes, it is there. Now the appellate said all the orders will be in the record.
So, 9th February.
Yes.
Kindly come to the order. Learned counsel appearing for ACIA CR places Section 5A of the Environment Protection Act and Section 16 of the National Green Tribunal Act to submit that the petitioners have an alternative remedy under the two statutes to approach the tribunal as an appellate authority from the order impugned in the present petition. Council further submits that the petitioners have constructed 3 buildings which are part of one and the same project. Well, Lord, I shall come to the facts, my lord, later on because facts would be required.
Correct.
Learned counsel for the petitioner places a document in respect of an inspection taken by the authority on 7 September 2020. After considering the statutory provisions, it is evident that the question whether the authorities acted without jurisdiction in issuing the impugned order, particularly one for stopping the work of the project, will have to be decided on whether the project in question is one or 3 different projects. This is by reason of the fact that the minutes of the 43rd meeting of the state level expert appraisal committee held on 15 June 2022 record that none of the 3 buildings have an area of above 20,000 square meters, which is a part of the notification issued by the Ministry of Environment, Forest and Climate Change dated 14 September 2006. Council are accordingly directed to file short appeal. Now, my lord, this point of my lord, the alternative forum, my lord, was not accepted by the court. No appeal has been preferred from this order of 9th of April. On the contrary, my lord, they have complied with this order by filing an affidavit, my lord, which affidavit was filed by them on 13th of February 2023. My client had also disclosed further documents, my lord, by another affidavit. Thereafter, my lord, a further order was passed on 22nd of February 2023. Counsel for the petitioner proposes that the respondent number 3 be the state level environment impact assessment authority is directed to consider the environmental clearance only for zircon with a total built up area of 18,940.76 square meters as indicated in an inspection report of 14 September 21. Learned counsel for the respondent number 3 on instruction submits that the petitioner number 1 may be given leave to apply for the respondent number 3 in respect of this one having the project detailed and described in the inspection report dated 14 September. The total built up area of 8,940.76 square meters. After hearing counsel for the parties as an interim measure, the respondent number 3 is directed to consider the application of the petitioner number 1 only in respect of zircon as per the inspection report of 14 September for environmental clearance if such application is made by the petitioner within 7 days from now. Now this was done. And then, my lord, an order was passed which is under challenge, my lord, in Can 1. My lord, now I shall give you, lordship, the background. My lord, consider, my lord, a large chunk of land. My lord, a large chunk of land is purchased separately by several corporates. The writ petitioner, my lord, is one of those corporates who has purchased a portion of the land. Now, after purchasing the land, the portion of the land, the petitioner, my lord, approaches the authorities, takes, my lord, all requisite permissions, my lord, fire clearance, height clearance, everything, and then, my lord, obtains a sanction plan for construction of 2 buildings. Totaling to, my lord, that 18,000 and odd square meter.
18,940.
Which is below, my lord, the cutoff is 20,000.
Yes, yes.
The cutoff is 20,000. The other companies, my lord, also make similar possibly applications and they, my lord, obtain, my lord, separate plans. Completely, my lord. There is no, my lord, it's not that, my lord, all the plans are, my lord, are combined plans. Now, my lord, the entire area, my lord, they name as, my lord, Gem City. My lord, on the last occasion, on an earlier occasion, I said, my lord, if, my lord, 10 lawyers purchase, my lord, plots of land contiguous to each other, and, my lord, they obtain plans for separate construction of separate buildings, and name the area, my lord, as Lawyer City, whether it would be, my lord, one project, or it would be, my lord, separate, my lord, projects. Now, I get sanction plan, no objection. I make construction, no objection. When the construction is, my lord, is at the finishing stage, my lord, the pollution board comes in and says, no, all these are one project. And it has to be considered as one project. Now, my lord, plans are different. Now, my lord, when we say that I cannot, James City, my lord, is not a legal body, legal entity. James City cannot apply. And
In whose name the plan was approved? Separately or?
Separately.
Not in the name of.
No.
And the areas are different.
Areas are different.
And they have calculated as one.
Like,
Correct.
This is the total area. This portion is valid petition, writ petition. This portion is valid somebody else. A third portion is somebody else. So I get a plan for this portion only. sanctioned, and my lord, I make my construction. And now they say no, the entire thing is one.
Okay.
Now, my lord, this, my lord, in my submission, such order or this stand taken by, my lord, the pollution control board, my lord, is, my lord, without jurisdiction, they cannot do this.
Yes.
And that is why, my lord, we have come up before, consciously, my lord, we have come up before the court, before this court, challenging, my lord, the decision of, my lord, the pollution control.
So how the gem city has come? How the gem city has come in picture?
The, my lord, the entire area is named as James.
Okay.
Nothing further. I could have understood, my lord, or appreciated, my lord, that one, my lord, plan sanctioned by Jensen. No,
That's what I'm telling. If the gem city is only a namesake.
given of the entire area, right? New town. So, my lord, tomorrow, my lord, somebody comes and says pollution control board comes and says, well, new town is entire area. So
All buildings should go.
you cannot make any construction there. You have to obtain the permission.
Yes.
Now, this is, my lord, the fact. Now,
Yes, what supplement you want to file? What are the documents you now want?
the document is, my lord, area or, my lord, roads have been, or it was not, my lord, initially, that, my lord, roads would be laid, not public roads. Those have been gifted to, my lord, the government, the authorities, to the responding authorities. And they have accepted.
From your recorded plan. It has been surrendered, given to the government for the purpose of the road. Correct.
Now, that is the document. Now, so far as, my lord, Lordship has seen the order of 22nd of February. Now, my lord, specific, my lord, liberty was granted to my client, my lord, to make the application. I make the application. What the authority do is, they again say that it's a entire.
So that order is passed.
Yes.
Where is that order?
Yes, my lord, that is, my lord, Can 1. Kindly come to Can 1.
CR. CR, no?
Yeah. Kindly come to page 63, my lord, directly.
एरी जे तुम्ही
Or, my
ऑल्टरनेटिव्ह
lord, kindly come to page 60. 60.
Yes.
They give a notice of hearing on 27th of February. Sorry, the notice is dated 27th of February. Hearing is fixed on 2nd of March. Notice comes to me, the writ petition.
2nd February. Notice hearing dated 2nd March.
Yes. Now, my lord, I go, my lord, I make my representation, and then, my lord, from the next day, I start typing that give me the minutes. My lord, kindly come to, my lord, page 61 at the bottom. 3rd March, I send a mail. Our company attended the meeting called for hearing of our Zircon project on scheduled date and time. Submitted all our submission in the meeting. We request you to share the minutes. Then, my lord, again on 14th of March, another mail is sent that give me the minutes. Then, my lord, kindly turn the page 24th March, another mail. Then, my lord, a further mail is given, my lord, that is, my lord, on 5th of April. And thereafter, my lord, they inform that they have uploaded the minutes in their website. And that is page 63. The following persons appeared for PP, that is Bhuturia Construction, which is the writ petition. In the hearing. Kindly, next. PP explained the project details which are enumerated as follows.
So your challenge is by way of can, but you have not amended the writ application.
No, because the order, my lord, on the
In terms of the order, it is. So and you want to then you, have you dealt with the can?
No,
My lord?
Have you dealt with the can? No.
No, my lord.
And you let the supplementary affidavit taken on record. You deal with this
Rejoinder to the supplementary affidavit.
supplementary affidavit as well as the affidavit of can. And how soon you will file? If you said then I will fix a date so that matter can be end up.
My lord,
How soon you can file the affidavit?
2 weeks.
So then they will file the reply and you take the supplementary affidavit.
2 weeks, my lord. Everything in a short, my lord. 2 weeks.
2 weeks. then you file the reply. How soon you will file the reply? Within 1 week? 2 weeks.
2 weeks, my lord, because no, they are coming.
They want 2 weeks.
No, not for that. They will be coming up with 2 affidavits, my lord.
Yes, yes.
Correct. Supplementary and
Three affidavits actually. One
Main.
can, one to supplementary, one to rejoin to the supplementary.
No, supplementary can
May I suggest, my lord, may I come back with one single affidavit dealing with all four?
anything.
All four.
Exactly. One is main and one is scan one.
Can.
You do
The
one thing, you
supplementary-
file separately. You file the affidavit in opposition can and affidavit in regard to the supplementary affidavit, and Mr. Mitra will deal with both by in reply. Yes. Learned counsel for the petitioner has has filed supplementary affidavit disclosing certain documents. After having the copy to the learned counsel for the respondent, let the same be kept with the record. The petitioner has also filed
rejoined to the supplementary.
an application being CAN 1 of 2023 challenging order challenging the order dated. What is the order? That impugn order dated CAN 1.
My lord, it's a notice dated 22nd of February.
Order dated. Order.
My lord, it's order dated 2nd March 2020.
2nd March
Order contained in the minutes dated
2025. 2023. 2023.
2nd March
2020. 2nd March 2023. 2023. Police counsel for the respondents prays for time to file affidavit in opposition in connection with CAN 1 of 2023 and the supplementary affidavit filed by the petitioner. That affidavit in opposition of
Supplementary
both
rejoined to
be filed within 2 weeks after serving the copy to the London counsel for the petitioner. Petitioner is given liberty to file replies of both the affidavits if any, within 2 weeks thereafter. And with regard to the main application, an affidavit is completed.
No,
Main-
no, it was
No, no,
without
no.
affidavits. Your Lordship.
That's why I said, my lord, four separate.
The petitioners have also prayed for time to file affidavit, wait for extension of time.
Petition was given long back in the
Date for extension of time to file affidavit in opposition in connection with the writ petition, original writ application with 2264 of 2020. That also 2 weeks.
My lord, 3 weeks in totality.
Counsel for the petition plays for 3 weeks time to file affidavit in opposition to the writ application. That affidavit in opposition is filed within 3 weeks. Reply if any there to be filed within 2 weeks thereafter. List the matter. 5 weeks, no? 1, 2, 3, 4, 5. List the matter on 18th December.
My lord, may I ask for one thing, my lord? Your lordship has passed the order, my lord. Kindly record also that, my lord, maintainability is still, my lord.
That already 22nd February, 9th February order is there.
My lord, with deepest of respect, my 9th February order deals
Correct.
with my maintainability
Correct.
I have raised,
That will
but
continue.
that has been dealt with by the honorable bench.
Correct. That will be done. That's why the court
No,
has
my lord.
passed an order to file the affidavit.
My lord, kindly record also that, my lord, maintainability will be there, my lord.
The point of maintainability raised by the petitioner.
My humble submission was, my lord, that when the order was passed, the point of maintainability was not, my lord, accident.
No, not accident, but affidavit is direction. So it has the point of maintainability decided at the time of final hearing of the
Grateful to
final
lordship.
hearing of the writ application.
Grateful to lordship.
18th December. Because 5 weeks, 3 weeks, 2 weeks, 5 weeks. And on that day you will be all be ready, then I will fix. Otherwise, let it come on the normal way.
We are on the safer side.
On the safer side.
When rejoined the Ratanpur.
I'm sorry, my apologies.
They have taken, my lord, for 4 affidavits, they have taken 3 weeks. I could not have done that. I am incompetent.
Okay, then that come as a normal, then we'll see. If it is completed, then we'll fix.
Juniors are more incompetent than Mr.
Yes, next.
Grateful, Your Lordship.
My lord, before for the private respondent number 4, my lord. My instruction is that, my lord, petitioner number 2, prior to 7 months, my lord, back, my lord, he died. This is my instruction, my lord.
Number 2.
2, my lord. Father and son. Son is the petitioner number 1, and father has died, my lord. Petitioner number 2, my lord. My instruction, my lord. I am.
Yes.
I'm not aware.
You are for the petitioner.
For 1 and 2, father,
So,
my father
whether-
died.
which-
I'm thankful to my land friend. I'm not taking
And-
If
So
he
you,
says so, yes,
you
I-
persons are appearing before the court on behalf of the party and not taking the instruction and appearing.
Not informed us.
And 7 months, no substitution.
7 months. And when the
That's the statutory period is over.
Joshi, even then it is not abated because the main
July 2025 the matter appeared.
Page 31.
So what can be done if the petition number 2 died then?
Not abated because the father
Main is there, but
And the petitioner number 1, my lord, made the representation on behalf of the petitioner number 2. And the case is on behalf of the petitioner number 2, my lord, who has already.
correct.
Page
That's
31 of the
correct.
writ
Unless
petition.
until the record is not clear how the
Kindly fix 2 days after I take instructions come back.
you are appearing for the whom? Respond number?
4, my lord.
Counsel for the respond number 4. Inform this court that the petition number 2 passed away 7 months before. Counsel for the petitioner that he has no instruction and prays for time to take instruction. According cases adjourned, let the matter appear on. How soon? 1 week. Let the matter appear on 20 November under the same heading. 20. कोर्ट मैनेजमेंट में बोल के ना याला जरा बड़ा लग गया देखो गिर जाता याला दूसरा चेंज करो ठीक है नेक्स्ट not today next
I'm for the statement.
who is for the petitioner
I'm for the petitioner in
Last
this matter,
occasion,
Lordship.
petitioner also not.
Lordship, I am for the petitioner in this matter. Yesterday, petitioner informed me that he was appeared before the concerned district magistrate, office of the district magistrate Hooghly, relating to issuance of legal heirship certificate. The concerned office of the district magistrate asked him to submit the necessary documents. So, Lordships, I am praying before your Lordships to kindly give me some time.
Yes.
My client or the petitioner has informed me that the office of the district magistrate informed him submit the necessary documents for issuance of legal heirship certificate. So, Lordships, I am praying before your Lordships some time.
Have you gone through the order dated 4th November?
Yes, Lordship.
Then, what is the prayer you have in the present writ application?
Present writ application relating to issuance of legal heirship certificate.
Legal heir certificate in terms
Yes,
of the
Lord.
application. So,
the concerned district magistrate office informed him submit the necessary documents before.
okay, so I am disposing of this. I am disposing of this, directing the authority to consider the application for if
Page 13, kindly see page 13.
1-3.
1-3.
Yes.
Actually, his 13 and 15, his sister, eldest sister was the 100% nominee. And then next, my lord, after his death, his legal heirs, husband was not there.
Okay, whatever it may be, I am disposing, you pass an order.
My lord, my lord.
If this representation is pending,
My lord.
dispose of and pass an order. Nothing remains here.
My lord.
He's telling that the district magistrate called him. So let the
Oh, no, my
district
lord.
magistrate decide.
Let him decide.
Lordship, leave may be granted to the petitioner for adding the district magistrate, office of the district magistrate, district collector, office of the district magistrate, Hooghly, for incorporate of the parties here.
Where is the P4?
Page 18, Lordship.
Number 3.
P, district magistrate.
RTI application.
No, Lordship, kindly see.
V4,
Yes, P4.
You have prayed for direction, issues legal air certificate. Kindly come to your P4, page number 18.
Yes.
The undersigned is not a public information officer who is liable to provide queries sought under the RTA Act. You are requested to communicate the proper authority to get the information. So,
Kindly see page 22. Page 22. According to RTI received from said husband named Subroto Banerjee, no documents attached of late Tapati Banerjee's ex-sister of MCH Kolkata returned from service on 30th November 2016. Pension cell of MCH Kolkata has searched for the of the marriage register certificate. After verifying the service book, it is found that the surname of Tapati Mukherjee has changed from Mukherjee to Banerjee. Height order number such and such dated 27th December 2002. But no marriage registration certificate has been enclosed. Kindly see, Lordships, page 11.
Page 11?
Yes.
Yes.
Right side, Lordships. Surname change, height order number such and such dated 27th December 2002 from Mukherjee to Banerjee.
Page 11 is your affidavit of the writ petition. Page 11 is your affidavit.
Lordship, page 12. Page 12. Sorry,
Yes,
Lordship,
page 12 is the what you want to show. That is the extension, some sealed or government
yes,
seal.
This is the service book page, Lordships, right side
Correct.
top. Surname change, height order number such and such dated 27th December 2002 from Mukherjee to Banerjee.
Correct.
After marriage with her husband, C. Subroto Banerjee.
Yes.
Issued by the Superintendent Sub-Divisional Hospital, Asansol.
Correct.
So accordingly, after death of my wife, petitioner approached before the authority concerned for issuance of my family pension in favor of me. But there it is seen that in the PPO, there is no family pensions. I have visited the office of the concerned pension sanctioning authority. The authority informed me that collect a legal heirship certificate from the competent officer. That is the district collector, office of the district magistrate. I have approached before the concerned district magistrate. Kindly see page.
Sir, what is your prayer in the writ petition?
Issuance of legal heirship certificate.
Legal heir certificate. Where is your application for grant of legal heir certificate? Where is your representation?
25, page 25.
So you go to the civil court and take the declaration from the court.
No, Lordship.
How the authority will decide you are the husband? Declaration will be granted by the court only.
No,
Civil
Lordship.
court.
The district collector, office of the district magistrate, is the competent authority to issue the legal heirship certificate. Accordingly, petitioner approached before the court, before the office of the district magistrate. This district magistrate has now already transferred the file to the district magistrate.
The petitioner has filed the present application, praying for a direction upon the respondent number 3 for issuance of legal heir certificate. Petitioner says that the petitioner has applied before the district collector, Paschim Bardhaman, on 5th of April 2024 for issuance of the legal heir certificate of the deceased Tapti Mukherjee, within bracket Banerjee, who died on 5th of June 2022. But in spite of receipt of the representation submitted by the petitioner, the authorities have not issued the legal heir certificate, and the representation filed by the petitioner is pending before the concern or before the district collector. Consider the submission made by the counsel for the petition perused the record. This court find that the petition has made a representation to the district collector on 5th of April 2024 for grant of legal heirs for issuance of legal heir certificate upon the death of his wife Tapti Mukherjee within bracket Banerjee, who died on 8/9/9. Thus, the representation is still pending before the authority. In view of the above, the writ petition is disposed of by directing the district collector Paschimi Bardhaman to dispose of the representation filed by the petitioner dated 5th April 2024 after giving an opportunity of hearing to the petitioner within 4 weeks from the date of receipt of the account. The appropriate concession is
Grateful.
Yes, next.
Item number 13, I beg to appear on behalf of the state, my lord. Your lordship, kindly see the last order dated 4th of November 2025. On that very day, I do appear, and my learned friends, junior, took time. But unfortunately, my name has not been incorporated in the order.
You might not been given the cheat.
I have given the cheat, my lord. I was there, but some other's name has been given. Some other advocate's name has been given.
Because I am not familiar to name. I can be familiar with the face. That's why I am not recording the name.
let us.
I have handed it up to the officer concerned who are there.
Let us resolve this dispute today. Take up the matter tomorrow. I need to sit with my juniors. I don't have a very good case, I tell you, lordships. But I just want to find out something. Allow me to come back tomorrow. I need 1 day's time.
What is the matter?
Not matter concerning a license to be granted by the forest authority for running a sawmill. But I tell you, lordships, I have found out some points for your lordships kind consideration. But I just need a day's time. But the last order says, my lord has deprecated my junior, so I am very afraid of asking for a day's accommodation. If my lord allows me to come back tomorrow, I can assist your lordships.
Yes, what is your name?
My name is Tarak Karan.
Tarak?
Karan, K-R-A-N, Karan.
So let's come tomorrow?
Yes, Kalke. Ajay, tomar naam ta
Concept here for the state.
Yes, my lord. I'm led by learned AGP, Mr. Ashish Kuhoman.
Counsel for the state submit that on 4th of November 2025, he has appeared in the matter. But in the cost title of the order dated 4th November 2025, the name of another advocate, Mr. Tushar Sinha Mahapatra, is recorded. Accordingly, in the order dated 4/11/2025, name of Mr. Consequential is recorded appearing on behalf of the state. As per the prayer made by the counsel for the petition, when you will be ready?
By tomorrow, my lord.
Let the matter appear tomorrow under the same heading.
It will, my lord, it will appear the same position, I believe. I'm so grateful to you.
Yes, yes. Thank you.
Extremely ready today. You want to open my case?
Yes.
This is second round. May I just give a brief overview, before looking into the papers? My account, was classified as fraud, under the master direction of 2016, behind my back. No notice, no show cause notice was given, no hearing was given. That, I came to know, subsequently through other sources, I challenged. And, that classification was set aside by the single bench. And also, all consequential steps were set aside. There were penal consequences like registration of FIR, etc. They preferred an appeal. Now, even though, an intra-court appeal is not maintainable because these writ petitions are usually criminal in nature. So, they should have gone to the Supreme Court. But nevertheless, it was entertained, and a portion where consequential steps were set aside, directed to be set aside, that was revoked. But the division bench said that fraud classification is set aside, but the bank will, if they so desire, in accordance with law, they can again do the proceeding afresh. So, fraud classification set aside. Now what they have done, my lord, is they, my lord, issue a show cause notice to me suddenly. The show cause notice, my lord, is.
Who are you?
I am, my lord, an ex-director. All the events, my lord, that are being complained of, my lord, I was not a director then. I have specifically written that in my reply. The show cause notice was issued to me, my lord, and the company, which is also now under liquidation. Settlement talks were also going on. I have given them 10% my lord, money to consider my OTS. They are asking for documents, etc. My lord, that is going on. Despite that, my lord, they issue a show cause notice saying that I am issuing the show cause notice on the basis of the allegations made in my lord, a forensic audit report. This audit report, my lord, was prepared in the NCLT proceeding. So just copy pasted, my lord, those allegations and saying that consequent to your fraud declaration, my lord, I am issuing this notice, so please reply. Two things, my lord, I will show. Kindly, my lord, now take that show cause notice. They proceed on the basis as if, my lord, the classification is still there. Kindly, my lord, quickly I'll show the single bench order, page 85, if your lordship takes, my lord, of the second volume. That's the operative portion I am relying on. Last part, my lord, accordingly, WPA such and such is allowed on contest, thereby setting aside the classification of the petitioner and the company, namely Swati Mining, as fraud as per Master Director. And the next page, my lord, the consequential actions, my lord, were directed to be set aside. Now, the appeal court order, my lord, kindly takes page 93, just the operative portion. Para 14. In the result, the appeal is allowed in part and while sustaining the order passed by the learned court, setting aside the classification of the petitioner and the company as fraud, liberty is granted to the appellant bank to proceed afresh in accordance with law. My lord, two things from here which emanates is that, my lord, one, there is no classification, my lord, against me as on date as a fraud person. Two, my lord, if they have to do again, it has to be afresh in terms of the master direction. Now, my lord, kindly see, my lord, the nature of their show cause notice. That, my lord, your lordship will find at page 142 of the third volume. I have annexed the master direction. I'll show. 144. Kindly, my lord, takes 144. Now, this is also, my lord, under the earlier master direction. There was subsequently, my lord, July 24, a different direction had come. Sir, we are not on that. Kindly see, my lord, the subject. Show cause notice seeking your submission on re-examination of your account consequent to classification of fraud. So, fraud classification is there. They are not saying that I have removed your classification. Now, at the request of, this is very important, my lord, the first paragraph. At the request of Swati Mining to our Ranchi branch, bank has granted certain credit facilities to Swati Mining Private Limited for the express purpose mentioned in the loan application proposal. At the request of Swati Mining, such and such was granted. Then, the account was turned NPA on 2019 with outstanding of 6.61 crores as on 31st Jan 2024. Para 2. As per extant guidelines, forensic audit of the borrower's account has been conducted by Messrs. B. Singhi and Associates, and forensic audit report dated 18 March 2020 has been submitted by the auditor to our bank. The observations, findings, conclusions of the forensic audit were placed before the competent authority of our bank, who felt that there was suspected fraudulent connotation in the account, and accordingly the account was classified as fraud by our bank. The gist of the observations or findings or conclusions which were taken into consideration for classification of the account as fraud are as follows. Now, my lord, these observations which are tabulated here, these are, my lord, kindly note observations of the forensic auditors. I'll show, my lord, Ultimately, the order which was passed, my lord, in breach of the principles of natural justice, the same thing is reproduced in the order. No application of mine, no reason for it. So these are all, my lord, forensic auditors' observations, my lord, I was called upon to address. Page 150, my lord, para 3. Now, in order to re-examine the matter, you are advised to provide your written submission, if any, on the above observations and so cause within 15 days of receipt of this communication for re-examining the account. Kindly note this, my lord, which has been classified as fraud. My lord, what sort of justice, my lord, I ask myself, I am going to get from the authorities, where a show cause notice itself is saying, my lord, that your account is already classified. If your reply is not received by us within 15 days of receipt of this communication, it shall be presumed that you do not have any say in the matter, or if your written submission is not satisfactory, bank shall proceed, etc. Then please note, notice is not being issued to Swati Mining as it has already been liquidated and dissolved by Honorable NCLT Kolkata bench. Now, Lord, this is my reply at page 151. I'll just take to the relevant portion. At page 153, my lord, third paragraph, I ask for a copy of the forensic audit report. My lord, irrespective of the fact, my lord, if I have it, I don't have it, my lord, it is the duty of the bank, my lord, to provide a copy. I have judged. Kindly see, my lord, third paragraph. Moreover, your show cause notice is bad and contrary to law inasmuch as you have not supplied a copy of the forensic audit report dated 18 March 2020, on the basis of which you have allegedly re-examined the account. You have also not stated before which competent authority such report was placed or who felt that suspected fraudulent connotation in the account, on the basis of which the account was classified as fraud, and the date of such classification as mentioned in paragraph 2 of your letter. Unless you provide copy of such details, I am unable to provide any further details. In any case, the company is in liquidation. Then I do not have any relevant document necessary to reply to the show cause notice. Please also note that as an ex-director or promoter of the company, I am next. Moreover, the classification of the company's account as fraud was set aside by an order of 18 July 2023. In the event the bank wishes to re-examine the notices have to be issued to the company and an opportunity of hearing must be given to the company which was the borrower. So, my lord, I also say that first, no FAR and personal hearing. You must give a personal hearing. And account is, my lord, account was of the company. Company liquidation. You are not calling, my lord, in this process the liquidator or, my lord, whoever was the RP to ascertain what were the activities. Suddenly, my lord, lifting something from the forensic audit report, my lord, you can't do this. And here in this letter, I've also said, my lord, at that relevant time, I was not a director. Kindly see, my lord, page 152.
152.
Yes, just the previous page, 152, my lord. I say that there is no scope or any provision of law which permits re-examination of an account of a company which is under liquidation. Moreover, I have not been a director of the company since 14 November 2018 and have no connection with the company under liquidation, which is under liquidation. Now, my lord, if your lordship sees, my lord, all these allegations which they are saying, my lord, is of a period, my lord, I was not there. Now, my lord, kindly see what they do. No personal hearing given, no FAR, my lord, handed over receipt. Straight away, my lord, passes an order. Page 156.
Yes.
I will show, my lord, that this is not really an order. This is a communication. No order has been served. Oh, and now, my lord, kindly see the names to the person's address. Number 1, notice number 1, my lord, is the company. If your lordship recalls, my lord, no show cause notice was issued to the company. Number 2, my lord, Somrat Chakraborty, he is the director, no show cause notice was issued to him also. 3, no show cause notice was issued. 4, this is the only person, that's me, my lord. The order which is issued now, I have received the show cause. But see the procedural lapses, my lord, I want to show. Show cause notices being issued to a set of persons, orders being issued to a different set of persons. Now, my lord, the order. Swati Mining Borrower Company, such and such. Registration, following persons were promoters. Page 157, my lord, kindly come to the 5th paragraph.
Yes.
The findings of the forensic audit or internal investigation were placed before the competent authority. Now, my lord, no details of that provided. The competent authority, after perusal of the forensic audit or internal investigation, has felt that there are suspected fraudulent connotations in view of the following observations, finding conclusion of the FAR. Finally turns over the page, my lord. This is the same, my lord, table lifted from the show cause notice, my lord, which is my lord given here. Just the paragraph is different. There it was 1, 2, 3, 4. Here it is ABC.
Correct.
Same thing. Now, kindly see, my lord, page 162, para 6. The competent authority has felt that the borrower or notices has to be given a chance to make their submissions in the interest of justice, consequent to which show cause notice was issued to the notices. This is also incorrect. It was not issued to everybody. Herein seeking their written submission on the findings of the forensic audit report. The show cause notice was served on the notices on 28th February 2024, detailing therein the observations, finding, etc. Pursuant to the receipt of the written submission of the notices, no written submission is received within 15 days of issuance of show cause notice. The fraud monitoring group of the bank has carefully examined the forensic audit report or internal investigation report, written submission of the notices, non-receipt of written submission, etc. The FMG has come to the conclusion based on the above findings. The account of Swati Mining is fit to be classified as fraud. First, they say company is in liquidation, notice is not being issued to the company, no requirement. Now here they say I am declaring the account as fraud of the company. And my lord, next, the above indicates clear diversion or siphoning of funds and utilizing the funds for purposes other than for which it was granted, causing wrongful loss to the bank and gain to the notice with the intention to defraud the creditor. Committee also finds noticee numbers 2 to 4 by promoters, directors, etc. at the time when the transaction took place and cannot be without their consent and connivance. In light of the above facts and after providing above opportunity to the notices to make their submission, bank has decided to classify the account of Swati Mining as fraud. Again, my lord, liquidated companies account being fraud. Accordingly, the bank shall report the same before the various authorities, including filing of complaint before the law enforcement agency. The above order shall come with immediate effect. My lord, kindly, my lord, pause here. I'll show the master circular, my lord. Here, the paragraph that they say, the fraud monitoring group, my lord, has classified the account as fraud, my lord. The master circular says there is a process. First, my lord, there will be a fraud monitoring group, which will identify, my lord, some warning signals, whether there is fraudulent activity or not. Then, my lord, they will declare that this is a red flag account. They will have to inform me. NPA, my lord, your lordship notes, my lord, notice have to be given. The red flag account, my lord, also has to be given to me. Then, this fraud monitoring group, my lord, will report it to the CMD or CO because, my lord, there is huge consequences. I'm a borrower. I have gone to the bank. If I've done something wrong, of course, declare me fraud. But not incorrectly, not without due process of law. Because then, my lord, CBI is triggered. I will not be able to take any loan from other banks for 5 years. So, my lord, may I, my lord, show now that the process is wrong? They were required to, first of all, my lord, give a reason hearing. Kindly, my lord, takes Rajesh Agarwal. Rajesh Agarwal. State of West Bengal versus Rajesh. This, my lord, interprets the master direction. I have the master direction, my lord, I've annexed it. Finally, my lord, so straight away, for the for Milord the point that they must file, Milord, they must issue a reasoned order. May I, Milord, take your lordship to para 94. Before concluding, we also want to address the argument by the borrowers that the requirement of passing a reasoned order must be read into the master directions on frauds. The borrowers also relied on jar developers, wherein it was held that a final decision of the review committee declaring the borrower as willful defaulter must be made by a reasoned order. We agree with this contention of the borrowers because a reasoned order allows an aggrieved party to demonstrate that the reasons which persuaded the authority to pass an adverse order against the interest of the aggrieved party are extraneous or perverse, and the obligation to record reasons acts as a check on the arbitrary exercise of the powers. The reasons to be recorded need not be placed on the same pedestal as that of a judgment of a court. The reasons may be brief, but they must comport with fairness by indicating a due application of mind. In light of the legal position above, we hold that the rules of audio alternate patent ought to be read into the master directions on fraud. Consistent with the principles of natural justice, the lender bank should provide an opportunity for banks to the borrower by furnishing a copy of the audit reports. Kindly see, my lord, this is a duty cast upon them to do it without any qualification. And allow the borrower a reasonable opportunity to submit a representation before classifying the account as fraud. So the audit report in my case, my lord, was never given. A reasoned order has to be issued on the objections addressed by the borrower. Now, I have given a written objection where there is no reflection in the order of the objections, my lord, that I have put in. On perusal of the facts, it is indubitable that the lender banks did not provide an opportunity of hearing to the borrowers before classifying their accounts as fraud. Therefore, the impugned decision to classify the borrower account as fraud is vitiated by failure to observe the rule of audio alternate patent. In the present batch of appeals, this court passed an ad interim order restraining the bank from taking any precipitate action against the borrowers for the time being. In pursuance of our aforesaid reasoning, we hold the decision of the bank to classify the account as fraud is violative of the principles of natural justice, etc. And then fresh steps to be taken in accordance with. Now, my lord also takes 98.61. The principles of natural justice demand that the borrowers must be served a notice, given an opportunity to explain the conclusions of the forensic audit report. Now, today, if they don't serve me the report, my lord, there cannot be an expectation that I will reply to that. And be allowed to represent to the banks or JLF before their account is classified as fraud under the master direction. In addition, the decision classifying the account as fraud must be by a reasoned order. May I just let us just quickly go back to that order. Kindly see, my lord, this document. I ask myself, my lord, does this document, my lord, have any of the trappings of a reasoned order or any order which is passed by any authority or committee? Kindly see, my lord, who has signed this list? For and on behalf of Bank of India, Deputy Zonal Manager Recovery. A recovery officer, my lord, is signing this.
Which page? Which page?
Page 163 of the third volume.
Last order.
Third volume.
Deputy General Manager Recovery.
Yes. And the same person has also issued the show cause notice. Kindly, my lord, takes the show cause notice 142. I'm not mistaken. Yes. Now, my lord, this principle, my lord, I am not citing any judgment. Your lordship knows, my lord, a person cannot, my lord, judge his own cause. Page 150.
Yes.
150 show cause notice issued by, my lord, the Deputy Zonal Manager Recovery, who is saying give reasons. He is the same person who has apparently, my lord, adjudicated and, my lord, is issuing this. Same person.
Who is the authority to decide?
Now that, my lord, your lordship sees, my lord, the master direction. Page 107. It starts at 107. Kindly takes Millard first, clause 4.4. Page 117.
Yes.
Now these directions also, Millard, are very vague. That is why we need court's involvement. And Millard, your lordship will see various provisions need to be looked into, Millard, to finally come to a final. 4.4.1, Millard, 117. While the audit committee of the board shall monitor all the cases of frauds in general, banks are required to constitute a special committee of the board for monitoring and following up of cases of frauds involving amounts of 10 million and above exclusively. The special committee is to be constituted with 5 members. The board of directors consisting of MD and CEO in case of public sector banks and MD in case of SBI and private sector banks. 2 members from the audit committee of the board, ACB, and 2 other members of the board excluding RBI nominee. The periodicity of the meetings of the special committee may be decided according to the number of cases involved. In addition, the committee will meet for these reviews. Now, also, Millard, what is relevant is clause 8.3. So, Millard, one has to, Millard, understand that a special committee will do this sort of business, passing an order. It does not specify, Millard, who will. 8.3.6, Millard, if your lordship takes. They say, Millard, FMG, if your lordship, because Millard, para 2 of the order, FMG has come to the conclusion. Now, kindly see 8.3.6. What is FMG supposed to do? The FMG or any such designated committee shall classify the account as RFA, red flag account, and the details of RFA accounts shall be put to the CMD or CEO every month. So, FMG's jurisdiction, Millard, is not to classify an account as fraud. He will, Millard, he is at the first stage. You declare RFA, then the committee will do. Then a report on the RFA accounts shall be put up to the special committee of the board for monitoring and follow-up of frauds, providing inter alia a synopsis of remedial action together with their current status. So, remedy or classification, I would say, Millard, this current status would be
Place before the committee.
the classification part. This is, Millard, how, Millard, I see it. Otherwise, Millard, it is not very clear. Now, 2 other clauses, Millard, I want to show. 125. The 8.2, Millard, is the objective of this. What is the objective, Millard? Is the objective of the framework is to direct the focus of the banks on the aspects relating to prevention, early detection, from reporting to the RBI. Now, when, Millard, can this be done? Only when the loan cycle, Millard, is active. This is my submission, Millard. There are no judgments on this. And I say that, Millard, on the basis of the last 5 lines of that clause. The timelines or stage-wise actions in the loan life cycle are expected to compress the total time taken by a bank to identify a fraud and aid more effective action by the law enforcement agencies. Early detection of fraud is necessary. So, what is important, Millard? It has to be within the loan cycle. Millard, it cannot be at a time when the company, Millard, has gone into liquidation. It is really, Millard, a post-mortem, Millard, what they are doing now. Kindly see page clause 8.4 at page 127. These states, Millard, they must take and come to a finding.
8.4.
8.4.2.
Yes.
The most effective way of preventing frauds in loan accounts is for banks to have a robust appraisal and an effective credit monitoring mechanism during the entire life cycle of the loan account. Any weakness that may have escaped attention at the appraisal stage can often be mitigated in case the post-disbursement monitoring remains effective. In order to strengthen the monitoring process based on analysis of the collective experience of the bank, etc., during the different stages of the loan cycle should be carried out. So many times, my lord, this phrase is used. At a pre-sanction stage, my lord, this exercise can be done. Disbursement stage, my lord, this can be done. And my lord, when annual review. But when the company is dead, my lord, the only intention now is to, my lord, harass the directors or ex-directors and nothing else. Kindly now see, my lord, the procedure at 129, my lord, in the event it is a bank is a sole lender. 8.8.1.
Yes.
In cases where the bank is a sole lender, the fraud monitoring group will take a call on whether an account in which early warning signals are observed. This is only can happen, my lord, in the loan cycle.
Yes.
Should be classified as red flagged account or not. This exercise should be completed as soon as possible and in any case within a month of the early warning signal being noticed. So, time is the essence of this circular.
Yes.
In case the account is classified as red flagged account, the fraud monitoring group will stipulate the nature and level of further investigations or remedial measures necessary to protect the bank's interest within a stipulated time, which cannot exceed 6 months. Again, time. The bank may use external auditors, including forensic experts or an internal team for investigation before taking a final view on the red flag account. Even now may not know fraud classification. And this forensic expert, this external auditor is all while the account is live. The report which they are relying on, Milord, is during liquidation proceedings which was Milord prepared. At the end of this timeline, which cannot be more than 6 months, bank should either lift the RFS status or classify the account as fraud. So, Milord, two things. First, you have to say that my account is a red flag account. And if within 6 months, Milord, I have not behaved myself and I have continued to be fraudulent, then I am not entitled to any warning. You straight away then say that you are fraud. But any person, Milord, that first warning is entitled to. Before you hang me, you must tell me what is my fault. But here, the bank straight away says you are fraud and you are entitled to now liable to suffer all consequences, Milord, without any warning. Now, Milord, the other point, Milord, is the show cause notice and the order, Milord, cannot be a reproduction of the forensic audit report. There is judgment because it says that is, Milord, a mere piece of evidence with disclaimers. I'll show Prashant both. Prashant Bothra versus 2023 SEC online, Cal 264.
SEC online, Cal
2643. Kindly takes Milord para 21 and 22. The very premise of the request was a forensic audit report allegedly authored by a particular concern. The said report at best, has your lordship got that?
Yes, yes.
Para 21. Said report at best is a piece of evidence in the liquidation proceeding and is in no manner conclusive proof of evidence of any illegality committed by any entity. In fact, it is common experience that each and every such forensic audit report contains several disclaimers restricting the operation of the same to the proceeding in which they are filed, as well as confined to the impression of the authors thereof on the basis of the documents which are available to them. Under no stretch of imagination can such a report be conclusive proof of the allegation against the petitioner. So here, my lord, This is clear, my lord, that this forensic audit cannot be the basis of. And my lord, I have.
Yes.
Your lordship takes. This company, my lord, 2-3 orders. The CI company, my lord, went into CIRP on 8 July 2019. The order, my lord, is 24 to 48. Then, my lord, liquidation order was also passed, my lord, on 22nd January 2021. That order is at page 49. My lord will get that in the intake.
Yes.
And the show cause notice, obviously, my lord, is February 2024, which is much later.
No, this order, page 49, what is the order dated?
22nd January 2021. Oh, sorry, 8 July 2019, page 48.
Page 40? 49. Page 49 order starts with regard to NCLT.
Yes, that is the liquidation order.
Correct.
22nd January 2021.
21.
21. And now, my lord, even this FAR, my lord, if they produce a copy of this, my lord, has a lot of disclaimers. I have not annexed that because I didn't have a copy of that.
Yeah, for the audit report.
Now, my lord,
তুই বলে তুই পাওনি
লাগাই দিব।
পাওনি বলছো
তাই তো।
হাতে আছে তো
Now, my lord, I'm sure I got it, but now, my lord, there is one judgment of our High Court where, my lord, this procedure is given. This is on hearing. Hemant Kanoria versus Bank of India.
What is the stage of the insolvency proceeding?
Liquidation and, my lord, dissolution. And they are admitting that this is the case. Kindly takes para 64 to 68.
citation both
2024 SCC Online Cal 101.
1-2.
Yes.
First, a show cause notice is to be issued enumerating the exact offences alleged against the borrower director. If any forensic audit report or other document forms the basis of the show cause, the same is to be served along with the show cause notice. Both the set criteria have in fact been satisfied in the present case in respect. In that case, my lord, it was satisfied. But, my lord, I am showing what has to be done. Then, a fortnight thereafter would be ample time to give reply to the show cause notice. In its reply, the noticee shall, apart from addressing the allegations and controverting those specifically, specify the documents which are required to be provided to the noticee by the banks or financial institutions. If necessary, in the reply, the borrower or director or promoter can reserve its right to give further additional reply upon receiving such documents. Here I have done that. You give me my FAR. Within a week from receiving such reply, the banks can give an inspection of the documents if extremely voluminous or furnish copies of the particular documents which are sought for by the borrower. Within a further fortnight, if necessary, the noticee or borrower can be given an opportunity to file additional reply in the light of the documents which have by now been inspected or served on them. Thereafter, a hearing shall be given by the bank on the basis of the reply. So this contemplates a personal hearing.
Yes.
Upon such hearing being concluded, a decision shall be taken whether or not to declare the borrower, company, or its director or promoter as fraud or perpetrator of fraud. The aforesaid procedure would take at the most 8 weeks in total to be concluded, which would be sufficient compliance of the master directions. Thereafter, If declared as fraud, perpetrator of fraud, the same can be intimated by the bank, the RBI. The very first step has been complied with.
That is that case.
So, my lord, this is there, and my lord, the master circular. Why, my lord, this is very important is because there are penal consequences. My lord, that is that clause 8.12 at page 134. There are, my lord, extreme consequences which I will face. So, this sort of thing cannot be done lightly.
Your question is that they have not followed the procedure. No opportunity given.
Which is why, my lord, I have come before your lordship and I have given a written representation where I have asked for certain documents. I have asked for personal hearing, not given. And the authority who is now saying that they have passed an order is not the correct authority. And this is not a reasoned order. This is only, my lord, reproduction of the forensic auditor's views, tabulated. My lord, those are my submissions now.
Yes.
That I will file my opposition, my lord, because certain documents have been suppressed. Particularly, my lord, the document by which, my lord, the forensic audit report was in fact given to my learned friend's client, and despite receipt, they chose not to respond to the.
When it was supplied.
After the reply to the show cause, where they asked for a copy, a letter was given by the bank forwarding a copy of the forensic audit report. That apart, my lord, there are various points my learned friend has taken, my lord. But may I just summarize, my lord, if my lord is hearing me on the interim order, my lord. But may I just respond? The first point my little friend takes is that the company itself is in liquidation. So therefore, the actions against the directors could not have been taken. But that's perhaps is not the correct position of law. But it's the directors only, the promoter director, who have committed fraud. And they have to be proceeded with, my lord. Apart from the fact that a criminal proceeding has been initiated, a CBI investigation is going on, which was initially, my lord, by the order of the single bench was virtually quashed. My lord, I wanted to show that portion of the order of the division bench where, my lord, the investigation, the entire purpose today is to stall the investigation, the CBI invest. That's perhaps the hidden agenda behind this writ petition, my lord. May I just show, my lord, the portions of the division bench's order where, my lord, the court allowed my appeal in part, where, my lord, the order of classification of fraud was set aside not on merits. It was only done on the ground that no notice of hearing was given. Subsequently, Rajesh, judgment, the Supreme Court has also had that the right of audience has to be read into the circular. So therefore, there's a revised circular which now gives. Earlier it was not there, but the court read into this and directed the bank to start afresh. The single bench, had also directed that the investigation would be undone. To this, the Honorable Division Bench, kindly comes to page 90 of the judgment, Paragraph 7, Division Bench's order,
Yes.
In page 8 of the impugned order, the learned writ court has directed the appellant bank to take immediate steps for reversal of the impugned action by intimating the concerned authorities, including investigating agencies concerned. The gist of the order passed by the court to enable such agencies to declassify the writ petitioner as well as the company as fraud. Advocate for the petition appearing for the respondent writ petitioner seeks to sustain this order and direction passed by the learned single bench, and to support her contention relied and placed upon the decisions of so and so, the three judgments are cited. In Kapil Agarwal, the Honorable Supreme Court was satisfied that criminal proceedings amount to abuse of the process of law, and it amounted to bringing pressure upon the accused in exercise of inherent powers of the Honorable Supreme Court quash the criminal proceedings. To be noted that the said decision arose out of criminal miscellaneous writ petition filed by the writ petitioner before the Allahabad High Court in facts and circumstances. The court has recorded that it is satisfied that there has been abuse of process of law and exercising the inherent in the course caused the proceeding. We find the decision distinguishable on facts. In Uday Desai, the court clarified that the order will not preclude the consortium of bank or any bank from independently taking actions in accordance with law after affording an opportunity of being heard to the appellant therein. And then, my lord, eventually the investigation was in fact not disturbed. The bank was given an opportunity to restart the proceeding. this liberty was granted. Now today, my lord, if I summarize my learned friend's arguments, my lord, the first point that my learned friend takes is that the bank in its show cause notice has already proceeded as if it was a classified. Perhaps that's not correct reading of the letter, because the bank in the show cause notice, my lord, will see, has given about 25 instances of commission of fraud. These are the incidents which comprise of fraud so far the bank is concerned. The bank called upon them to reply. But these are the specific allegations made against you. These are the things that we have found against you. You reply. Now, if the reply to the show cause is seen, my lord, all technical objections were taken, which I'll deal. Not a single word dealing with the allegations of fraud. No reply.
But how you can say in the so-called reply, so-called notice that classified as a fraud?
Perhaps that was not correctly worded. But my lord, kindly sees the essence of the notice. The essence of the notice is that in a show cause notice, the bank is supposed to give the borrower to explain circumstances. In this case,
but you come to the conclusion.
But the real finding is the last order. The real
Finally, come to the page 150, paragraph 3.
Yes, my lord.
Page 150, paragraph. Now, in order to re-examine
the matter, you are advised to provide the written submissions, if any, on the observations and show cause within 15 days of receipt of this communication for re-examination of the account, which has been classified. But here, the account has to be first identified, and then the exercise of classification is done.
You can identify it in the so-called. Why this should not be classified as a fraud? Why in the so-called notice? How you can say has been classified?
Yes, my lord. If my lord kindly visualizes this, I bow down. The expression used perhaps is not absolutely correct, but my lord, no pursuant to this show cause notice, no actions were taken. The consequence of classifying a fraud account, there are those have happened subsequently. So on this notice, they have, although the expression says it has been classified, but perhaps, my lord, this was only identified, and they were called upon to give this explanation as to why it should not be formally classified and actions will be taken thereafter, because they did not challenge this order when the notice was sent to them. They replied.
Correct.
And now they have come against the final order where the classification really happened, my lord, which is the order impugned, my lord. So I bow down, my lord. The expression could have been, my lord, identified, but you reply. So this, my lord, can, my lord, read down, if I may say, the expression classified as fraud. It should have been identified as fraud, and you explain the circumstances, my lord, yes, in my respectful submission. And therefore, my lord will also appreciate the first sentence, which says re-examination. So they were all ready to re-examine everything.
That's correct.
Provided there is any response.
First two lines.
Yes, my lord.
Two line is no problem. Only with regard to that word
Also
has been classified.
I bow down, my lord. Yes, my lord. Also, the last line also clarifies.
Submission is not satisfied.
Shall proceed ahead in the matter of classifying the account as fraud. So if you don't do, then the bank will proceed.
So
and
now
then
the notice were issued to whom?
This notice was issued to the promoters and the directors, my lord, because the company by this time had already gone into liquidation. So, my lord, now these are the persons who had to be proceeded with, my lord, because the consequence of a fraud directly, my lord, has to be faced by the persons who were involved in fraud. And these are the persons who are involved, who have committed fraud upon the bank. So therefore, and this loan was taken in 2015-16, my lord. This person has resigned after committing the acts of fraud in 2018, November. So I'll come to that, my lord. So these are the addressee persons who had, in fact, who were the promoter directors of the company in question, my lord. And the company, in the last paragraph of the notice, the bank notes, my lord, please note that this notice is not being issued to Swati Mining Private Limited, as it has already been liquidated and dissolved by the. So there's a non-entity, my lord. So could not have been given. Now, my lord, kindly, my lord, takes the reply to the show cause. The reply, my lord friend, has placed. The first technical point taken was there's no reply on merit. The first technical point taken is that how can you proceed in case of a company which is already into liquidation? Because the simple answer is it's not only against the company in liquidation, it is also against the company and its promoters, because it's a case of fraud. It's not a case of willful default. It's not a case of recovery of money. It's a case of classification of fraud. So therefore, merely because the company has gone into liquidation does not mean that the bank cannot proceed against the directors. But this objection perhaps was not. Now, the second point taken was, since the account does not exist anymore, you can't declare it. But may I come back? I have a matter fixed at 2 p.m. I can come at 3 or I can come tomorrow, whatever says.
2 p.m. one matter is there.
Yeah.
After finishing?
Yes, I'll come back.
Today only.
Pass.
May I come back tomorrow, because I may. No, it's a 2024 writ petition, 23 rather. I can, or I shall come back. I shall come back.
See, if time permit, I will.
Yes, because I might be get engaged in other court immediately after that also. That's why after committing, I don't want to.
Come tomorrow.
I'll come tomorrow morning. I shall not take more than half an hour.
As a first matter, I will take.
Yes, I'll come in the morning.
Counsel for the. Okay. Counsel for the petitioner has concluded his argument in connection with the interim order. Counsel for the respondent has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at the top under the heading adjourn motion. No, I'm not adjourn, under the heading urgent motion.
So let them not take any steps in the meeting.
Tomorrow, nothing.
I'm deeply obliged.
That's what I thought. And I think I was correct because
Section 4,
that was the problem.
Section 4 is there designated.
That is why, Malad, I thought that every court can be designated. That is not a problem. But it has to be first
It has to be
designated.
designated. So it has clarified that.
Then at least I have 1 point off my shoulder.
Yes, call the matter. Yes, call the matter.
Malad, may I tender my apology when I could not be there in the morning? I'm sorry, Malad. Malad,
Who is
as
the
your lordship
respondent?
is
You are
My lord, I am for the respondent, my lord.
tender matter, Malad. But I know that restricted now judicial review, Malad. But I'll take your lordship through a very small point, Malad, which I need to show your lordship. Malad, straight away, Malad, if your lordship comes to the clause. Malad, this is a tender for the underground transformer supplies, Malad. Now, Malad, what I found out, and I think it's an admit position, the L1 is now who's the L1, Malad. And my quotation was below the L1 by 2 crores. But I obviously could not reach the L1 stage because they are saying I'm not technically compliant. Now, Malad will kindly come to page, Malad, 45. 3 onwards, Malad. It's volume 1, Malad.
Yes.
Malad, 1.4.
Malad,
I will just give a short background as to who is the bidder. Now, the bidder is a consortium. Now, consortium consists of 2 companies. One is by the name of Shinjili, but it is not too important. The other one is more important. The other one is Universal, the lead bidder. Now, Malad, Universal is a company which is formed under a scheme under section 366 of the Companies Act, where, Malad, partnership firms can also be converted into companies, Malad. So this company has become a company only this year. So obviously, Malad, it does not have financials for 3 years or back. On that background, Malad will kindly now see the clause. The clause says EPC contractor bidders, both as sole or consortium, a maximum of 2 members, should fulfill the technical and financial eligibility requirements. Both as sole or consortium should fulfill these eligibility criteria. Now, first thing, Malad will kindly see the technical eligibility criteria. The bidder should fulfill the following technical eligibility criteria. Bidder should have experience of design, engineering, supply, manufacture, erection, and commission of similar work in India or overseas during last 7 years, ending last date of month prior to the month of issue of this NIT. Under operation satisfactory for a minimum period of 12 months after commissioning. But I have not been found disqualified under this, though the lead bidder was a company only for 1 year. I have not been found technically not eligible. What the tendering authority has held, Malad, kindly now comes to Malad, only kindly comes to page 44, Malad. If your lordship kindly see a note. The notes, Malad, if your lordship finds. D, Malad, in case the bidder is consortium, one or more of the consortium members, maximum 2 consortium partners, including lead members, are permitted, can either individually or together fulfill the criteria as per above. So now they say that anyone is entitled.
Correct.
Now kindly see, Malad, the next clause, that is financial eligibility criteria.
Yes.
The average annual turnover, Malad, that is too technical, Malad. It talks about a figure, Malad. I'm not on that, Malad. I fulfill that, but, Malad, what has happened? Kindly takes page 45, Malad. After turnover calculations, my lord, kindly see 2. The net worth of the bidder. Your lordship has got that, my lord. This is where the dispute. The net worth of the bidder, sole bidder, or all the members of the consortium, in case of consortium, should not be negative. This is the first criteria. As per the immediate preceding years audited financial results, and should not have eroded by more than 30% in the last 3 immediate preceding financial years. Now, my lord, kindly appreciates, for the purpose of the two parts of it. One is that shouldn't be negative in the preceding year. Other is 30% erosion in the last 3 immediate preceding financial years. My lord, kindly appreciates this company does not have 3 financial preceding years. But my lord, there is no bar on a new company, my lord, bidding for this this tender. Now, my lord, kindly sees the definition of net worth.
No, net worth of the bidder, solar consortium
should not be negative.
Negative.
One is that as per the immediate preceding year's audited financial result.
Correct.
So 1 year back, it shouldn't be negative.
Correct.
And second is, should not have eroded.
Correct.
Erosion. We're talking about erosion by more than 30% in the last 3 immediate preceding financial years.
Till 25 years.
Starts from 2022.
Correct.
When, my lord, this company was not existent, it was a partnership firm. It's a partnership firm.
Correct.
So, my lord, the intention or the requirement is to show that I was financially stable. Financially, I was stable. Now, my lord, kindly sees what is the meaning of net worth. Net worth means the aggregate value of the paid up share capital. So, my lord, first, a partnership firm will not have a paid up share capital. Now, in their definition only, they do not provide for anything else but for a company. Now, kindly sees aggregate value of the paid up share capital and all reserves created of the profits, securities, premium account, and debit or and debit or credit balance of profit and loss account after deducting the aggregate value of the accumulated losses, deferred expenditure, and miscellaneous expenditure not written off as per the audited balance sheet, but does not include reserves created out of revaluation of assets, write back of depreciation, and amalgamation. Now, my lord, kindly has a look. My lord, I'll just give the facts first. My lord will kindly see on the basis of this, my lord, your lordship will kindly take the 3rd volume, my lord, kindly, my lord. And my lord, kindly take page 392. My lord, considering my bid, my lord, there were several correspondences made, and my learned friend's client sought for several documents. One of them I'll kindly see is page 392. Your offer is under active consideration. On scrutiny of your offer, following clarification documentations are required. The financial documents submitted by Universal Infra Private Limited for 22, 20 and 21 in the name of Universal Transformers kindly clarify the relation between Messrs. Universal Transformer and Messrs. Universal Transformer Infra Private Limited. Please submit the certificate of incorporation and partnership deed as applicable. Also, please submit business transfer article in the memorandum of association. Then, my lord, kindly sees the clarifications are sought for, and my lord, 4.
Both the consortium members should
to submit the audited profit and loss balance sheet statement for the financial years 24-25. I've given it because I had it because I have that year. So I gave that. Then, my lord, kindly takes my answer at 393.
Yes.
Here, my lord, whatever documents they sought for, I've given. One kindly sees it's their attachment, my lord, with reply to each of their query. Then, my lord, 395, this 13th October. Again, your offer is under consideration. You are requesting the following documents: CA certified and audited copy net worth of universal transformer for financial years such and such, and CA certified and audited copy net worth of SIPL for the year financial year. Now, SIPL is not under dispute. The first one, Malad kindly takes page 396. This is where, Malad, I submit the CA certificates. Malad, it has been missed out, Malad, though attachments, Malad, I have not, it is not a part of the petition. I am handing over, I've already handed over to my learned friend.
I've received, my lord.
And I believe that he also wants to rely on this, Malad, if your lordship kindly has a look, Malad.
Yes.
Malad kindly sees, we have verified the audited financial statement and other relevant records as by conversion under section 366 of the Companies Act 2013. Name of the net worth. The net worth as per audited financial preceding financial year as on 31st March 2020 is under. The net worth is 626.18 lakhs.
Yes.
Then further, the net worth of the bidder UTIPL, this is a limited company, as on 31st March has not been eroded by more than 30% in the last 3 years. Because there was no last 3 years. For the purpose of showing an erosion, there has to be a platform that is not there because it was a partnership firm. Then, kindly sees, we have therefore included the financials of the partnership firm also. There, your lordship will find during earlier years, the net worth of erstwhile firm Universal Transformer was as under, and the net worths have been shown. And certificate also given that 30% is not eroded. Then kindly sees, moreover, the firm Universal Transformer converted to company, namely the bidder Universal Transformer, and the capital of the partner. Now, in a partnership firm, your lordship is well aware, there is the capital of the partnership firm and then there is the capital of the partners which can be used. Now, this capital of the partner is also, a part of the reserve in a partnership firm. Now, this partnership, when it's converted, 360 restructuring, this has been made into a quasi-equity capital by way of an unsecured loan from the promoters.
Yes.
So, this is also a part of the reserve. Now, that is why it doesn't explain. The capital of the partner converted to equity capital of rupees 600 lakhs and quasi-equity capital as unsecured loan of rupees 2138, aggregating to rupees 2738.62 lakhs. So, together, your lordship will find this quasi-equity as an unsecured loan has been made on restructuring under 366. Now, if your lordship kindly appreciates, the capital which was there in the partnership firm itself, that has to transfer only.
No, so moreover, the Universal Transfer converted to company, namely bidder Universal.
Yes,
and the capital of the partners converted into the equal capital.
Yes.
600 lakh.
Yes.
And the quasi-equity capital 2138 as on 31st March. So, you have taken the two.
This is the partners.
Okay.
Well, that is the crux of the matter. First of all, they say, it becomes erosion. It cannot be an erosion. It's the capital itself. Now, why I am saying this, kindly see the consideration. After this is given, I have explained. Now, kindly sees their letter. Now, kindly first comes to page 397. On 31st October, they send a regular letter saying that you are informed, by this page 397.
Yes.
That your bid for the above tender has been rejected during technical evaluation by duly constituted committee for the reasons commercially disqualified. This is a technical bid. I don't know how they are saying commercially disqualified. Whatever it is, I am accepting it for the time being. Then my lord kindly takes, they say 399, we would like to inform, they will organize a conference call. Then my lord kindly straight away comes to page 405. We write to them earlier, they're saying that you have told us nothing, no reasoning given. Why is this? Now kindly sees 414, 6th November. This is to has your lordship. I'm sorry.
Yes.
This is to inform you that your offer has been techno-commercially not accepted, which was intimated online prior to opening a price bid. The offer has not been techno-commercially accepted as per the following clause. And my lord, it just sets out the clause. Now my lord kindly appreciates the background. They ask for a certificate from the RCA. We give the certificate. It says that this, it's explained. But there is no consideration of that document which they had called for. This is only stated, and then they said it is noted from the document submitted at the time of tender opening and subsequently. Offer of Universal Private Limited and CG is not found technically suitable.
As net worth.
Now it is technically not suitable as net worth of the lead member of the consortium has eroded by more than 30% during last 3 financial years. But how can the company have their erosion? Because the company is only a 1-year company. So they do not consider that partnership firm. They do not consider the provisions of section 366. May I just read out 366? I am sure your lordship is well aware, the restructuring. This is a statutory provision. And they don't consider. Your lordship has seen. It's the partners who have become promoters. And now kindly see 366. Oh, my lord, may I just hand over the book?
Yes.
For the purpose of this part, the word company includes any partnership firm, LLP, cooperative society formed under any other law for the time being force under this part. Now, with the exception subject to the provisions contained in this section, any company formed whether before or after the commencement of this act in pursuance to any act of parliament or other than whatever it is in time being as well, being otherwise duly considered 2 or more members may at any time register under this act as a company unlimited or by shares or by guarantee. So this was a point of conversion.
Unlimited company or as a company limited?
Limited by shares. Now that limited by shares, that has been transferred into equity. And the rest, which was the capital contribution of the partners, that is only shown as an unsecured loan. So, when we are talking about erosion, since they have not given any definition, we have to look back into the erosion, which we generally say about insolvency and things. Where is that? And if your lordship kindly sees the earlier returns, which we had filed just to give them the comparison, there cannot be any erosion. It's only because the unsecured loan is being shown, they are just telling that. I think they are telling that. They have not given a reason for that.
That is not the reason.
No reason given. The reason is not technically commercial. Now I say, my lord, why I have come before your lordship. But I'm not asking your lordship to decide on this. But the point remains, my lord, the way it has been dealt with. If they had not asked for it, that would be a different thing. They themselves asked for the document. They don't consider the document. And they go ahead and say, we are rejecting. And that document clearly explains the situation. But I could have understood that on the face of it, they thought that it is eroded. When they have asked for a clarification, they've given the clarification, my lord, they do not consider. And straight away, I say, my lord, this is unfair.
Yes.
On the part of the state.
Next.
You need to be fair about this, my lord. This is my only case, man. I want
what is the prayer?
My lord, my prayer, that page 25, my lord. And obviously, I have sought for quashing and setting aside of the rejection. And the prayer be isn't the alternative so that they can deal with my this rejection and at least give me a personal hearing and hear me out.
So whether what is the situation? Tender issue, work order issued?
No, my lord, work order is not issue, my lord. Such is not the requirement, my lord. I'll place my case, my lord, if your lordship permits, my lord.
No, I am asking whether what is the stage or now?
My lord, the tendering process is going on, my lord. We are at the stage of finalizing because this is a very important tender, my lord, because I'll show why it is, my lord. It is with regard to substation of Malajkhand copper mining project, my lord. Your lordship may be aware of this, my lord, that copper is now a critical mineral, my lord. We are fighting against China because it is only 5% what we are producing, my lord. And this is a way of arm twisting of the India also, my lord, because your lordship knows, my lord, that there are dummy bidders also in contract, my lord, whose intention is not to secure the contract, but just to uninstall the contract, my lord. Now, I'll satisfy that they have been dealt properly, my lord. My lord, may I bring your lordship's attention to page 45 first. These are admitted facts, my lord. My learned friend has not disputed. So still, I'll start my case from there itself, my lord. If your lordship sees point 1, my lord, may I place this, my lord? I'm grateful, my lord. The bidder, sole bidder, or all the members of the consortium, in the case of consortium, shall have positive net worth as per their latest audited financial statement ending on 31/3/2025. Relevant documentary evidence, including copies of the annual report containing profit and loss statement and balance sheet for immediately preceding 3
consecutive account
preceding 3 consecutive accounting years ending on 31/3/2025 shall be furnished together with the bid. A bidder, sole bidder, or each member in the case of consortium not having positive net worth as per the latest audited financial statement is ineligible to participate in the tender. Further, the net worth of the bidder, sole bidder, or all the members in the case of consortium on 31/3/2025 should not have eroded by more than 30% in the last 3 years ending 31/3/2025. Now, my lord, may I show your lordship the financial statement of this? It is admitted fact that it was a partnership firm, my lord. It has been transferred into a company now, my lord. But it is their choice who has changed the nature of the capital. I'll show what has been done and where is the mistake, my lord. My lord, in 2022-23, my lord, their partnership capital was, my lord, 15.24.
Where from your read?
My lord, page, I'm sorry, my lord, it is page 283. Your lordship has got it, page 283, my lord.
Yes.
If your lordship sees, my lord, at the left-hand side, my lord, it is little ineligible, my lord, but approximately, my lord, it is 15.24 crores rupees, my lord.
15 to 15, yes.
Now, your lordship may please come to page.
Fixed assets.
No, my lord, I'll not draw your lordship attention to fixed asset. This is the capital, my lord.
283.
Page 283, my lord.
283.
It is the balance sheet as on 31st March 2023.
Correct.
Left-hand side, my lord, your first assets, my lord, you'll find, your lordship will find fixed asset. Legible document. It is approx 15.24 crores rupees, my lord.
Fixed asset, that's what I'm telling.
My lord.
Fixed asset.
Now, my lord, in the year my lord, my pages are not legible, my lord. My lord, the capital was 15.24 crore rupees, my lord. Thereafter, in 23-24, it became 18 crores rupees, my lord.
Where from you?
My lord, I'll show your lordship. 22, 23. Then 24, 25.
Yes, page 286.
My lord, I'm grateful, my lord. 286. It becomes 18.28 crore rupees, my lord. Now, my lord, if your lordship comes to page 277.
277.
My lord.
Yes.
Net worth. The net point number 1, my lord. The net worth as per the audited financial statement of preceding financial year as on 31st/3/2025 is 626.18 lakhs. Now, my lord, so here the net worth has eroded, my lord. Now, their contention is that we cannot have a preceding financial statement because we are a new company. But what have they done? It is on their record, my lord. Now, your lordship may please come to the documents which they have handed over additionally, my lord.
Yes.
First, I'll take your lordship's attention to the next page, my lord, which has been pressed by my learned friend, my lord. May I press this, my lord? Moreover, the firm Universal Transformer converted to company, namely the bidder Universal Transformer Infra Private Limited, and the capitals of the partner, kindly mark this word, my lord, capitals of the partner converted to equity capital of rupees 600 lakhs, that is 6 crore rupees, my lord, and quasi equity capital as unsecured loan. So, my lord, this capital has become a loan. It is no more a capital of the company.
Yes.
And whatever has been stated, my lord, below that it was a capital was in the partnership, it was capital of this amount and equity quasi capital was this amount, is an afterthought, because they have been called upon this, that your capital has eroded. That is why they have come with an afterthought. No, this was the provision there. My capital was this and my equity quasi capital was this. Why haven't they shown in the partnership? Now, my lord, they are simply converting their capital into a loan. So their liability becomes only with regard to that amount, because loan is no more an assets of the company. So we cannot consider them anymore, because, my lord, in the PQC, I have shown you, I have shown this quote, my lord, that
the 277 is
277 is, my lord, the document where they have stated, my lord, that the net worth has come down to 6.26.18 lakhs, my lord.
when it was given to you.
My lord, it has been given
16th August. 16th August 2024. 16. That is subsequent to the bid, after opening of the bid.
My lord,
after
my lord, may I take the instruction? My lord, it was additional documents, my lord, because these documents, my lord, these document has to be checked, my lord, with regard to the credential of the bidders, my lord.
That's what I'm telling, because you are relying upon this document. This document after the technical bid.
My lord.
After the technical bid.
My lord.
And technical bid, they have submitted, what are the documents they have submitted in the technical bid? That is,
my lord, they have submitted the balance sheet, my lord.
The 283 and 281.
My lord.
283 and 284.
My lord.
283 and 286.
286, my lord.
Which shows that the 15 and 18.
15 and 18, my lord.
And 18.
Now, in the subsequent year, that is 2025 to 24 to 25, my lord, they have given that certificate, my lord. Their CS certificate, which admittedly says that their capital has come down to 6 crore rupees, my lord. And they have admittedly said that the capital of the partnership has now been converted to the loan, my lord.
Okay, got it.
Now, my lord, I will place one judgment also, my lord, of the Supreme Court, where the Supreme Court has reiterated the stand of the Supreme Court, where in contractual dispute, the writ court should not interfere, my lord. Just for your lordship's convenience, my lord.
Which document? Which
my lord, it is 2023-19 SEC 3 judges bench, my lord. 23 পেজ একটু প্লেস করে দিই তারপর বলছি নামটা টাটা মোটরস my lord paragraph 57 I'm relying upon my lord 57
Yes.
may I place it my lord
Yes.
I'm grateful my lord as observed by this court in Jagdish Mandal versus State of Orissa that while invoking power of judicial review in the matter as to the tender or award of the contracts, certain special features should be borne in the minds that evaluation of the tenders and awarding the contracts are essentially commercial functions and principles of equity and natural justice stay at a distance in such nature matters. Decision regarding to award of contract is bona fide and is in public interest. Courts will not interfere by exercising power of judicial review even if a procedural aberrations or error in assessments or prejudice to a tender is made out. Power of judicial review will not be invoked to protect private interest at the cost of public interest or to decide contractual disputes. My lord, with greatest of respect, my lord, I've already submitted at the start of my argument, my lord, that what importance this tender is, my lord. It is not of 100 crore rupees, my lord. It is regard to copper production, my lord. We are fighting against China, my lord, now, because this is a critical mining, my lord. Now, if this is delayed with regard to any judicial review, my lord, everything will come standstill because it is regard to a power station to be installed in Malajkhan copper project, my lord. Because of this power station, my lord, the entire copper mining will be derailed, my lord. So in my humble submission, my lord, this writ petition should be dismissed, my lord. Grateful, my lord.
Well, two things only. I wouldn't again reiterate the facts. My learned friends refers to 16th August document. Well, they had considered, after that in October, they called for this document from me. I gave it. Now, Malad, in that document has been explained. Malad, the capital account was always there in the partnership firm, and that has only been made into an unsecured loan. Malad, that is of the promoter's loan. It is not a loan from the market. That is never dealt with, Malad. And that will not show erosion, Malad. That is what I'm on. What is erosion? Erosion is that your company has failed.
No, they have taken this trend. Kindly come to the additional document.
Well, the one of 16th August, Malad.
Which you have given.
No,
which you have given the hand.
Which I gave. Yes, yes, Malad. Yes, Malad, I'm on that.
Moreover, the firm universal transfer converted to company, no problem. The bidder universal transfer insurance and the capital of the partners converted into the equity capital of 600 lakh.
And quasi-equity capital.
Quasi-equity capital as unsecured loan of rupees. So it is to be taken as a loan.
Well, these, sorry, my finishes, I'll explain.
Yes, it is taken, if it is taken as a loan, so how it can be taken into consideration?
It is well, kindly appreciates. This is not a loan, Malad, from the market. This is a quasi-equity. Why? Because this is a loan from the Malad, kindly see just below. Neha, Rati and Surari, they are the promoters.
Correct.
It's a promoter's Malad money. So it's the
how in that,
because Malad, the partnership also had that money. The partnership also had that money. What I'm on, Malad, there has to be a parameter, erosion. Erosion will be vis-a-vis the earlier financial statement. That they cannot show because that is already there.
Because which you have disclosed in the original kindly 283 and 2.
Yes, Malad. I'm there, Malad.
15 and 18.
Yes, Malad.
15 and 18.
Yes, Malad.
Correct. 15 and 18. After a clarification has been called from you.
Malad, this is because these documents are of the firm.
Correct.
Firm. Now, Malad, he said 18 crores. Malad, this is also that. This is part of that money which has been restructured. That is what I'm on. It's 366. It's a restructuring. It is not erosion.
Correct.
So that is what I'm on because they are considering that the restructuring is an erosion. Well, erosion has to be on the facts of the case that the money value has come down of the company. Like we used to have the Sika, 50% erosion. But this is not an erosion. What I am on is they called for it. They never explained it. Why did they call for it then? This was post.
They have given an opportunity.
My point is, they should have at least considered this. Because where I'm explaining.
But nowadays, Mr. Ray, you know.
But I'm not asking your lordship to go into nitty-gritties.
Correct.
What I'm seeking from your lordship is will kindly consider 2 points. Did they call for it? The answer is yes. Once they call for it, as a state, they are under a duty to consider it. It is not a judicial review,
No, then they have taken the page 414, which is the.
Where is that with humility, where is that?
That is a consideration.
That is what I'm saying, and it will take only 1 day for them to consider.
You do one thing. I am not passing any interim order. Whatever you pass this order, but what are the document you called for, you submitted that considered
deal with it.
Order.
My lord, again it will lead to a second litigation, my lord. This contract will be.
The court, I will clarify that the court is not impressed with regard to grant of interim order, but find that you have called for the document, they have submitted the document, but where you have rejected the tender, you have not given any finding whether this has been considered or not.
My lord, we have given that
Where is that?
Capital has eroded, my lord.
Where is that?
They are referring to the last paragraph, my lord.
That mail, my lord, which my learned friend has pressed, my lord.
Has eroded more.
How?
That's why
30%.
How?
It has already.
How?
My lord, we have explained it, my lord.
That's
my lord, the matter is before your lordship, my lord. Now everything is explained, my lord. With deepest of respect, my lord. Everything is.
Cannot go beyond the contact, beyond the order which was passed by the authority.
Is not about
The court cannot import in that thing. This is to be taken. You haven't.
My lord, there is an email of November 6, 2025.
Sure.
We have considered it, my lord.
That is what I've shown. 414 too.
This is that is the.
That's the document.
So this document was
I've shown that.
After that, we have given the email, my lord.
What?
That is a 414.
That is 414.
Then after the document was given to us, we have given them email,
That
my
is
lord.
what I must
We have,
say.
after considering it, we have given the email, my lord.
Same document too.
Yes,
Same
it
document.
is there. That is the page.
My lord, we have considered it. We have taken into consideration. Then we have given the email, my lord.
Okay. Yes, anything, Mr.
No, my lord. And I say, my lord, I couldn't find how they have come to a conclusion that it has eroded by more than 30% by considering this document. That is what I.
Then if you want, I will pass an order to affidavit that they will disclose that.
Well, let them disclose.
No, my lord, unnecessary. It will be delayed.
But I think let them give us a hearing in 5 days' time, my lord.
What purpose will be served? You tell me.
My lord, because what I want to. My lord,
What purpose?
my lord, the purpose is, my lord, if my learned friends can show that this tantamount to an erosion, my lord, then yes. But there has been no consideration of that. First thing, my lord, they are relying on my 24-25 financials to say there is an erosion. They cannot do that.
No.
Erosion has to be vis-a-vis another financial. That is not there.
Correct. But
That is not there. That is why I'm saying that this is not a fair stand. Let them give that stand.
My
What is the
learned
stand?
friend is submitting that loan becomes an asset of the company.
Yes.
okay. The petitioner has challenged the impugned order dated November 6, 2025, wherein the tender submitted by the petitioner was rejected by the respondent on the ground that the petitioner is not found technically suitable as inverted comma no net worth of the lead member of consortium, that is SS Universal Transformer Infra Private Limited, has eroded by more than 30% during the last 3 financial year. Inverted comma close. Full stop. The counsel for the petitioner submits that As per the tender clause, the net worth of the bidder within bracket sole bidder or all the members of the consortium in case of consortium should not be negative as per the immediate preceding years audited financial result and should not have eroded by more than 30% in the last three immediate preceding financial year, that is 2022-23, then 23-24 and 24-25. In case accounts of 24-25 is already audited / certified by the statutory auditor. Mr. Leonard Counsel for the petition has brought the attention of this court to the definition given in this tender document with regard to the word net worth, which means the aggregate value of the paid up share capital and all reserves created out of the profits, securities, premium accounts and debit or credit balance of profit and loss accounts after deducting the aggregate value of accumulated loss, deferred expenditure and miscellaneous expenditure not written off as per the audited balance sheet, but does not include reserves created out of revaluation of assets, right back of depreciation of amalgamation. The counsel for the petition submitted that after the opening of the technical bid, the respondent by way of an email dated 7th of October 2025 has requested the petitioner for providing clarification in documents. Accordingly, the petitioner has submitted all clarification as per the requirement submitted as per the requirement of the respondent. The petitioner submitted while submitting the additional document as per the requirement of the respondent, the petitioner has informed the respondent that the net worth as per audited financial statement of preceding financial year as on 31st March 2025 was equity capital was rupees 600 lakhs, reserves as surplus as 26.8 lakhs, and therefore the total net worth is rupees 626.18 lakhs. It was further clarified that the net worth of the bidder UTIPL as on 31st March 2025 has not been eroded by more than 30% in the last 3 years ending 31st of March 2025. In this clarification, it was further clarified that though the firm Universal Transformer converted to company, namely the bidder Universal Transforms Infra Private Limited, and the capital of the partners converted to equity capital of rupees 600 lakhs and quasi-equity capital as unsecured loan of rupees 2138.62 lakhs as on 31st of March 2025, aggregate to rupees 2738.62 lakhs. 738.62 lakhs. Counsel for the petitioner submitted in spite of giving the clarification as required by the respondents, the respondents have issued the impugned notice by rejecting the tender without any reason. And as such, he submitted any reason. And as such, he prayed for an interim order. Per contra, Leonard Counsel appearing for the respondent submits. This is an important project for copper production. The petitioner has participated in the tender, and in the technical bid, the petitioner has submitted the balance sheet for the year 2023-2024, wherein it reveals that in the year 2023, the fixed assets was 15,24,91.15.24 lakhs, and on 2024, 18.27 lakhs. Subsequent, when the respondents have called for the clarification from the petitioner, the petitioner has submitted the clarification stating that the capital of the partners converted to the equity capital of rupees 600 lakhs as quasi-equity capital as universal in unsecured loan of rupees 2138.62 lakhs as on 31st of March 2025. He submits that the respondents have considered the clarification given by the petitioner and found that the company has eroded by more than 30% during the last 3 financial years, and as such, the respondent authorities have not considered the additional documents submitted by the petitioner. Learned counsel for the respondent has relied upon the judgment in the case of Tata Motors Limited versus Brihan Mumbai Electric Supply and Transport Undertaking within bracket West and others, reported in 2023 volume 19 SCC 1 and submit that the Supreme Court has categorically held that while invoking power of judicial review in the matter as to the tender or award of contracts, certain special features should be borne in mind that evaluation of the tender and awarding of contracts are essentially commercial functions, and principles of equity and natural justice stay at a distance in such matter. He submits that in the present case, after opening of the technical bid, the respondents found that some clarification is required from the petitioner, and accordingly clarification has been called. But after considering the documents submitted by the petitioner as per the clarification, it is found that the petitioner company has eroded more than 30% during the 3 financial years, and as such the respondents are not considered the case of the petitioner. Okay? Article and counsel for the respective parties produce the materials on. Admittedly, at the time of filing of the tender document, the petitioner has submitted the balance sheet of 2023 and 2024, wherein the fixed asset is rupees 15.24 and 18.27 lakhs. But when the respondents found that some clarification is required from the petitioners, accordingly respondents have called for the clarification. In the clarification, the petitioner has clarified that the universal transfer converted the firm Universal Transformer converted to a company, namely Universal Transformers Infra Private Limited. In this said clarification, the petitioner has also informed that the capital of the partner converted to equity capital of rupees 600 lakhs and quasi-equity capital as unsecured loan of rupees 2138.62 lakhs as on 31st of March 2025, aggregating to rupees 2738.62 lakhs. This clarification has been considered by the respondent and finds that the petitioner has eroded by more than 30% during the last 3 financial years, and accordingly the tender of the petitioner was rejected and informed to the petitioner by a communication dated 6th of November 2025. The main contention raised by the petitioner that though the respondents have inform the petitioner that the petition has eroded by more than 30% during the last last 3 financial year, but that the respondents have not given any finding or justification why the additional documents submitted by the petitioner as per the request made by the respondents are not considered the same. This could find that the authority are the best persons to taken into consideration with regard to the technical and financial bit. The court is not having any specialization with regard to the tender matters. With regard to adjudge with regard to adjudge the technicality in the tender. The respondents have considered the supplementary documents submitted by the petitioner as per the request made by the respondent. And on consideration of the same, the respondents found that the petitioner firm has eroded more than 30% during the last 3 financial years. And accordingly, the same was rejected, and according the tender of the petitioner was rejected. Considering the above, this court find that there is no, this court did not find any fault by rejecting the case of the petitioner on the ground that the petitioner has eroded more than 30% during the last 3 financial years. Accordingly, the writ petition is dismissed.
I'm extremely grateful, man. Grateful.
Sorry.
No, Malat. It is our duty only place the case, Malat.
Very grateful. Take the book. Yes, call the matter.
I am for the petitioner, my lord. Your lordship may recall, my lord, this pertain to a, my lord, stationery shop, which has been granted by way of a leave and license agreement to the petitioner, who is a ex-serviceman. On the last occasion, my lord, I have canvassed 3 points. Firstly, my lord, that the termination letter, my lord, has been issued, my lord, during the subsistence of the lease agreement. Because the leave and license agreement, my lord, has been executed on 12 February 2025 and it is about to expire 11 January 2026. 10 January 11 February 2025 and 10 January 2026. So I am very much covered within, I am very much within the time. Secondly, my lord, the point they have taken that since, my lord, a policy has been introduced in the year 2018, but that their document, that policy decision has been annexed by way of a, my lord, this is a guideline, my lord, that has come from the Ministry of Defence, my lord, that there would be a locking period for 3 months. But so far my case is concerned, my allotment letter was
3 years.
3 years. So subject to correction, not 3 months, but it should be subject to 3 years. But so far my case is concerned, my lord, the petitioner case is concerned, my lord, that allotment letter was given in the year 2012. That has been continued time to time. And lastly, my lord, the leave and license agreement has been executed in the year 2025. 11 February 2025 and my lord. So therefore, my lord,
that the 25 agreement
lordship, there is no whisper. No whisper.
Suggest any time.
No. 11 months, my lord.
11 months.
But there is also renewal provision is also there.
Correct.
But so therefore, my lord, it is the intention of both the parties that there is the express provision. I am not saying that the petition is automatically entitled to renewal, but at least there is an option. So therefore, having regard to that policy decision, if they are not oblivious of that fact that there is no policy, had that been the case, then they would have mentioned this thing. Because according to
No,
their
no,
case,
but
the policy has already come into effect.
After the entering into the lease agreement dated 11th February 2025, can you go back to the letter dated the initial order of the 2012?
No, 2012, my lord, that is the allotment letter.
Correct.
But the 2018 policy, with my lord, also, my lord, kindly take into account when the 2018 policy has come, my lord, thereafter, my lord, this leave and license agreement has been executed. So, therefore, it can be very well, my lord, inferred that they are also well aware of this policy.
See, this agreement is not in consonance with the 2012 allotment letter.
But that is continuing because this petition has.
That may be continuing.
Maybe, but
that's what I'm telling.
Yes.
Give the answer to that.
Lordship.
2012, if there is no 2012, there is no time limit. You can make a submission. If there is no time limit, they have to either it has to be
Initially for 5 years,
by way of a notice, and whatever it can be determined, whatever that the court will decide whether the determination is correct or not. So 2012, now 2025, you entered into an agreement
for 11 months.
11 months. So once you are admitted for the 11 months, can you go back to the 2012 allotment order?
No, I am not saying that. But what my case is, what I am harping, 2000 is the initial allotment letter.
Correct.
Thereafter, that is for a period of 5 years.
Correct.
That continues right up to 2017.
Correct.
Thereafter, fresh agreement executed.
Yes.
Now, the question is, when is policy sought to be introduced, that cannot have a rate unless it is expressly, so far the judgment is concerned, it is, everybody is aware that it has a retrospective effect. But in policy, nowhere it is written that it will have a retrospective effect. So far, the earlier, the lease are concerned, that will be also, come within the, where, kindly see their policy, where it is
Where is
written.
the policy?
Yes, that they have annexed in the annexure
C.
C of the revenue in opposition,
It is already available in the public domain, Lordship.
Kindly come to
It is
page
already given to
24.
them.
Page 24. In the affidavit in opposition, they have disclosed.
Lordship, this is the matter letter of 2018.
Let me-
Already public domain, all that expired in 2022.
My lord,
Page,
let me.
page
My lord,
where?
kindly come to annexure C, my lord, page 24.
Page 24. Yes.
Firstly, my lord, this policy, my lord, in my respectful submission, my lord, cannot have a retrospective effect. Secondly, my lord, the leave and license agreement, my lord, they have executed. 10 January, 11 February 2025 is still very much subsisting.
This has been given on February 2018. Correct. Para 8 of the reservation.
Just say, my lord, I would say, my lord, this is not even a, my lord, nowhere it is written, my lord, it is a bio of a gazette notification, they have said it. It's just, my lord, they have taken a decision, they have communicated all this, my lord. Whether, my lord, it has got the effect of a gazette, my lord, that also I don't know. But nowhere it is written that it will have a retro.
Have you challenged this?
My lord,
Are you challenging this?
my lord, this particular they have disclosed, my lord, in the affidavit.
Affidavit.
Now, my lord, I cannot, then, my lord, I have to amend my
Correct. If you want to, now you are making a submission, it should be a notification and cannot be a guidelines. So if your submission is if the court you want to go by your submission, then you have to challenge this. Then the court has to decide. Only on the affidavit they have disclosed and
they have disclosed because, but even if, my lord, if I take it as face value, that even if, my lord, this is a policy decision or, well, that cannot have an effect. So for my case is concerned, because, my lord, firstly, my lord, when this agreement has been executed, at that point of time, my lord, both the part they were very much well aware. But when they have given me, well, kindly see my present lease agreement, but that have also annexed, my lord. Kindly come to annexure P2 of the writ petition. My lord, this is the present lease agreement. Lordship has got it. My lord, it starts from page
19.
21.
21.
Page 19 is the initial order.
Yes.
Page 21.
Page 21.
Correct.
Well, now your lordship will see the date.
11 February 2025.
11 February 2025.
Correct.
And yes, my lord, it comments. It is going to expire 10 January 2026.
Correct.
So therefore, my lord, I am
that this court will take care of it.
Because
see, that's what I'm telling. If you go by this agreement, So 11 months from February, 11 months when it will be completed?
Well, 11 months it will complete it by 10 January 2020.
January 26?
Lordship. So I'm very much covered, my lord.
So you are covered. 11 months in the month of 10th of January 2020.
What they have done, my lord, they sought to evict me. My lord, kindly see the notice now, the termination notice. Termination notice, my lord, they have stated for the first time they have talked about this policy. My lord, how this is?
Where is the
Yes, my
termination?
lord, that the termination notice your lordship will find at annexure annexure, my lord, that is P3,
page number
my
40.
lord, page 30.
40, 40, 40.
Well, I stand to be corrected, my lord, page 40. Annexure P3.
Yes.
Well, this is the termination. Now your lordship will find that, yes, 17 mail, page 40, my lord. Annexure P4, vacation of shop. But it's a cryptic nonsense. Well, kindly see the notice. For the first time, my lord, they are talking about the policy. My lord, that policy has got no role to play so far the case of.
Okay. If you go by that, so your agreement is up till January 2026.
I am pretty covered, my lord.
So you are covered.
And I have not committed any breaches.
So the guidelines which they are referring to at page number.
Yes, my lord, that is the annexure.
Affidavit in opposition.
Opposition, my lord. That is annexure. That is the annexure.
Let us
B.
see page number 24 in my evidence opposition, lordship. Please, please see the paragraph number.
Annexure C, my lord. That is the policy guideline, my lord. That is 7 February 2018, page 24.
Correct. That's right. 7 February 20. But when you entered into an agreement, this guidelines was there. You have not taken care of it.
Lordship,
There is,
absolutely
existing
correct.
agreement is there.
Lordship, but only one thing. My learned friend has not submitted in my the B. Para number 9, period of allotment, license period allotment shall be subject to the 5 years with a 3 years cooling of the period. He is not able to challenge this leave licensee because they cannot take part in that in any license agreement. 3 years at least, because 5 years, 12 to 17 enjoyed, 17 to 22 they've enjoyed. After 3 years, they cannot come for this one. Number one.
I am not going to interfere with this.
Lordship.
I am on this only this level.
Lordship, now my in the agreement of
The question is that when you entered into an agreement on 11th of February 2025,
I'm coming.
Guidelines which are relied at page 24.
It is clearly stated. In page number 25, I'm not giving trouble now.
Page 25 of
repetition of the inner page of the 4
of the writ petition.
Lordship. Paragraph number 7, page number 25. Page number 25
of writ petition.
Lordship, the part of the agreement.
1 month notice period.
Yes. Yes.
Yes. Notice period. 1 month notice from either side will be sufficient to terminate the agreement, and on such termination, the license will hand over the vacant position.
Which page you are referring? Which page you are referring?
25, page number 25,
notice
7.
Period, yes. 1 month notice from either
Sufficient.
side will be terminated.
Will hand over the vacant position of the premises back to the licensor without showing any reservation whatsoever.
Yes.
The licensor is not bound to give any reasons for the termination of this agreement. I am binding this, Lordship. And they have gone through, they have signed it.
But the question is that you have not taken. You are not telling that you have taken care. You have given the vacation notice considering the 2018 guidelines.
That is two part. Both is covered by this notice, Your Honor, Lordship. In view of the same sense, as per the 2, we have the general policy NC branch. Letter number February 18 license period allotment shall be subject to 5 years. So 5 years are already completed. After that, he is under might. Might cannot be a right. If he has given a license anyhow, but the clause is there that I can cancel your agreement what is the meaning of the license? He is not the lessee, he is not the tenant, he is not the owner, he is not going to transfer the property. License means ki, just I have given license to given to continue the shop.
That is correct, but only gave.
There are so many policy lordship, there is a policy of the government that we can understand that you are not doing the well, or that is not required of that shop or that platform. So there are so many required. So so that's why we have made this clause for 7. It is clearly stated, and already he is in right 14 years. Even then, I have to wait for the 26.
What 3 months?
Lordship.
3 months.
Lordship.
Today we are in November, December.
Then there is no meaning of this agreement license.
I am giving it for 3 months. I will keep the writ petition, let it come on 19th of February. He will vacate and I pass an order.
Lordship, then there should be state order, the completion order. If he failed and neglected to hand over, then he will pay the some different rate.
Pass an order in terms of though he will. After the 2025, he cannot claim the rent, and you are at liberty to take appropriate steps.
Again, he will come here for the stay.
Only one thing,
I am last 14 years enjoying. So, Lordship,
my learned friend, my lord, has shown your lordship clause 7. But at the same time, my lord, I will also take your lordship to kindly see clause 10. What? There is a renewal provision also.
Correct. That's why I'm telling. One clause here, one clause there. Correct.
So therefore, my lord, they are
only on the basis of one clause they cannot evict you, and only on the one clause you cannot ask for the extension that the court has to adjudicate.
Not as a matter of courts,
and
my lord.
That cannot be adjudicated by the writ court. That cannot be adjudicated by the writ court, whether the tenancy is to be extended or whether the tenancy is to be terminated or the termination.
License, not necessary. I cannot.
So now here only the point of you have raised the question point of.
Yes, I have come up against the 17 May notice.
Correct.
Because that
notice on the basis of which the 2018 guidelines he has issued the notice. Whether this notice
that is not so far that has got no manner of application so far the case of the petitioner is concerned.
Yes.
So that is my sum and substance of. And secondly, my lord, there is a renewal provision. My lord, they cannot throw away. My lord, your lordship knows. My lord, if there is a renewal provision, if I make an application, they have to consider. My lord, at least. My lord, this is the
matter of the department.
The authority should not, my lord, act, my lord, in a partition manner and unfairly. And that to the policy, my lord, without having a retrospective effect.
Petitioner has filed the present writ application.
Okay, sir, Lordship, one thing more. Page number 26. 26
of your affidavit.
Of the petition, the part of this agreement, Lordship.
Yes.
QR. In case of any dispute arising between the licensor and licensee, then the said claim shall be referred to the sole arbitrator, namely an officer appointed by the GOC and HQ, Bengal of sub area, and the decision of the such arbiter shall be.
Have you taken that plea in the affidavit?
No.
Then
Lordship, when the agreement is there, then he put the.
No. See, now the law is settled. If you are taking the benefit of the arbitration clause, the very first initially you have to raise the objection. Once initially you not take the objection, then it's gone. Now whether you have taken the affidavit,
No, I have taken, my lord.
I have the 4 points to cancel his agreement. 4 points.
Your officer is there. Take the instruction.
My lord, there are also cases where even the existence of arbitration clause will not, my lord, prevent the writ court from exercising jurisdiction. Your lordship knows Justice Chandrachud's judgment is there, which says, my lord, if the decision is arbitrary and malafide, writ court can always. My lord, there is absolutely no bar.
There are 4 bars to cancel your agreement.
4 bars.
4 bar is there to cancel agreement, lease agreement. One is the 5 years completed. You cannot take part in this. Number 1. Number 2, already I have the right to terminate your license in 1 month. Number 3 is the arbitration clause is there. Now what do you want? How much clause do you want for the cancellation of your agreement?
Clause has got no manner of application so far this case is concerned. Here the decision of the authority has been challenged. You have nowhere in the opposition has stated that there is arbitration clause.
Lordship, we can again the matter will linger, no. So Lordship, again we can file a supplementary affidavit on this behalf as per this agreement.
What's
regarding the arbitration clause?
That can't be. First, you already filed the affidavit. You are not taking this, and now you cannot. By way of supplementary, you cannot take that ground. Very initially you have to take this ground.
छब्बीस में खत्म हो जाता, 24 में तो खत्म हो जाता था।
But there is also no bar.
Do one thing, you take instruction properly.
Lordship, then
I suggested, because this I am not going to this with regard to the 18 guidelines. I will
Lordship.
record that, but on the agreement which is subsisting.
So Lordship,
till
this
the
is a
January-
policy for the ex-service.
Correct. I will record that until January 2026. You considered, you ask for the department, take the decision, come tomorrow or day after tomorrow.
And
Lordship, we require some instruction.
that this has also become infructuous because
When you will come?
Day after tomorrow.
Day after tomorrow.
Day after tomorrow.
The council for the parties have argued the matter at hand. This for a day's time to take proper instruction, appropriate instruction, according cases adjourned. Let the matter appear. 13th this November 2025. Under the same heading, adjourn motion hai? Under the same heading.
I'm grateful.
well, that notice has also become infructuous. 17 May, 31st July.
Yes, next.
My Lord, state advocate for the state, Mr. Owen Banerjee is appearing in this matter, my Lord, for the state respondent.
Who is appearing?
Mr. Owen Banerjee.
Arun Roy.
Mr. Owen Banerjee is appearing in this Lordship. He is engaged in court room number 37. Lordship, I am praying for only not today, Lordship.
What is the matter about?
Matter is what I'm seeking for implementation of an order passed by the second appellate authority under the Right to Information Act. I make an application under Right to Information Act. They do not give any reply. I prefer a first appeal. They do not give any reply. Thereafter, the second appeal is made. Second appellate authority says that you supply all this information. Thereafter, again, the first appellate authority draws a memorandum and minutes directing the state public information officer, being the block land and land reforms officer, to give the inspection of documents and the documents as required in the right to information application. My right to information application is page 13. My father's name was appearing in the record of rights. Kindly see page 13. My father's name was appearing in the record of rights. Suddenly it disappeared. I made an application under Right to Information Act saying that, did you initiate any proceedings? If yes, give me the proceedings so that I can take my avenue. Date on which the name of such and such was recorded as the owner of plot in your books of records. This
They have not given any reply.
They didn't give.
So
The
you
date
prepared
on
an appeal.
mutation case number.
So you have prepared an appeal.
First appeal, nothing. Thereafter, again, second appeal. Second appellate authority order is at page 19.
Page 19.
Yes.
Being
dissatisfied, second last paragraph. Being dissatisfied with no decision of the first appellate authority, preferred a second appeal. After perusing all relevant documents as annexed thereto, this commissioner has found sufficient grounds to enter into the matter, as has decided to hear the instant matter on such and such in the presence of all concerned. Both parties are present during the course of hearing. The matter has been called on for hearing, heard submissions of both the parties, and after considering all the documents, it appears that the first appellate authority has rightly directed SPIO to dispose of the RTI application. The commission thus upholds the direction of the first appellate authority and further directs the SPIO to allow inspection of all relevant file-stroke documents prior to the computerization of the records, and to provide authenticate copies of the documents thereof as indicated by the appellant, free of cost, within a period of 4 weeks from the date of receipt of this order. Now, my lord, thereafter the first appellate authority kindly comes to the next page. My lord, conducts a meeting. Kindly sees case of the record in compliance.
Take necessary action in strict compliance with the order of the chief commissioner.
Yes. Nothing. Thereafter, I make a representative. These block land and land reforms officers, my lord, are above everything.
Yes. Yes, madam.
My Lord, Mr. Owen.
Let him come with the with all the information required.
Not today, Lordship.
I understand her predicament, my lord.
Tomorrow?
Tomorrow, Lordship.
I will not adjourn tomorrow. If your signature is not there, then you come ready.
Lordship.
Simple thing, you take instruction, what has happened?
Yes. Let the
Whether you have
block
given
landed
the
and reforms
instruction-
officer come to the court
Whether
with
you have given the
everything.
instruction in terms of the order passed by the appellate to second
2020
appellate
matter.
authority, or whether you have not. If it's not, why it has not been given, and or if it is not given, come with all the documents.
It should be put to task.
Tomorrow, day after
Tomorrow,
tomorrow.
tomorrow.
Tomorrow. As per the prayer made by the counsel for the respondent, the case is adjourned. Let the matter appear to.
Grateful, my lord.
17, my lord, appear for the petitioner, my lord. This is my affidavit of service and
But
I
I
put
appear
in
for
the
the-
deficit court fees, my lord.
I appear for the Madrasa Service
The
Commission.
matter is pertains to, my lord, for implementation of the order passed by the West Bengal Information Commission, my lord, whereby directing the SPIO to provide the answer script within 4 weeks, my
Well,
lord.
to the benefit of my learned friend,
But PH
public access.
Yes,
There-
your benefit.
there may not be any requirement because in an identical matter, an order has been passed, 8 weeks time given. He has a genuine case, like there are certain things he's asking for. So there was a delay. So Lordship may pass this order. I have no difficulty for that.
But only one
I
thing,
had
my
a
lord,
talk
instead
to-
of 8 weeks, my lord, may it be 4 weeks, my lord. Since
That may be difficulty for me because, my lord, this is
Then
an
these-
examination of, 2010. So
that
I
has
had
been
a talk to the secretary.
that has culminated in
So
August
It's
2025.
a lakhs of, my lord, this may be difficult. So kindly,
But this order also has not been complied with, my lord, of this honorable
I
court.
think you are not with the contempt today.
That is different thing.
Same order, 7th February.
Yes, yes.
Yes, ma'am.
Lordship may pass this in.
Order date also same, my lord.
So what is your submission?
Submission which has adopted since order has been passed.
The petitioners.
I cannot stand in
The petitioners press for implementation of. Yes. For the direction by the West Bengal Information Commission on 7th February 2025 for providing the information sought for by the appellant before the commission through email whenever it is available. The learned counsel learned counsel representing the West Bengal Madrasa Service Commission submit that similar order has been passed in the case of in WPA number 10394 of 2025 dated 27th of August 2025. In the line of the said order, the petition can be disposed of. In view of the submission made by the learned counsel appearing for the West Bengal Madrasa Service Commission, the writ petition is disposed of by directing the West Bengal Madrasa Service Commission to take steps in terms of the order passed by the West Bengal Information Commission at the earliest, but positively within a period of 8 weeks from the date of communication of this order.
But instead of 8 weeks, my lord, some shorter period.
Authority is required.
There I'm taking quite a lenient view because it's a matter of 2010.
But that has culminated in
not-
August 2025.
But the volume of the matter is absolutely disproportionate to the effect of the matter. The order, it is so voluminous.
That's why.
Yes.
So he has enclosed all the document, but
Yes.
you have not disclosed the document which you require.
Yes, my lord.
Correct.
Grateful. Grateful.
May I please, Your Lordship, time for the petition of Your Lordship.
For the respondent deputy.
Yes. Affidavit filed. First move. What is your grievance?
My Lord, petitioners,
Give any effect to the lease deed executed on the 1st of August 2012 in favor of the respondent.
my Lord, the
Number 8.
property belongs to the petitioners. Petitioner's grandfather's name appeared in the earlier record of rights, and after his death, petitioner's father's name is appearing as the owner thereof. They're owning and in possession. And all on
Who
a
has
sudden,
executed the sale deed?
sale deed of governor, respondent number 3 on behalf of the governor executed in favor of defendant number 8, company. Allegedly, in the deed, it is written that the land has been acquired and it was transferred in favor of respondent number 8. Lord, kindly
Who is
have
the
a
respondent number 8?
respondent number 8, Your Lordship, is a company, Banerjee Automart Private Limited. represented by its managing director, Parthopriya Banerjee.
In the name of the company, the land was registered, conveyance deed was passed.
Yes, Lordship.
And
Kindly have
there
a
is no
look.
acquisition proceeding.
Nothing. We are still in possession. They all on a sudden in the year 2025, they started excavating the land. All on a sudden. And though deed was executed allegedly in the year 2012, they didn't do anything. And all on once after the death of the father of the petitioners, they all along are trying to record their name. And the respondent number 3, for one reason or the other, they didn't record the name of the petitioners.
So if you challenge the deed, how the writ court? How the writ
My
court
lord,
can interfere in that?
My lord, this is a lease being executed on behalf of the governor, honorable governor. What we are humbly submitting before lordship, call for a report as to how this lease.
Let the file affidavit.
Yes.
Yes, you are appearing for? For ADT. Huh? My lord, ADT.
What I'm appearing?
You are appearing for?
For ADDA, the requiring body.
The respondent number 3 has executed the deed in favor of, on behalf of the governor.
8. Who is for the other part? Other? Have you served?
My lord, we did serve.
Item
There is
telling
twice we had to serve because initially the service was affected on all the parties, wherein the writ petition number went wrong. So subsequently, again, we wrote a letter. Well, the earlier communications made was incorrect with regard to the number of the writ petition number. That
affidavit for service filed by the petition be kept with the record. Full stop. In spite of service, none of the respondent appeared except respondent number 8 and 9. 8 and 9 both.
Yes, Raj. 9 is the, my lord, the managing director of the company.
State.
But I am appearing for respondent number 5.
My lord, 9 is the
4 and 5.
Huh?
I am appearing for respondent number 4 and 5.
4 and 5.
4 and 5.
And you are appearing for?
State.
क्या बोला? No. After
State is represented.
So all are appearing. File the affidavit. Because these are recorded, sealed it how the deed has been executed. He is telling that his land.
Yes.
And they are telling that the government has given the land to them by way of sealed it.
The least deed.
Leased it. So, but he is telling that he is the owner of the property. No
The
acquire.
development authority, if I may submit. Development authority, that is respondent 3, has handed over the Milord subject property to Milord the private respondent.
Okay, let all the thing come with an affidavit.
Petitioner is claiming it's a righty land. But Milord Arma, this authority, development authority, they have the entire acquisition proceedings of the land with them.
So let the record, let the file by way of.
We have received it by way of an acquisition and now we'll file our affidavit.
Consult for the respondents pressed for time to file affidavit.
Report on affidavit.
File report by way of an affidavit. Let a report be filed by way of an affidavit within 2 weeks. Within 2 weeks.
3 weeks, my lord.
Within 3 weeks. 3 weeks.
Exception if anyone.
After the service of the copy to the petitioner, the petitioner is liberty to file exception if any within a week thereafter. List the matter on 16th December.
My lord, I'm praying for an ad interim order. The respondent
Already
number, my lord, kindly, your lordship. Respondent number 8 and 9, they should not interfere with the possession. But they're working out there, your lordship.
Let the report come.
Certain measures, your lordship.
Come the record. Yes. Next.
Yes, my lord. I appear on behalf of the petitioner, my lord.
Yes.
Yes. Yes, my lord. The issue remains. There was a tender. Subsequently, my lord, I have become the successful successful bidder. I have been allotted the work admittedly, and I have executed the entire work. Thereafter, my lord, certificate has been issued.
Completion certificate.
Completion certificate. And my lord, ultimately, my lord, I have raised the bill as per their query. That is at page 37. My lord, it was raised. That is amounting to 3,52,142. Till today, it has not been paid. But we have requested, we have made the representation before the authority also. That is at page 38. Let them, my lord, at least let them consider the same.
Although I do not have any instruction in this matter, Bharat may keep this matter next week so that I come back with the instructions.
My lord, what will be the fruitful my lord, purpose? I do not know. My lord, the issue remains. I have made the representation. That is on 17th April 2025.
Dispose of this.
Exactly. Let them consider within a
Consider the representation.
exactly within a stipulated period.
The petitioner has filed the present writ application laying for direction upon the respondent authorities for release of the payment with respect of the work executed by the petitioner. The petitioner says that the respondent authorities have issued the tender notice, and accordingly petitioner has participated and the tender of the petitioner was accepted. After the acceptance of the tender, the work order was issued to the petitioner. The petitioner has completed the work with the satisfaction of the authorities, and accordingly the authorities have issued the completion certificate. Full. After completion of the work, the petitioner has submitted bill for a total sum of rupees 3,52,142 on 13 June 2024. But in spite of the receipt of the bill submitted by the petitioner, the respondent authorities have not considered the bill, has not paid the bill as claimed by the petitioner. The petitioner also made a representation to the authorities for consideration of the bill submitted by the petitioner, but till date no payment has been made. This could find that the petitioner has completed the work and the completion certificate has already been issued by the competent authority, by the concerned authority, not completed by the concerned authorities, but in spite of the receipt of the bill submitted by the petitioner, the respondent authorities have not released the amount to the work executed by the petitioner. In view of the above, the petition is disposed of by directing who is the concerned authority.
Lord, respondent number 6, District Education Officer. He is the disbursing authority.
The respondent number 6, the District Education Officer, Samagra Shiksha Mission, Malda, is directed to consider the submitted the bill to them.
Lord, DOE, that is Lord, the usual.
Consider the bill submitted by the petitioner and to pass necessary order.
My Lord will get at page 37, Lord, second column, bias details, the TOE Samogra Shikha Mission. Lord, that is the bill. We have raised before you.
By the petitioner, and if it is found that the petitioner is entitled to get the payment, the respondent shall release the payment within a period of 8 weeks from the date of receipt of this.
Within a period of 8 weeks.
8 weeks.
I'm great.
Yes. Item number. May I please your. This is my affiliate service, Manor. Here, what has happened is that
Union of India.
the petitioner is the only Chinese school in the Eastern India run by the Chinese community in Chinatown of Kolkata. It's an age-old institution. The building, my lord, not only runs the school, but also this is a religious place of the Chinese as well as the community center. But in the year 2024, the government of West Bengal Home Affairs write to me that for residents of CIFF Jawans
I need part of your school building. 18 rooms, my lord. I replied that since it's a order of the Supreme Court regarding the Nirbhaya case, the CIFs come, so let them stay, but only for 2 months we are ready. They have asked for 2 months. And we allowed. But now more than 1 year has passed. They are not leaving, my lord, and the school is seriously hampered. We cannot celebrate our festivals. Community center has
School
been
is still
closed.
functioning.
Pilot?
School is still functioning.
Yes, pilot.
What,
Chinese
up,
school.
up to which stage? Middle or primary?
It's a primary school.
Primary school. So what is your grievance? Direction
My
to vacate?
grievance is to vacate. They are not.
All persons have filed a civil suit in the writ court.
But they have the action of government authority asked for public to let them use it for 2 months,
Yes,
and then
why
keep
you're
it for
not
1.5 years
vacating?
without paying a single
State
funding.
State is the answering respondent, my lord.
This is the report from the
You are appearing for?
Union of India.
My CIFS also wrote to the government of West Bengal. Say you make a suitable arrangement. The West Bengal government is sitting over the matter.
Government of West Bengal?
Yes, my lord. Home and Hill Affairs. And there is no law, my lord, to take this type of premises from the public at large.
Who is in the occupation? CISF?
CISF.
So CISF, how the state will come? Is the central?
CISF, my lord will please come to page 58 of the writ petition. But that will clear everything.
58?
58.
Yes.
But this is the main order by which it has been requisitioned. But the Special Commissioner of Home and Hill Affairs writing to me that I am directed to defer to the caption subject and inform you that under the Honorable Supreme Court of India order in the writ referred above, the state government has to make accommodation provision for 3 coys of CISF currently deployed in guarding and protection duty at Arjigar Medical College. In this connection, temporary accommodation arrangement for 2 coys of CIFS is required to be made in the absence of a place to accommodate about 200 CIFS personnel. Your premises which is lying vacant is found to be suitable for the purpose. Under the circumstances, I am directed to request you to spare 18 rooms of an institution for set on temporary basis for 2 months. They also take it for 2 months. And we granted in the next page for 2 months.
Yes. What instruction? When? Tomorrow? You will take instruction by day after tomorrow. Counsel for the state press for a day's time to take instruction. According to cases adjourned, let the matter appear on 12th. Na? Affidavit of service filed by the petitioner.
My lord, the report submitted at Instance Opinion of India we kept on record, my lord.
You keep this, come on next day.
Lordship. As your lordship.
Then
Grateful, lordship.
yes, original side.
My lord, may I be permitted to mention?
Just a minute. Let the officer exchange.
India bags.
अभी क्या हुआ फिर अभी लाएगा
My lord, may I be?
Yes.
My lord, may I be permitted to mention item number 62 of today's list, my lord?
62?
62. My lord, the container number 4 is present. Other side is also there. We have complied with the direction. We would like to file the supplementary affidavit.
62.
62.
My lord recalls the contempt matter where the
Yes, it was listed.
Yes,
On
my
the
lord.
last occasion, you will say that on 7th, you will 11th, 10th, you will be available that you are not present yesterday.
My lord, today was a returnable date, my lord.
Today was the
Yes,
returnable
my
date.
lord.
Yes.
The contender
Lord,
number 4 is present
Ah.
because and the supplementary affidavit has been affirmed by him, and I've already served the advance copy of Atul Dhave's affidavit on the other side. I shall file the affirmed copy
What
by
has
next
happened to your negotiation?
negotiation, my lord. We
Lords,
have
I
no
appear.
negotiation as such, my lord.
My apologies, my lord. Lords, I appear on behalf of 1 to 4, my lords. I'm instructed by Miss Pooja Shah only, my lords. The contender number 4 is in court right now, my lords.
Yes.
And we have been reassured, my lords, that the balance payment of 4.5 crores in terms of the agreement to sell will be paid on or before 18th January, which was the date agreed to, my lords, in terms of the agreement to sell. And the valuation report also in the meantime we have taken and we have exchanged it with the buyer, my lords. So we will go through the sale deed, my lords, and we'll pay this 4.5 crores to.
How much time it will take,
My
sir?
lord, we have
Lords,
already
lords,
given
we have,
the time limit.
lords, it
By
was already
18th
recorded in
January
the
we'll
order.
do it. By 18th January.
Yes.
It's already mentioned in the previous order, my lord.
there is a valuation report which they have annexed. My lord, from the valuation report, I am unable to ascertain the land they are selling and the valuation report that they are
But
now
there is
indicating. May I indicate, my lord? They, if my lord comes to, it is unnumbered. So if the second page of the valuation report, my lord sees that the valuation report, they have valued the property as 1.47 crores. Whereas, my lord, the sale price was agreed or what they had proposed was 4.5 crores.
But
So, my lord, this is one issue which I find from the valuation report.
but my lord, that is irrelevant to him because
My lords, I will just clarify. my
Okay, okay. See, already 18 January, they are giving the deadline.
the purchaser is agreeing to
Let
purchase.
No, no, my lords, I will,
Yeah. Yeah,
if my lords will permit me, I'll just, if my
Contempt.
lords will permit me, I'll just clarify.
Contempt.
So let it come on 20th January.
My lord, let this matter be appear on 20th January.
7 XF, my lord, there was also approximately 93 lakhs, which is still
92 lakhs, my lord.
still due and
By that
payable.
time, if they will pay, otherwise 18th is the
Let this
deadline.
matter be appear.
I am fixing on 20th January. 20th January is open. Yes, 20th
Yes, my lord.
January. Let come on 20th January.
Let it be on 20th January. And my lord, there was one more direction that the affidavit of Atul Dhave need to be filed, my lord. I've served the advance copy. I shall file that affidavit within 1 week's time, my lord.
1 month.
1 week's, my lord. It will be coming from Bombay, so the required time.
And let's content number
4.
4 is present in person and has filed affidavit stating that the process for execution of sale deed is in process and by 18th of January 2026 the sale deed will be executed and the remaining amount will be paid by the petitioner. Condemned. This is adjourned. The matter appear on 20th January 2025.
My lord, may I?
How he intends to pay this balance?
Not already my earlier order is
Earlier order is there, my lord, and
He does not say that.
to that effect, my lord, I've already paid 50,000.
I don't want to repeat all the things.
My lord, to that effect, I've already made a part payment of 50,000
Who will file the affidavit?
by contempt number 4.
No. That
Atul Dave.
Atul Dhave.
Mr. Learned Counsel appearing for the alleged contempt number 4 submit that those he has served the advance copy of the affidavit of Mr. Atul Dave, but she will file the affirmed copy of the Atul Dave within a week in
Within a week, my
the
lord.
department.
Lord, just to clarify about my learned's query, my lords. Lords, that was the circle rate 1.4 crore.
That's why I am not interfering on
That is irrelevant to this.
That is the circle rate and 300 to 350 per square feet. Otherwise, is the
Okay,
rate.
please come on 20th
Please, my lord.
with a positive result so that the matter can be disposed of.
Very great.
My lord,
Lordship, I'm
may I be
appearing for
permitted
5,
to
6, 7, and 8. For 5,
Yes.
6, 7, and 8, Lordship.
वो दिख देना so and so appearing for the 5, 6, 7 and 8.
Lordship,
my
great.
lord, my lord, may I be permitted to mention, my lord, that 283.3 matter, my lord, 283.3 Succession Act, my lord. Division
What happened to the appeal?
Division bench held, my lord, where, my lord, consents have been given by the heirs in intestacy, my lord, no citation is required.
No citation is
My lord, I have given handing over this. My lord, para 24 onwards with regards to 283. My lord, matter is item number 60. non-contention.
Paragraph?
28 is most relevant. Starts from 24.
28.
28. Page 23. Bottom.
Only the executor appointed by the field of the disease is entitled to obtain property.
And thereafter, my lord, 32.
This is not fair because see, last time when hearing, I proposed your counsel, Mr. Rajan. I have started and moreover last 2 days मतलब आप लोग के साइड कोई टाइम लिया गया था अदरवाइज रिप्लाई भी कंप्लीट हो जाता so this is not now because the bank is a hardship नहीं मैं तो बोले रही हूँ because bank is also suffering interim order.
Yes.
I think assistance of Amicus Curie is also there.
So what can be done?
Approve it to be granted. Item 60. 60.
Specialization है?
Yes.
Specialization है?
Yes, part hard part. It was hard in part. My lord appointed Amicus Curie, Mr.
No, I will fix a date because it's 62. कब करेगा?
Yeah, okay, सारे assistants.
14th correct the top में. 14th it will be listed as in the top. इसको file में रख दो.
May I be permitted to mention one matter, my lord?
Testamentary suit. Lordship that Ramesh Kejriwal and Mahesh Kejriwal. Your Lordship fix the matter on 20th and 24th November.
Pattern?
Yes,
Oh,
Your Lordship. For
Assignment.
Especially
assignment.
Your Lordship, what?
We are happy
Happened, Your
with your lordship. We are very happy with
You are happy, but what?
I am happy, very happy with you.
What the group 9 will do?
Because
My
my matter got
20th and 24th, Your Lordship is not available. He has gone somewhere, Your Lordship, for business meet. Any date, Your Lordship, in December, Your Lordship.
my lord, this I object with regard to this
He has
because
gone
with the
to for a
consent
business
of him
meet
was
for the business.
the date was fixed. With the consent of the witness, the date was fixed. This is the probate application, my lord. They are opposing it. Fight between two brothers, my lord. In other litigations also, they are taking time with regard to this probate, my lord. My lord, just refund date any day before 20th.
20th of?
Any day before 20th November. 1 day, 2 days.
Before 20 November, it is not possible.
Not possible. So 20th November, I oppose, my lord. Then a short date. Not December.
Any date, Your Lordship, on the first week of December, Your Lordship, he will be available.
2 days, your lordship will then.
Yes,
दिसंबर का कोई फिक्स है क्या हम लोग का? नहीं है. वो कब फिक्स किया?
Consecutively 2 days.
नवंबर. Item number?
Not, Your
Not
Lordship,
there.
is
Not in the
appearing in the
list.
list, Your Lordship. This is the last order passed. It's the last order.
Let it become tomorrow as to be mentioned.
Yes.
May I be permitted to mention one matter, my lord? There are 5 analogous matters, my lord. I'm mentioning upon notice the petitioner's advocate is present, my lord. These
My lord, I am here, my lord.
petitions were filed challenging the declaration of willful defaulter of loan by the IDBI Bank Limited, my lord. Now, this matter, all these matters are filed in sometime in 2024. Bank is suffering interim order, my lord. And this matter was substantially heard on as many as 8 to 10 days, my lord. All the arguments on behalf of the petitioner and the respondent is complete. Only reply on the part of the petitioner is due, my lord. So, my lord, I'm just praying, my lord, if my lord, these matters are released, my lord, and it's because, my lord, otherwise it would unnecessary.
No problem. Where is the list?
Lord, Mr. Bose
No,
is
my lord,
appearing
my lord,
virtually,
my
my
lord,
lord.
kindly hear me, kindly.
Order seats, my lord.
My lord, before that, my lord, allow me to say something. My lord, I am the petitioner.
Yes.
She is opposing my writ petition. My lord, admittedly, the matter was heard on repeated occasions. This is not
My lord, I'll just tell you
the
about
court. No, my lord, why am I not being audible? Mr.
Yes, yes,
Khandani, why are you
there is a
interrupting me?
problem in the link.
My lord, am I audible now?
Yes, now you are audible.
My lord, this prayer, my lord, we had made this prayer before the coordinate bench on repeated occasion to treat the matter as part heard. My lord, her ladyship was pleased to reject our prayer that no, I will not treat the matter as part heard. So then under these circumstances, well, in fact, we were mentioning the matter. In fact, on the last occasion, we were giving notice to mention the matter for inclusion in your lordship's list. Well, under these circumstances, my lord, where is the question?
My lord,
Do one
the-
thing, you
with
both,
CPS
both,
of risk,
both when
my lord, we have done that.
I am opposing such submission, my lord, because
That's why I am telling both advocates sit together, toss the matter.
My lord, your
court,
lordship will see
which
this
court the
tossing.
toss will come?
my lord, if
No, my
my
lord,
lord
I'll
sees
tell you,
the last
lordship, my lord,
order, my lord, that would be clear, my lord, that the entire matter is heard. In fact,
Correct, I appreciate.
No,
but
but the
the
question-
problem is that if the other judge is, you mention the court, if the court will say, yes,
No,
she will
we
take, I will release,
mentioned
no
it.
problem. I have no problem.
my lord,
My lord,
Correct,
we
you
had
mentioned before
specific.
her ladyship. And if it is released, then I will release and take the assignment from the chief, and matter can be done. Because if without the consent, I cannot release.
yes, my lord, I bow down to that.
Correct.
I will miss.
This is for my lord, listing of the matter. Matter to be listed.
But this is not right.
Annexures are illegible in the petition. Thereafter, they say that if the leave may be granted by the honorable court, they say actually the fine. I'm paying for leave.
What you want?
So, all the some papers are illegible there. If this court, granted court shall give leave, then
How the court will accept the not legible paper, illegible paper? You have to come with the legible paper. At the time of hearing, how you will refer the paper if it is not legible?
it has hard upon us by the other side, my lord. I have not.
So what can be done? What can be done? If you wrote a letter to the other side, give the legible, then come before this court if they are not giving that. Correct. That's why you write the letter to the other side who has supplied that, give the legible copy. If it is not, then come to this. Yes, call the matter. This court finds that the plaintiff has proved the will and testament of the testator dated 29 February 2008 and is entitled to get probate. The department is directed to issue probate of the will dated so-and-so on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate, decree be drawn accordingly.
I'm for the plaintiff, my lord.
The defendant is directed to pay an amount of rupees 6,28,029 rupees along with interest at the rate of 15. I have not granted 24%, 15% per annum to the plaintiff from 1st October 2019 till realization of the total amount. The defendant is also directed to pay the cost of rupees 1 lakh.
Right.
Case is disposed of.
Well, this is
অনলাইন নামে চলবে আমার 4টা করে দিন দেন 1 সেকেন্ড লাগবে
হবে না আমার
my endeavor goes
No, I don't.
I lost my all credibility. I try to pursue them not to do this matter.
They are still there that they are in 38.
করবো ছোট করে শেষ পরেরটা নয়
Yes, is anything, Mr. Basu?
The matter will take some time, so I was thinking that my next matter is a short motion.
এটা ওই বিল্লা নয়
নয়
Well, this is matter very briefly. Well, there was a subsidy scheme. We did not get benefit under the scheme fully. We got 40 odd crores, supposed to get more. We came to the High Court. Writ Court passes a mandamus in my favor. The respondent state goes up in appeal for the Honorable Division Bench. All their points considered. Appeal dismissed, mandamus upheld. They go to Supreme Court and then Supreme Court dismissed. Then we file a contempt petition.
and they file a review application. Review no order, contempt to be heard. At this point, they enact a statute. Just simplicity that the scheme is bad. Scheme is bad, and no decree order will be given effect. This is on the face of the statute. This is on the face of the mandamus, and so the vires of the statute is what we have said.
Yes, so it's for the other side.
On the other side, first day they appear. The learned advocate general appeared 15th on the
Affidavit
5th of,
filed, no?
No, 5th August. They did not file directions, and thereafter one more direction.
No.
Asked for a report. Asked for a report to be filed 5th August, paragraph 8.
By 26th August 2025.
Nothing has happened.
File exception to the same. No, nothing is filed. Yes.
My lord, think the matter, my lord, 15 December, my lord. This is the filing, my lord.
That is an appellate site.
15 December ki ache.
No, that is not. That is an appellate site. That's why when I have seen this, then some matter has been filed in the appellate site.
Oh.
Some writ petition has been filed challenging the same in the appellate site. Yes. That is on 15th
December.
No, but is there a mandamus in that case? Mandamus already passed because any others, Vadi's challenge will be on other grounds also. But my principal ground is that just to nullify a mandamus of a writ court if an order is passed.
We are appearing for WBITC. So state is the answering respondent.
Yes, state. Who is for the state?
But because this matters, my lord, there are many matters where the orders were passed. So mandamus were there. Court was hanging. Many matters.
Nobody is for the state.
I will humbly pray, Lordship, kindly fix a date and give them one more chance. And because this is, even though Vairi is involved, it will not take me much time.
By an order dated 5th August 2025, this court directed the respondent to file report by way of an affidavit, specifically disclosing the benefit which were due to the petitioners, the benefits already granted to the petitioner, and whether the respondents intend to withdraw/recover any benefit already granted to the petitioner pursuant to the earlier scheme. Full stop. This court directed the state to file affidavit by 26th of August 2025. When the matter is called today, none appears on behalf of the state. For the interest of justice, the matter is adjourned. The state is given one last chance to file affidavit in terms of the order dated 5th of August 2025 within a period of 2 weeks from date, after serving the copy to the learned counsel for the petitioner. If the petitioner intends to file any exception to the affidavit, exception shall be filed within a week thereafter. This is the matter. 2 weeks bola na? 2 weeks, 1 week, 3 weeks. This is the matter on 2nd December. कुछ fix है क्या? 2nd December.
Just till the next date of hearing.
2nd December 2025. The interim order is extended. Interim order passed on 5th of August 2025 is extended till 5th of December 2025. Or
Well, may retain his position. Well, may retain his position because
at the top.
I'm grateful.
Yes.
But I'm praying for short pass over my life.
No.
In this matter, Madam Learned ESG is appearing, Madam. He is
ESG?
Yes, Madam.
What is the matter about?
Very important matter. I am asking for details of my passport. So very important. And on the ground of my lord, the document which are not to be discussed, on that ground it has been with me. I am asking for my passport details. This will travel list is used or in a soup.
24(1), Schedule 2 does not prohibit.
Yes.
Very short pass.
Pass हुआ? Pass हुआ?
Very
Not
dangerous. Very dangerous. Not today, not this year, I can sustain. But a passover is very dangerous.
So tomorrow you will be available?
Yes, ma'am.
I will take up origin certificate.
Now origin said every day 3:30 onwards.
3:30. Don't keep it on Friday.
It is your luck.
No. Don't keep it on Friday 3:30. Make it then 2. Because 3:30 maybe
3:30 every day I am fixed because other the part-head matters are also there.
My lord has carried something. In this determination, there is no pressure as such. But my lord has carried the pressure.
I wanted to release, then I got today again one notification. Now you continue with the delegation of the commercial court.
Problem will be there. Litigant will be. My lord has substantially hard some matter.
That's why.
I am happy. I am happy that my lord is. In this jurisdiction, sort of seldom I can appear.
Thank
you. My lord, I am a foreigner there.
Not today. कल रख लें. ऊपर ही रहने दो. Item 5.
Lordship, I am for the petitioner in this matter. This writ was against the order of West Bengal Clinical Establishment.
Yes.
This writ petition was against the order of West Bengal Clinical Establishment Commission. It was heard. The order was stayed by an order dated 4th March 2021. Thereafter, the respondent number 2 was supposed to file an affidavit in opposition. They have not yet filed their affidavit in opposition.
Who is appearing?
Lord,
Number
just
1.
now he has said that respondent number 2. Lord, we are the
You are
regulatory
appearing for?
commission.
2.
Lord, we are the regulatory commission. Lord, we are the order passing authority. We have relied upon the documents what is placed before your lordship. Now the order which has been passed, that is to be tested by your lordship whether it is correct or not, because we cannot develop or we cannot reduce something. For such reason, my lord, the affidavits ought to have come on behalf of the 3, respondent number 3, because he is the private respondent, not by us. Respondent number 3, because he is the complainant before the regulatory commission.
Your Lordship,
Have you served?
We have served. They had received the some petition, but they did not appear. They have not been appearing since the very inception of this petition.
They are not appearing. If your lordship wants, I can argue on merit.
But ready? You are ready?
Lordship, then kindly fix a date.
I am fixing next week. You inform the next date to all the other authorities.
My lord, merit I shall, because my lord.
Your Lordship, one more indulgence. I need to file a supplementary affidavit in this matter.
For what?
This when the interim order was passed by the authority, at that time the matter was referred to the Medical Council, West Bengal Medical Council. The Medical Council's order has reached finality, so we need to incorporate that order as well.
Because my lord, here there is a difficulty. My lord, Medical Council is in respect of the West Bengal Medical Council of. There is another act when the negligence on the part of the doctor, and here when negligence on the part of the clinical establishment. Completely different altogether, and not only that, the authority is also different. That is not necessary to incorporate the same before this in this matter.
What benefit you will get with regard to
Exactly.
that order? What benefit you will get? It is the order of the authority.
Yes.
If you rely upon, you place the order at the time.
Exactly, it's a merit. On merit,
Then kindly fix this for hearing on the next.
Not yes, I am fixing.
Yes.
That if nobody will come, then I will hear without affidavit. But
My lord, can be.
None appears on behalf of the respondent number 1
and 3.
For the interest of justice, the case is adjourned. Let the matter appear on 20th November 2025.
20th November. My lord, instead of 20th, can it be on 19th? Or
21? 21
or 20 after 20, 24th.
24th
24th.
24th में ये तो नहीं है ना, evidence तो नहीं है ना. 24th November 2025. It is made clear that on the date fixed, if the respondent number 1 and the respondent will not appear, comma, the application will be taken up for hearing in the absence of the respondent.
My lord, I'm grateful. 24th. Take it up.
My lord, Aparna Banerjee is appearing for the respondent. Her mother-in-law has expired. Kindly keep it after 25th.
As per the prayer made by the counsel for the respondent, the case is set down. Let the matter appear on 26th November.
Grateful.
Next.
My lord, in this matter, my lord, I'm for the petitioner. My lord, there is one practical problem, my lord, which I think I must bring it before your lordship.
Yes.
My lord, affidavits are complete. It is ready for hearing otherwise. It's with respect to incentive scheme, my lord. But my lord, before I place it on merit, my lord, there is something which has come up in the meantime. My lord, there's a notification, my lord, which has been passed. Now, with this notification, my lord, what has happened here, my lord, I just went through it. I'm just handing over that notification. My lord, every such thing which was granted.
Recall. So
has
it is
been-
pending.
My lord,
Several
we-
writ applications are pending.
Yes, but my lord, the thing is that since this is also related to this, I think we should come up with an amendment application and
For
also
the
challenge.
petitioner.
I am for the petitioner and challenging the virus of this act. Or else, my lord, I think this will not be proper to place
Correct.
because, my lord,
Otherwise
what
you
has
become
happened here?
infractuous.
What has happened here, subsequent to the payment of the value added tax, my lord, we were supposed to submit the documents based on which they were supposed to sanction the subsidy. In few cases that has been sanctioned, but no payment has come yet. Well, there was a representation considered, thereafter not considered, the again read, many things has happened in the meanwhile. And also, my lord, in another such matter, my lord, there has been an order which has passed subsequent, my lord, to the apex court order, my lord, wherein they have already cleared the payments. But by virtue of this act, my lord, I think this has to be brought under challenge. So kindly grant us the leave to file an amendment application, or else, my lord, it will be left out, and in that event it will actually be infractuous.
It is a submitted in view of the notification dated 22nd April 2025. The petitioner intend to amend the writ application according pace for time. In view of the submission made by the counsel for the petitioner, time to file taking appropriate steps to amend the writ application is allowed. The petitioner director will take appropriate steps within a period of 2 weeks.
Well, 3 weeks.
Within a period of 3 weeks.
My lord, only I was beseeching, my lord, since, my lord, the advocate general has to be added because of state legislation, my lord, I will be also at liberty to add.
If the amendment with your application, amendment application, you have to disclose all the things.
Absolutely.
Okay, well, within 3 weeks. This is the matter on 2nd December.
Another statute, my lord, it says for section 4 subject to correction, all proceedings also stands abated. And this is a statutory abatement.
That's why all have filed the writ application challenging that.
No, yes,
because
we have been,
otherwise
I have been
even the order of the Supreme Court cannot be implemented.
Yes,
I have,
it's absolutely.
contempt matters have been
Judicial review has been shunned off.
Two contempt matters, Honorable Chief Justice was pleased to dispose of on this ground only.
That's correct.
Well,
that
has to be. I'm grateful.
Much obliged, your lordship.
For the petition.
My lord, I'm for respondent number 8 bank.
Yes. What is your application, sir?
My lord, this is the application, lord.
What you have prayed for?
I have prayed for stamp duty. My lord, is required to be paid as per the value mentioned in the sales certificate in terms of the judgment passed by the full bench, reported in 2010, volume 3.
Purchase from by sale?
Purchase from public auction. Now, my lord, to that effect, my lord, I made representation before the authority. Now, my lord, the authority did not do anything. In the meantime, my lord, another clarification, my lord, was issued, my lord, by the special bench, my lord, of this honorable court. My lord, what happened, my lord, in the previous judgment of 2010, it was mentioned that in court auction and DRT auction, all auctions, my lord, the sale value of the auction in the mentioned in the sale certificate to be abided by as this sale proceeds. Now, my lord, two of the single benches will lord hold different views. One said that in respect of bank auction, surface auction, the sale value is to be paid as per the market value. And another single bench held no. This is also public auction. Similar status should be given. The matter was again referred to the special bench. Well, special bench held that no, this is also a public auction. So the stamp value is to be paid as per the value mentioned in the sale certificate. Well, this is the crux of the matter.
My lord, Mr. Oyon Banerjee appears for the state respondent, my lord. My lord, he's engaged in courtroom number 19, lordship. Been instructed to pray for an adjournment before, my lord.
When?
My lord, the sale has been conducted.
You are appearing for whom?
Back. My lord, do we have sold the property?
You have sold the property which
Yes.
you have purchased. You
Yes.
have taken on auction.
Taken.
Sold to the petitioner.
Uh,
So who will pay the court fee? Stamp duty.
My lord, Bali Fabs, there is a
I will
judgment.
pass an order. The bank will pay the stamp duty and this will be decided.
Yes.
My lord, why should
Subject to outcome of the requisition.
outcome of the my lord, we have sold the property, he has registered the property, everything done. If there is a refund, we will not object to it, we will be supporting. And my lord, there is a judgment.
When your senior.
My lord, only not today, my lord. It may be taken up
Tomorrow
tomorrow.
Think tomorrow. Once I adjourn, if I fix, then no adjournment. Think it when you want.
May I then seek for instruction?
Next week, come on the next.
Next week, my lord. Yes, lordship.
We have been governed by the Bali Fab judgment passed by Honorable Court in this matter.
Let they come then.
My lord, deeply obliged, my lord.
They are made by the counsel for the state respondent. The case is adjourned. Let the matter appear on 18th November.
No, deeply obliged, my lord.
I appear on behalf of the respondent bank.
Challenging, my lord, the order passed by the willful defaulters committee, my lord, declaring the petitioner, which is the guarantor, as the willful defaulter. Now, my lord, from an order refusing to pass interim order in the writ petition, we had preferred an appeal. That appeal is pending, but really, since this matter is ripened for hearing, my lord, we can proceed with the hearing of this. But my learned friend says that since the appeal is pending, they have not filed any opposition.
That is why, because we have filed a supplementary paper book disclosing a few documents in the appeal court. If your lordship permits right now, then I'll take some time.
Appeal is in the list today. It's in the list, but we should really, you know, thrash it out here.
But without the affidavit,
No, let them file.
When you file, or you will wait for till the appeal is disposed.
I was under the impression that since they had challenged the order from refusing the interim order, they are going to flash it out there. But since it has not been done, your lordship will kindly grant me 2 weeks' time. I have to put in the affidavit because the bank can have to get it affirmed.
There's a direction earlier for affidavit.
Yes, there was direction. There was direction in the order. Yes, yes, madam. There was direction.
That has to be explained.
The counsel for the.
I'm praying for 3 weeks, your lordship.
Hey, how about 3 weeks?
Respondent bank. You are appearing for the bank.
For the bank.
Respondent bank prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. Reply by
within a week, madam.
Reply by a week thereafter. Release the matter on 15th December.
Grateful.
Ten, my lord. Similar prayer. Mr. Oyon Banerjee is appearing for the state, my
The
lord.
matter is fixed.
My lord.
Earlier matter was fixed.
18th. Next week, 18th, my lord. 18th November.
Urgency. His senior is having difficulty. Have you filed affidavit?
Well, the pleadings are.
What is the matter about?
We have been served, my lord, with a copy of the affidavit in opposition. I will file the affidavit in reply.
Affidavit aaya?
File the affidavit in reply.
Where is your affidavit?
We'll file the affidavit in reply. My lord, we've served on the other side, right? Have you served the affidavit filed the affidavit in opposition? We filed the affidavit in reply, my lord. I don't know whether, my lord, they have filed the affidavit in opposition.
There's no affidavit in opposition on record.
I'll
Check from your office.
Yes, the last time I remember, my lord, we could not file the affidavit in reply because, my lord, their affidavit in opposition was not filed till then.
And the petitioner has filed affidavit in reply after serving the copy to the London Council for the respondent. Let the same be kept in the record. But this court find that no affidavit in opposition is on record. The respondent is directed to place the affidavit in opposition on record by the next date fixed. This is the matter on 19th November.
19th, I'm not in Calcutta.
When? 21?
Any other day, my lord.
21st November.
21st.
My lord and juniors are in some difficulty. My lord. Any
Anything
day.
other matter is fixed, madam?
18th of November, my lord. Lordship has fixed 18th.
25th November.
Done.
Very deeply obliged.
Deeply
But it
obliged.
only be made peremptory because, my lord, they have been
25th
taking
November
time.
Evidence, hai na? 25th evidence.
Because
25,
we-
26.
The last 3 occasions they have not appeared, and it's a point, my lord, where we are seeking a refund of a sum because, my lord, a property which was, my lord, to be auctioned thrice, my lord, it didn't fetch the price. Then, my lord, the price that, my lord, it fetched, my lord, we say that we are forced to, my lord, pay that extra sum of money, which now, my lord, they have to repay, my lord, refund it to us. That's the case, my lord. And I'll quickly indicate the facts and I'll go to the judgments. We're covered, my lord, by judgments, and I don't think they'll be able to come out from those points, my lord.
Then 28.
28 will be
Deeply
here.
obliged, my
I'm
lord.
very deeply obliged. my lord.
Next.
Your Lordship, I am appearing for the respondent bank authorities, Your Lordship.
I appear for the writ petitioner, my lord. So this is against a declaration of willful defaulter against a petitioner. My lord, there were 2 writ petitions by the same petitioner. One, my lord, against different banks, consortium of banks. 2 writ petitions were filed. First one was heard. I succeeded, my lord. But I had argued 4 points. I succeeded only in 1 point. Therefore, I had to prefer an appeal. This appeal is being heard, my lord. It's item number 8 today, my lord. My lord, it will be covered, my lord. So, my lord, I was humbly beseech, my lord, kindly fix it in next monthly list, my lord. By that time, this appeal should be heard.
It is submitted by the Land Council for the petitioner and the appeal is pending and it's heard.
This would have
completely
connected.
Heard in part today.
Heard in part can be.
Heard in part today and praise for adjournment. On the said ground, the council for the petition praise for adjournment. In view of the submission made by the council for the petition, let the matter appear on 2nd December.
Very well.
Grateful, Your Lordship. Good.
My lord, I am for the petitioner. We didn't get any instruction from client. Kindly paying for 1 week time.
No instruction. So I will dismiss automatically. Your client will come and give instruction. That will be a better way. If the clients are not coming, the case is to be dismissed. Then you forward the dismissal order to your client. Then your client will automatically come. As per the prayer made by the council for the petitioner, case is adjourned. Let the matter appear on 28th November.
May I please, Your Lordship? But this
Yes.
is a case, Your Lordship, this has been heard elaborately by 2 different benches. Affidavit has been completed.
Now I am the third bench.
But this is the substantial question of law is involved under the Electricity Act. It is pertaining to optical fibers. So optical fibers, under the Telegraph Act, the authority has issued certain bills against the CSC authority. The bone contention in this matter is that so far the tariff is concerned, they cannot raise this tariff. Under the provision of the Electricity Act, we have got the authority to deal with this issue, Lordship. Now, Lordship, since the other side is not here, Lordship, kindly fix up any date subsequently because
Affidavit completed.
everything is complete, Lordship. And we are enjoying the interim order also.
As none appears on behalf of the respondent, for the interest of justice, the case is adjourned. Let the matter appear on 1st December. 1st December.
1st December.
1st December. It should come under the hearing or
Same, I will take all this.
as a lordship. But that will
Yes.
I'm deeply out of
If
lordship.
the parties agree, then you argue, then.
Yes, yes.
Great. 14, I appear for the petitioner. This is a matter, my lord. I have filed the writ petition, my lord. Interior challenging, my lord, the action of the police authority, my lord. They are illegally occupying my flats and for a long time. My lord, we moved before your lordship's court. Initially, my lord, 93 order, contempt, directed to hand over possession. They have not handed over. Subsequently, my lord, we have moved fresh writ application before your lordship's. Affidavits are complete, my lord. May I find my affidavit in reply?
Yes. Directing respondent to hand over the vacant position of suit number 55, second floor, premises, Benton District.
May your lordship kindly peruse the last order of your lordship's court, my lord.
All the petition represented the government. Last time also none appears for the respondent. So I am fixing a date.
Yes, my lord.
He inform the other side. If not come, then I will.
Next
hear
week, your lordship fix a date, pass an order. I have filed the affidavit in.
as none appears. What you have filed? Affidavit in reply. Affidavit in reply filed by the petition be kept with the record. Full stop. None appears on behalf of the respondent. For the interest of justice, the case is adjourned. Let the matter appear on 20 November 2025. 20 November 2025. It is made clear that on the date fixed, if none appears on behalf of the respondents, the matter will be taken up for hearing in the absence of the respondent.
Let it be 21st, subject to
21st.
Grateful.
Next.
I am out of time to file my reply by close to a year.
Your Lordship, I am for the
More.
response.
I was praying for 2 weeks' time to file my reply to the opposition, my lord.
Why after 23, 24, this matters have
Matter
not
happened, traveled up to the division bench from an interim order. There, the interim order got set aside. We came back. After that, it never happened. Give me 2 weeks. Never.
Reply.
Reply.
Your Lordship, we have already filed our opposition, Your Lordship.
So you are opposing for the reply.
Your Lordship,
Counsel for the petition prays for time to file, prays for extension of time to file reply. Let affidavit in reply be filed by
2 weeks, my lord.
2 weeks.
Even
List
for
the
the
matter.
26th.
Next the matter 26, 27, 28,
Hello.
the other evidence is fixed. On 28.
Very good.
Next.
Lordship, item number 16, I'm praying for a accommodation for a day. On
May
behalf
I
of the
respond?
respondent.
I'll just indicate this. Look, this pertains to a scheme where certain incentives are to be given to the petitioner. That scheme, you're entitled to that. Direction for affidavits were given on 14th of December
Which
20.
scheme? That now that has been amendment.
This is the central. The other one I was state ones have gone. Center still pays. 14 December 2023 direction was given for filing an affidavit in opposition. But they still haven't done it. After the last matter, I'm on a slightly sticky wicket. But
that's why I'm asking after 22, 23 matters have not been taken up. All matters I find this, yes. Why you not file the affidavit?
Your Lordship, I'm not briefed in this matter. I'm just
So?
kindly keep it to. Okay.
Well, these are old matter, my lord. If my learning.
He's young.
Also old.
He's
Sir, I
young.
want a scan copy of the brief, my lord, if required, my lord.
No, I'll give that. When will you give the affidavit? Please indicate.
Well, 3 weeks later, give my lord, because I.
What? 14 December 2023 order.
Well, we'll give it, my lord.
2 years have passed.
Go on.
I bow down, my lord. Well, the brief is not with me. Well, let them supply a copy, my lord. We'll definitely.
I'll give
I
him
am
my
not recording you with the copy. Counsel for the respondent prays for extension of time to file affidavit in opposition. That affidavit in opposition filed within 2 weeks.
Well, 3 weeks, my lord.
Within 3 weeks. reply, if any, there to be filed within a week thereafter. No. This is the matter on 11th December.
Oh, it'll appear under the same heading. No?
Yes.
Very good.
In this matter, I'm appearing for the respondent number 5, my lord.
Respondent number?
5, my lord.
Yes.
The private respondent. My lord, affidavits have been completed, my lord. But thereafter, my lord, I have filed one application under section 340, my lord. For perjury. 340, my lord. Perjury. So, my lord, I just want to place that application, my lord. It is an old application filed in
Which was the petitioner?
My lord, the petitioner is one of the there was a bid, my lord, by the Geological Survey of India. A tender was issued, and I was the successful bidder. I completed the tender. I have received my payment. But the petitioner had subsequently challenged this entire tender procedure based on certain documents which have on affidavit being stated by the Geological Survey of India to be forged document, my lord. So based on that, my 340 application is filed, my lord. There were orders.
340 application J1.
My lord,
J1.
yes, my lord. This is GA1, my lord.
J1.
GA1, my lord.
But have you served?
My lord, this has been served long back. My lord, it's a 340 application, so I
Correct.
served. The affidavit of service is already on. It's probably on record, my lord, already. The affidavit of service. It is already on record.
Your Lordship, the writ petition can be disposed of because
You are for the petitioner.
I'm for the respondent government authorities, Your Lordship. The writ petition may be disposed of. Her application may be taken up.
Madam, there is my judgment. 340 application is to be taken after the conclusion.
Affidavits are complete in this matter.
So I will take both applications together.
Yes, my lord.
Because, Your Lordship, they had challenged on the point on GEM portal. After the GEM portal, everything is uploaded online. There cannot be any manipulation by anybody. His case was limited to the point that we had.
The petition is not before this court. What can be done?
It may be dismissed for default, Your Lordship.
Then her application 340 is to be taken. Then the court will pass. They will come. Okay, I am fixing a date. Inform the other side if they will come. Counsel for the respondents are present. None appears on behalf of the petitioner. For the interest of justice, the case is adjourned. Let the matter appear on 20th November 2025. The respondents are directed to inform the next date of hearing to the learned advocate appearing for the petitioner. List the matter on 21st.
Obliged.
Next.
Mr. Imtaz Ahmed is appearing in this matter for the petitioner.
Oh?
Mr. Imtaz Ahmed for the petitioner. He is on his legs.
Everybody is on leg.
Paying for very short password.
What will happen? You all persons are not able to. What will happen to this all original side matters? 23, 20. I find that after 22, 23, nobody has bothered to.
Very short password.
Huh? Password, what will happen?
He will be joining.
Which you are appearing for the
state lordship.
As per the prayer made by the counsel. As per the prayer made by the counsel for the petition, case is adjourned. Let the matter appear on 2nd December.
Great.
Next. Not today. Next. Not today.
Item number 21, I am appearing on behalf of the petitioner, Your Lordship. On the last occasion, there was a direction for filing of opposition and reply.
Filing of?
Opposition and reply, Your Lordship. My reply is affirmed. So, if it can be taken on record and can come back on the next date, Your Lordship.
Opposition filed?
Opposition, they have served me.
Served.
So reply is also affirmed, your lordship.
No opposition is on record. Then, where are you filing the affidavit? Reply?
Reply is ready, your lordship.
Counsel for the petition has filed affidavit in reply. Let the same be cut with the record. It is found that no affidavit in opposition is on record. The respondent is directed to place the affidavit in opposition on record by the next date fix. List the matter on 3rd December.
Item number 22, Your Lordship, I am for the petitioner. I'm enjoying an interim order, Your Lordship, on 11th of March 2024. An order was passed.
Yes.
Wherein the Honorable Court found, Your Lordship, that without the termination, Your Lordship, this respondent authorities, they are trying to evict me. And against that, Your Lordship, an injunction was passed. If Your Lordship kindly sees 11th March order once. Lordship, kindly sees page number 2. The petitioner has challenged a notice dated 19th of January annexed at page 93 of the petition, whereby the petitioner has been directed to hand over the vacant possession of a premises which, even as per the said notice, is a tenanted premises. The learned counsel for the petitioner places reliance on the relevant clauses of the tenancy agreement between the petitioner and the relevant respondent authorities as submit that the respondent cannot in law evict the person without the following due process of law. A perusal of the relevant provision of West Bengal government premises 1976, which is apparently the relevant in terms of the agreement between the parties as well, reveals that section 6A therefore permits eviction of an unauthorized occupants and penalty for occupation is to be charged where from any person not being a tenant occupies or remains in occupation of any government premises without the written order of the prescribed authority, even by use of force as may be necessary. The petitioner, however, makes out a prima facie case as to whether being no termination of the tenancy of the petitioner at any point of time, since even in the impugned notice, the respondent authorities mentions the premises as a tenanted premises. Although on a certain grounds, the petitioner has been labeled as an unlawful trespasser. The fact remains that the tenancy agreement has not been terminated prior to the eviction notice being issued. There's an arguable case as to whether the petitioner can be termed as a person not being a tenant as envisaged under section 6A of the 1976 Act. And lastly, Your Lordship, there is a restraint order against Your Lordship, the respondent authorities. Till date, Your Lordship, no affidavit in opposition has been filed. This is the situation. On the last occasion they appeared, Mr. Shubhajit Das, and Your Lordship, we have communicated to them every month. We send them, Your Lordship, the rent, but as usual, Your Lordship, they don't receive it. And Your Lordship, the envelope, Your Lordship, comes back with the check or the draft. This is the situation right now.
Who is for the respondent?
Last time, Your Lordship, Mr. Shubhajit Das, Your Lordship, for the state he appeared. I can do one thing, Your Lordship. I can just intimate him and...
I am fixing a date.
Yes, Your Lordship.
I am adjourning. I am fixing a date. You inform the others.
And Your Lordship, kindly also direct in the meantime if they want to give the affidavit. Otherwise, Your Lordship, the hearing will all again, Your Lordship.
In spite of the direction passed by this court, no, there is a direction of affidavit.
Yes, Your Lordship.
In spite of the direction passed by this court, the respondents are not filed affidavit in opposition. Today, when the matter is called and appears on behalf of the respondent, no accommodation is sought for. For the interest of justice, the case is adjourned. Let the matter appear on 4th of December 2025. It is made clear that by that time fix, the respondent intend to file the affidavit. They are liberty to file the affidavit or serving the copy to and counsel for the petitioner within a period of 2 weeks. Reply if any there to file within a week thereafter.
May I indicate only one thing subject to Lordship, without prejudice, Your Lordship, let the receiver, let the respondents be directed to accept, Your Lordship, the rent. Otherwise, it's accumulating. Nothing. I am sending them draft checks, but they are not accepting.
Let they come. If they will not come, I will hear the application here. If they will come and they ask for the time, then I will pass an order, deposit the amount in the register.
With the register. I am grateful.
That will be better.
Yes, sir.
I am for the respondent, my lord.
Yes.
Sir, I am filing the new evident opposition, my lord.
Lordship, I am appearing on respondent number 1 and 2, Lordship.
You are appearing for Calcutta Stock Exchange. My lord, so far, my lord, in principle, my lord, the representative infracture because the reason that the account has been freed by the Calcutta Stock Exchange Limited. Now, this is instruction is made by the
Calcutta Stock Exchange is party.
yes, sir.
No. That is 3 and 4 million.
Which application?
3 and 4, my lord.
Item number 23.
Yeah.
दूसरा
But we have filed the affidavit in opposition.
Just a
today.
minute, just a minute. There is some Yes.
But I filed the affidavit in opposition today, I believe. So if they want to file.
Lordship, I am for respondent number 1 and 2. That is SEBI, my lord. Lordship,
Yeah, so for
affidavit in
respondent.
opposition over.
Where is the
I'll
petitioner?
file. Petitioner is not there.
Just give direction that we serve on the petitioner and make it returnable.
The respondent number 1 and 2 and 3 have filed their affidavit in opposition. Let the same be kept with the record. Have you served the copy to the petitioner?
Lordship, I have some date of
The petitioner is at liberty to file affidavit in reply within a week from date. Release the matter on 3rd December.
You are in 21 also?
No, only in 23.
Right, 21 your lordship called, same order because we are filing the affidavit today.
21.
21 was passed over, same malad. We want to file
today, not today, Kiana. 21. Come on, that.
In the meantime, only to just record that I have filed the affidavit. Then it will
21 में record करो.
and I'll serve the petitioner the copy of the affidavit.
21 में किया. Now they have already filed the reply.
They have already filed the reply. The affidavit we are today filing. Just kindly.
Counsel for the petition नहीं है देखो. Counsel for the petition filed reply ना. Let the same be kept with the record. The counsel for the respondent has filed affidavit in opposition. Let the same be kept with the record. Fixed answers.
24th extension. Extension to file F.
24.
Item number next.
I appear on behalf of the petitioner, my lord. There was a direction sometime in April of 2024 to file an opposition. We are not in receipt as of yet. I'm humbly praying, let this be kept next week, my lord. I'm under instruction that there may be an understanding that the parties have arrived at.
Parties are?
The parties may have arrived at an understanding. This is with respect to certain fine that has been charged by the Calcutta Stock Exchange upon the petitioners. I am submitting under instruction that there may have been an understanding that they have arrived at. Kindly keeps it next week.
Malad next week and Malad in the meantime affidavit in opposition if any.
24. Counsel for the petitioner. 24. Counsel for the petitioner submitted that there is a chance of settlement between the parties. So the counsel for the respondent prays for a week time to file affidavit in opposition. Let the affidavit in opposition be filed within a week. Reply if any that will file within a week thereafter. Release the matter on 2nd December. Again last. Again you have come last.
No interim order extension, my lord. Item number 35, my lord. I was appearing for the respondent number 3. Not called today, my lord. Possibility of being taken up tomorrow. But I have a doctor's appointment where I have to take my father to a cardiologist tomorrow, my lord. Junior will be here for taking an
Mention the matter, I will take.
Very good.
Which I was only praying for. I missed the opportunity to mention. But if your lordship kindly grants leave and allows me to mention for an inclusion of a matter, there's a bit of urgency. I'm grateful, your lordship.
Okay,